Can I just say something about Andrea?
Hey, everybody. Welcome back. Good to be live on a beautiful spring morning over here in Washington as we're waiting for the court to get started down there in Provo. Got about 15 minutes before things are going to move forward. So what I'm expecting from this hearing today, first off, I am expecting this to be a full court day. Maybe not, literally every second until it's time to send everybody home. But I do think this is going to take up most of what we have for the morning and the afternoon as well. And the reason why is because what is on the table here is the defendant's, oh, wait, not that one yet. We'll get to that one. But the motion to exclude the still cameras, the TV cameras, etc., from the courtroom. As you can see, extensive motion, 258 pages, a lot of detail about it. Couple of things. I did a video about this yesterday. So if you want to get caught up on kind of the broad outline of what the motion is about and what some of it's based on and so forth, you can go check that out. Go ahead and turn me up to 2 speed. Like you'll probably still be able to understand me just fine and get all caught up with that. And then you'll also see up in the corner here, I've got the QR code to the Substack. And I'm offering you guys this because this is where I am keeping the archive of the legal documents. Everything that I am collecting, I'm just posting here. It's not something that you have to subscribe to or pay me any money or anything like that. Is just a free access to everybody so that you can go through and check out the legal documents for themselves, read them to your heart's content, should you choose to do so. So this motion is there as well. So just a couple of things to get you up to speed on the main point of today's hearing and what's going to be addressed. Now, the reason why it's going to take so long is because the defense has at least 2 witnesses that they're going to be calling, 2 expert witnesses to talk about the effects of pretrial publicity in general on decision-making, on jury pools, and potentially also specifically in this case. So the defense wants the cameras out. They don't want us to have the live feed that so far Judge Graf has been he's just been such a transparency champ in this case. He's been our best advocate for keeping the courtrooms open. Just point to the hearing back when we were looking at the disqualification of the prosecuting attorney's office, and there was part of it that they wanted to close, and everybody agreed. The defense agreed. The media agreed. The state agreed. Sure, let's go ahead and close this part of the hearing. And Judge Graf's like, nope, not doing it. Public transparency is too important. So he denied that stipulation. We got to see that part of the hearing anyway. So defense has a little bit of an uphill battle here on this motion, in my opinion. We do have, of course, opposition from the parties as well. The state has opposed this. The media has filed 2 briefs opposing it. They filed a brief initially when the defense's motion was still private and they were not allowed to access it. So they filed this first response that was just kind of a general principle opposition to excluding the cameras. But then they also filed a supplemental once that motion was no longer kept confidential from them. They're able to see specifically what arguments the defense is making and then respond to those particularly. So that's the documentation that the court is going to have, setting out the arguments and the basis and so forth. General outline of what the contention is. The defense is arguing that pretrial publicity in the modern day and age, particularly where things are mediated through social media and internet commentary, it makes it much, much harder to escape prejudicial stories, information, takes, and so forth. It's well understood that exposure to publicity can have biasing effects on jurors, and that these effects can be things that we're really not even aware of. Everybody, we all think that we're very fair and impartial, and the reality is just that a lot of our cognition is happening on a level that we're really not aware of. Our attention is being directed at things because of other pieces of information and processing that's going on at a level that we're not conscious of it. And so it isn't an easy thing to ferret out always, in the jury selection process, because you can't just rely on people's, I don't mean this in a bad way, but just self-serving take that, of course, I can be fair and impartial and I can put things aside. Everybody thinks that about themselves. And it's just, unfortunately, not always going to be the case. Where I think the defense runs into a bit of a problem with their argument here is that I don't take issue with really any of those claims that they've made about publicity in general. I have, frankly, a great deal of sympathy for the position of a defense lawyer being faced with a high-profile case like this, and a lot of media coverage and things being claimed and so forth. It's just not going to be an easy position for them to be in and for them to manage. But the problem is I think there's a big conflation here between commentary about the case and, quote unquote citizen journalism and investigation sleuthing and things like that with the live camera court feed. And assuming that these things are equivalent, I think, is assuming potential for harm from this particular source of information that I don't think is really valid. And so that's the gist of the opposition that we got from the state and from the news media as well, is that, look, if the problem is all of this bad information and speculation and false claims and things like that are being circulated in the commentary, then having the live feed showing us objectively what the true facts are of what's happening in the courtroom, that this is information that mitigates against the prejudicial effects of all of the commentary and so forth. That this is kind of the check that we have on misinformation about the case. And so, problem is, if you remove the camera, it's not going to stop the commentary. That's just going to continue. And now it's going to be harder to challenge some of these false claims and things like that are being made because we've lost access to the one objective resource that lets us all see with our own eyes what's happening, what people are testifying to, how the arguments are made, and all of that type of thing. So I do expect this to be, I expect I'm going to be interested in this hearing. Dr. Edleman, I've seen him testify before in the Koberger case. I think he's fascinating, just a wealth of information about decision-making and bias and how all of that stuff works, which I always find very intriguing. But the challenge is, I think, going to be on cross-examination. How are you going to refine that down to identifying the news media feed as being the particular problem and not actually maybe a little bit of a remedy for some of these bigger issues that come up in criminal cases when you have a lot of public attention on a particular case. But the other thing that may be on the menu today, I kind of expect it will, but not 100% sure, but maybe like 75% sure, is the defense's motion to continue the preliminary hearing. They are arguing they don't have enough time to be able to do the preliminary hearing when it is currently scheduled, which is next month. Specifically, I got to look on my calendar now. The 18th, May 18th is when it's scheduled to start. And so they argue that because of the timing of the discovery and so forth, they have been unable to review everything. They've been unable to conduct their own investigation in response to the state's investigation. And so this limits their ability to be able to defend their client in this particular hearing. Now, the state has filed an opposition to this request as well, and their argument I found to be pretty solidly grounded in the law, at least relative to the defendant's position. And the state's argument is essentially that because of the nature of this hearing, you don't have the same types of rights at a preliminary hearing as you have in a trial setting. And there is apparently Utah case law that addresses some of these issues. That because the purpose of a preliminary hearing is just to screen out cases where there's no justifiable basis to require somebody to defend themselves at trial, then it's not meant to be a full vetting of the evidence and everything, with all of the same types of protections that a trial will have. And so they're arguing you have what you need. It's a low standard to just show probable cause based on the state's case. And so there is case law in Utah that establishes, for example, if the defendant wants to conduct discovery or call witnesses specific to the preliminary hearing, they have to show a pretty strong likelihood that that evidence is going to defeat probable cause entirely, not just nitpick around the edges of it. So that's a pretty difficult standard to meet because probable cause is a very low bar. So the state seems to me to have the better legal argument on this particular issue. The defense has what I think is a pretty sympathetic argument. Like, look, if you have the right to show up at a preliminary hearing and cross-examine witnesses and call your own and things like that, which the rules say that they do, then that's not a meaningful right if you aren't given the opportunity to be able to exercise it in a way that's going to actually be effective. So I understand the defense frustration very well, but unfortunately, it's kind of part of the defense life of a defense lawyer that there's rules out there that they say, yeah, but not when that's not when that's like going to help you, or not when that's going to be what you want to do, or whatever. It's just kind of the routine that a rule is announced and then it is rapidly ratcheted back on to make things harder for defense lawyers. Yeah, that's of course not the purpose of it, but just does tend to be one of the common consequences. So because the preliminary hearing is next month, it's a month away, May 18th. They're going to want to know sooner rather than later if they're going forward on this motion or on this hearing or not. They're going to have to arrange, witnesses and scheduling and so forth. So I do think there is a pretty decent possibility here that we're going to get a ruling on the motion to continue the preliminary hearing at some point today. Oh, another issue, of course, that factors into that. I'm just going to pull up so I don't lose it. This is the stream I'm waiting for over on ABC4. Another factor that's going to go into whether the preliminary hearing gets continued at all is the fact that Erika Kirk, as the victim representative, has asserted speedy trial rights, which Utah law grants to victims of crimes, and many states have victims' rights laws that provide similar protections, where she has asserted her right to a speedy trial that she's given under the law. And basically what that rule says in Utah is just that the victim is acknowledging that the victim has an interest in the prompt resolution of a case. Cases, hanging out undecided can be very disruptive to victims. It can be very traumatic for victims. You're, kind of always having to wait to find out, am I going to be called into court? What's going to happen? Am I going to get a restitution claim? Like all of these things kind of factor in. That's going to be exacerbated in this particular case as well, where you have Erika being a public figure and somebody who speaks about these kinds of issues, justice in America and stuff like that. And so while she isn't specifically prohibited from saying anything at all by the gag order, because the gag order doesn't apply to her, it just applies to the lawyers and the law enforcement. Nevertheless, the prosecutor's been required to caution her. You say things that could taint the jury and it could be a problem and, interfere with the fairness of the trial and so forth. So at the very minimum, she's been strongly encouraged to protect the process by keeping silent. So the longer it goes on, the less opportunity that she has to tell her own story and process her experience with all of this and what it means and everything like that as well. Because Erika has invoked this right to a speedy trial, under the Utah rules, that means that if they're going to continue the hearing, it has to be reasonably necessary. And so then that ties back into the argument that the state is making, given the nature of the preliminary hearing and the scope of the rights that the defendant actually has in that hearing. You can't make that showing because it's not the purpose of what they're there to do. It's not there to vet the entire state's case the way that a trial is. Now, the fact that that's not the purpose doesn't mean that nevertheless isn't what the defense attorneys want to do with it. Pretrial hearings, evidentiary hearings, there is a reason why defense lawyers frequently seek them out and want to have them. And it's because it gives them advantages in preparing for trial. It requires the state to go on record, the state's witnesses to go on record with their versions of events, their explanations of certain inconsistencies and so forth. There's always inconsistencies in a case. They may be a big deal. They may not be a big deal. But you get the explanation on record at an early part of the process, so that they're locked in. They can't change it. And later on down the road, if they come up with a different story, you've got their original testimony that you can pin them down to. You can impeach this with, back when you were under oath at the preliminary hearing, you said X. Now you're saying Y. You're under oath now. Which time are you lying? Kinds of things. So that's a huge advantage that the defense gets by having a more trial-like approach to these sorts of evidentiary hearings. Another issue is simply that they get a feel for the witnesses. They get a bite. They get a bite at the lead investigator and the medical examiner, the person who handled certain pieces of evidence and so forth. So they get a feel for who these people are, how they testify, what their strengths and weaknesses are, how we might be able to push their buttons and stuff like that. It gives you information that you can use to be more targeted and strategic with your cross-examination in the trial when you have that witness on the stand, because now they're not a stranger. You're not coming in cold. You already know a little bit about how they operate. So that's what the defense wants to use the preliminary hearing for. Completely get it. I totally understand. But it doesn't mean they have the right to do that. So that's what the defense is trying to achieve. They want the preliminary hearing to be kicked down the road another 6 months or so that they have time to go through everything. We learned from the last hearing, the prosecutor said at that point in time, the defense has received 100% of the discovery. They've received all of the digital discovery. They've received all of the, testing reports, things like that. Everything that was in the possession of the prosecution, the defense had received. So they want the opportunity to go through all of that, run it past all of their experts, and use that as an opportunity to make the state have to commit to some positions and pin them down and stuff like that, so that they can't change it later on when they get to the trial. So don't know if we'll get that decision, but I am, like I said, I'm probably 75% that I think the judge is going to rule on that, just because of the time frame that we're dealing with. They only have a month. They're going to have witnesses under subpoena and arranged. People are going to have to potentially travel here to testify and stuff like that. They need to know sooner rather than later if the hearing is going to go forward or not. So while I am expecting it, 75% expecting a ruling on that particular motion, not expecting a ruling on the cameras, not from the bench. Judge Graf himself at the last hearing kind of forecast that he's not going to do that. And it makes sense that he wouldn't anyway, because he hasn't heard from the experts. He's gotten he's gotten affidavits. He's been able to see kind of what their position is, but they haven't, explained and followed up, and there hasn't been the questioning from the state and so forth. And so it makes sense that, if nothing else, you want to make sure you have thought about this testimony before you've made your decision, or at least give the appearance that it matters. Generally a good thing to do. But the reality is this is actually an important issue. It may not be like a big case changer, but for people like this defense team, and I'm really talking specifically about Richard Novak and Michael Burt, because these guys are at the top of the game. Okay, when it comes to capital defense, these guys are head and shoulders above most of us who have been in the trenches of criminal defense. These guys understand the long game that a capital case involves, because we aren't just thinking about the trial. We're thinking about the appeal. We're thinking about the post-conviction. We're thinking about the sentence and mitigation and in a potential penalty phase. We're thinking about the possibility of pursuing habeas attacks down the road. They're able to think about the sort of dimensions of the case in a way that just most lawyers aren't doing that because they don't. All right, they're getting ready to get started, it looks like. And so what these defense lawyers are thinking about is not so much, it's going to give us a big victory in this case. They are thinking about this as a legal issue implicating due process in a kind of evolving media environment, a new environment relative to the kinds of media issues that courts were dealing with back in the 60s, 70s, 80s, even 2000s. The way that the internet has changed the way that we see and process criminal cases and the potential effects that it has. These are potential looking down the road, long-term, big picture kinds of issues. And so it may not win them a big victory, here in this case. Frankly, it may not even be to their benefit to have the cameras removed from the courtroom. But in terms of kind of setting up and preserving an issue that may not percolate through a high court for decision for years down the road, is really kind of what this is about. This is the 10,000-foot view of what due process needs to look like in a capital case, and it's planting a seed that publicity is presenting a new series of problems that hadn't previously been contemplated. Everyone's like, "Shut up, Andrea. There's hot mics. I want to hear what they're saying." We're not supposed to be hearing what they're saying, but at this point, it's sort of hard to fault the cameras. Because if the lawyers are just going to talk into the microphones, this is something that you really do, or at least should, learn pretty quickly in criminal practice, that the mics are hot. There's mics in the courtroom, whether there are cameras in the courtroom or not, because the mics are typically feeding into the court's audio recording system. If they have an audio transcript, system, which most courts have at least as a backup now, feeds into their Zoom court type of system. You're very used to having microphones there in the courtroom. And so the fact that they pick up on things constantly, like if you haven't learned by now that the mics have the potential to be hot, I don't know what's going to teach you. I don't think that's a camera problem.
Yeah, like you can. Like you make all these. It's a little stab it with the gauges and needles.
Thanks, Dad.
All right. Board of the court today, you're not now second.
All right. How is the sound, guys? Well, I guess we can't really tell yet.
Please be seated. Good morning, and just take me a moment to set up a couple things here. Appreciate your patience.
All right, camera's on it now. I'm gonna see if I can boost the sound a little bit.
All right, court is now in session. Video recording may begin. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Chad Grunander, Lauren Hunt, Ryan McBride, and Chris Ballard for the state here in the court today, Your Honor. County Attorney Jeff Gray is joining via WebEx, although I don't believe he will be making an appearance at today's hearing.
All right.
I don't think we have captions on this
Good morning,
one.
Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who is seated beside me.
Good morning to defense counsel. Mr. Robinson, good morning to you as well.
Good morning.
All right. Before addressing the business that's before the court today, I want to address some preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during these proceedings will not be permitted to re-enter until the recess. So I just want to give you that heads up. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom.
Beware of the hot mic.
Second, I wish to address the camera operator and still photographer, if you would both come forward.
I'm gonna do our now conventional shaming of the camera operators. No, it's not really. Just putting them on the spot a little. You guys know how to read, right?
I don't mean to cause you any discomfort, but I just want to ensure the expectations of how we're proceeding today. Could you state your names and your respective roles, please?
Trent Nelson as the still pool photographer for the Salt Lake Tribune.
Thank you, Mr. Nelson.
Adam Fondren, video pool for ABC4.
Thank you. All right. Have you both reviewed the court's standing decorum order dated February 24th, 2026?
Yes.
Yes, Your Honor.
And do you understand the requirements set forth in that order as it applies to your activities today?
Yes, Your Honor.
All right. Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No, Your Honor.
All right. Do you anticipate any difficulty with complying with the order?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Fondren, I appreciate your cooperation. Thank you.
Thank you.
Turning next to discovery,
Who would
counsel
love
for the
it?
state, could you give an update?
Your Honor, on April 3rd, I filed a notice of the state of discovery with the court. I don't know if you've seen that, but I attached to that filing a 225-page document that lists the discovery that had been provided as of April 1st of this year. There's over 20,000 files. That document has about 100 files per page listed. Discovery continues to come in. I believe it was March 26th, the defense counsel sent a discovery letter requesting special discovery or specific discovery of materials, case files, underlying data, and so forth of lab materials from scientific reports. We're going to address some of that in the motion to continue the preliminary hearing today. Those materials have been requested from the FBI and ATF labs. Both laboratories are responding to that. They're reviewing it and they're providing information. As of Saturday and Sunday of this week, ATF, or some weeks ago, ATF provided to SBI their entire lab files, their entire case file. On Saturday and Sunday of this week, SBI was able to process much of that material, and we were provided at our office about 1,700 files from the scientific reports from the ATF. Just last night, I was updated that we received some more of those files, and that discovery continues. We're processing that material, date stamping, cross-checking for duplication, and then providing those materials as efficiently as we can.
Thank you, Mr. McBride. Appreciate that update. All right. The court will now, and to the other parties, did you want to weigh in or comment on that?
Thank you, Your Honor. Richard Novak for Mr. Robinson. I think the status of the specific items of discovery that Mr. McBride was just mentioning is sort of the core of the present dispute about whether the preliminary hearing can go forward in mid-May. So I guess the best thing to do would be to reserve comments about that until the court wants to take up that motion.
Thank you, Mr. Novak. I appreciate your input on that. Well, turning to that, I do want to outline the procedure for today's hearing, and it's to do so in an orderly and efficient presentation of the issues before the court. First, we'll be addressing the motion to continue the preliminary hearing, which is set for next month. And what I want to do is I'm trying to manage time as at the same time allowing all parties the ability to present what is necessary in order for this court to make a well-informed decision. And so here's where I'm landing. As it relates to the continuation of the preliminary hearing, I will allow both sides 30 minutes to present what you wish to present to this court. This would include any allocation for rebuttal for defense. Upon conclusion of argument on that motion, the court will proceed to the pending motions concerning media access within the courtroom. Each side will be afforded up to 2 hours to present argument, examine witnesses, cross-examination, and redirect, and respond to inquiries from the court, as well as reserve time for rebuttal. So I just want to create that expectation. Knowing the expertise and experience of the parties, that's probably more time than you need, but I want to create an expectation so we know how to proceed. I encourage the parties to be succinct in presenting the evidence, and the purposes of these time allocations is for case management and not to alter or diminish any of the parties' substantial rights. Following the defense's presentation, the court will recess for approximately 30 minutes, during which time the courtroom will be closed. Proceedings will then resume with the state's presentation. If necessary, members of the media will be thereafter afforded up to 15 minutes for any responses. The court will then take a brief recess of approximately 10 minutes. Upon reconvening, the parties may proceed with closing arguments using any of the remaining allotted time. The court will monitor the time and argument will conclude upon the expiration of that time. The court anticipates issuing its ruling at a later time via WebEx, as you may come to expect, to permit full and careful consideration of the record and the arguments presented today. The scheduling of that proceeding will be addressed at the conclusion of today's hearing. The court recognizes the significance of the matters before it and the preparation undertaken by all counsel. All participants are expected to adhere to the applicable standards of professionalism, civility, and ethics. The court finds most helpful those submissions and arguments grounded in the evidentiary record and supported by controlling authority and applicable law. Counsel are expected to ensure that their witnesses conduct themselves in a manner consistent with these standards. The court will now turn to the defense.
So the motion to continue the preliminary hearing is where we start.
Mr. Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson. Your Honor, the three docketed pleadings that are germane to the defense's first motion to continue the preliminary hearing are our motion, which is docket number 466, the state's response, which is docket number 476, and our reply, which is docket number 493. I can keep track of my own time, but my expectation is that I won't need all 30 minutes, but whatever I don't use, we'll see if any rebuttal is necessary.
Thank you.
So I think, if I may, the last time we were here and there was sort of a preliminary discussion about the May setting for the preliminary hearing, I think I said to the court, I don't need to reiterate what the court said to us when it set the date. But I do think, in light of the status of specific items of discovery, which I will get to, and the state's position on whether the preliminary hearing can go forward, I do want it to be clear, at least for the record, because I obviously understand that Your Honor knows what the court said, that
But what the court said was,
the expression of the court back in
reset.
December was that no party would be prejudiced by this setting. And I think that's important because when we look at the status of discovery with respect to the specific scientific evidence we're talking about, and we look at Article 1, Section 12 of the Utah Constitution, and we look at Rule 16, and we look at Evidence Code Section 1102, it is clear that Mr. Robinson is prejudiced by the preliminary hearing going forward as scheduled at this point. And it can't even be remedied in the next 4 weeks. I very much appreciate the update that Mr. McBride provided. He actually provided that to us before the hearing. But the bottom line is that we don't have from the prosecution team, and I'm going to explain what I think the prosecution team means in this context, data which is in their possession, which is clearly discoverable under Rule 16, which is what the Constitution of Utah refers to when it talks about appropriate discovery. And that brings up the reliability question under Evidence Code Section 1102. So there is no doubt that the ATF and the FBI have data files that represent what I'll call the digitization of DNA evidence. The DNA evidence, literally the collected evidence, is physical evidence, which is specifically addressed in Criminal Procedure Rule 16A1C. And then when it's digitized, and it may be that experts will tell me that's not the right word, but when it is converted into data that can be analyzed, data sets that can be utilized in DNA analysis, that's electronic evidence under Rule 16A1C. And we don't have that, and Mr. McBride acknowledges that we don't have that. And when I say we, I mean the defense, from either the ATF or the FBI. Now, Mr. McBride, I think, said to the court, he did say to me, that the ATF has just recently given SBI some files. SBI has turned over some of them to the Utah County Attorney's Office, but not all of them. The defense has not yet received them. So neither Mr. McBride nor I actually know if these data files, the raw data upon which all DNA analysis has been done, have been produced from the ATF to SBI, and we don't know if it's gone from SBI yet to the Utah County Attorney's Office. The FBI has not turned over anything, according to Mr. McBride, that might include the data files because there has been no production by the FBI in recent months in what I'll call the DNA area. We did make what Mr. McBride called a supplemental discovery request some weeks ago that set forth with great specificity the forensic related documents and materials that we want, including those data files. That's actually attached as an exhibit to our motion. But that was not the first time that we asked for these data files. And I am not casting aspersions at Mr. McBride and his team, because those data files are in the possession of their federal law enforcement partners. We're not asking somebody to go looking for a needle in a haystack. Hey, there might be some piece of evidence somewhere. Can you go looking? We know that these data files exist because we have summary FBI and ATF reports summarizing the data analysis that go all the way back to September. So I actually think that one of the questions, if I may, one of the questions, because counsel don't ask each other questions in the courtroom. We understand that all questions are asked by the court. Why hasn't the FBI turned over these data yet? And why hasn't the ATF clearly communicated until very recently whether it has and why it has not? The state's opposition to our motion does not explain why the data files have not been turned over. So now what I want to talk about is the significance of the data files. We have a right at a preliminary hearing to both examine and cross-examine witnesses. And our right to present witnesses includes presenting expert witnesses. If the state doesn't want to call the forensic examiners at the FBI and the ATF to testify about their analyses and the conclusions, that's their choice. But we have a right to present evidence that gets at these DNA issues, and we have a right to do that through expert witnesses. We cannot do that when the law enforcement partners, ATF and FBI, have not provided us with appropriate discovery. That's the word, that's the phrase in the Constitution, appropriate discovery. So that appropriate discovery is the gateway to reliable hearsay at a prelim. It is meaningless for us to have the right under the code to present and cross-examine, present our own witnesses and cross-examine witnesses when we don't have the electronic evidence, that is these data files, that comes from physical evidence, the DNA swabs. It's a meaningless right, and it frankly makes a mockery of the reliability concept. We have identified for the court in public pleadings 2 DNA experts who we have retained who are waiting for these data and for other materials so that they can advise us on whether the opinions expressed in these reports, these are ATF and FBI forensic reports on the results of their DNA analysis, whether these reports are reliable. And if they are, if they're not, cannot be determined without that underlying data, those underlying data. So we have the experts.
That's fair.
They're waiting for the data. We don't have the data. It's not Mr. McBride's fault. It's not SBI's fault. It's the law enforcement partners who have had these data files since September. Like, it's been over 6 months.
It's the
and many
imperial
of the
fed.
DNA, reports that they produce are also dated September. And I could go through each one of them if necessary, but maybe I'll do that in rebuttal because I don't want to run out of time. So we can't present any expert testimony on DNA without having the underlying data. Second step.
I love Richard Novak.
If the state doesn't want to call the forensics examiners from the ATF and or the FBI as witnesses, we also have the right to call them as witnesses. We have a little bit of a jurisdictional problem because we're in state court and we're not in federal court. And so we have these TUI regulations, which I'm sure the court is familiar with and are addressed in our reply brief. And I have personally been in contact with counsel for the ATF and counsel for the FBI who have not said, yes, we will make these witnesses available. They have said, why don't you get us some subpoenas, which are, by the way, not enforceable, but they're subpoenas. And could you give us a more definite statement of exactly what you want them to testify about? But I can't examine those witnesses without the data and without the data files being evaluated by our DNA experts. The state suggestion that we just put these reports in through Rule 1102 before really calls into question the concept of reliability, because there is no way for this court to evaluate the reliability of those conclusions. There is no adversarial testing. If I don't have those data, if I haven't been able to give those data to our DNA experts, if they haven't been able to tell us what they think of the data vis-a-vis the conclusions in the reports. So we have a problem with adversarial testing. It's a critical stage of the proceeding. We are basically handcuffed under the state's proposal, which is the court receives into evidence reports which we cannot in any way address the reliability of.
Risky pan
and
here,
so this
Chair
actually
Guy.
goes all the way up to the Utah Constitution, which says that reliable hearsay is admissible if we have appropriate discovery. Appropriate discovery, again, is the constitutional phrase. But it also implicates, because it's a critical stage, Mr. Robinson's Sixth Amendment right. And as I addressed in our reply brief, the heightened reliability concerns that the Constitution reminds us of in any capital proceeding. And heightened reliability isn't just reserved for penalty phase. And I provided the court with a number of cases which talk about heightened reliability being something that is a gloss over the entire proceeding. So the court, in my opinion, needs to, and in light of the law here, needs to say to the state, I can't do the prelim until the defense has the data files in a reasonable period of time. When are we going to get the data files from the ATF and the FBI? And if Mr. McBride, given all of his due diligence, can only say to the court, I don't know, because the FBI hasn't told us when, and the FBI hasn't told us why, then we're just going to have to wait. We're not interested in postponing this for the sake of postponing this. We're interested in having a meaningful testing of expert reports, which the state wants the court to just receive into evidence under 1102b4. And that's not reliability. That's not reliability under the constitutional test, which requires appropriate discovery first. It's not reliability under the 5th, 6th, and 8th Amendments. And I'm not in the business of telling the prosecution in any jurisdiction how they should do their job. But the state chose to proceed by way of
He wants a grand jury.
preliminary hearing instead of proceeding through a grand jury.
Why? Because it's confidential.
And this is where we are. We have a right under the Constitution to have appropriate discovery before this court receives into evidence what the statute says is reliable hearsay. And if the court says, oh, you don't need the data files, then we believe that 1102B4 is unconstitutional, as applied in this case. If we have the data files and a meaningful time to evaluate them, then the state has fulfilled its obligations under the Constitution, and the reports can be received at least statutorily as reliable hearsay, subject to our right to present evidence through direct witnesses and through cross-examination. So I think other than what I've said so far, I would be repeating myself. And if I've not used my 30 minutes, then I'll save the remainder for rebuttal.
Thank you, Mr. Novak.
A lot there, and he's
Turning to
made
the
a,
state.
I think, very good argument and a very good record. That whole 1102B is unconstitutional as applied if you do this. In the record now, reserved it.
Trina, do you mind allowing me to present?
The legal argument predicated on
Your Honor,
Article 1,
the court
Section
should
12
deny defendant's motion to continue the preliminary hearing
Rules of evidence.
simply because the reason the defense has requested to continue the preliminary hearing really has nothing to do with the preliminary hearing. It's unnecessary, the continuance is. It's necessary to expert discovery, it's necessary to expert notice, it's necessary to a 702 hearing, it's necessary to a trial determination of the weight to give to expert testimonies, but it is not necessary to a preliminary hearing. Now, before I jump into my argument, Your Honor, is my screen sharing?
Not with us.
Can you see it there, Your Honor, on your?
Well, let's see.
We're not seeing anything at council table.
I'm not sure if it's being presented yet.
He means they chose a
Sure, I've got
preliminary
my
hearing
signature.
over a grand jury. A grand jury would all happen behind closed doors, and the defense has no right to be present, and they get pretty much, I mean, it's not like a complete free-for-all, but different
Also,
situation
that will come up as I'm talking, Your Honor, but
than a public preliminary hearing.
before launching into my argument, I want you to understand my structure here, okay? My first point that I'm going to make is the defense has not shown that a continuance is necessary to the purpose of a preliminary hearing. Maybe necessary for other reasons, this material, but not necessary. Maybe this material and discovery of this material is necessary for other purposes, but not for the limited purpose of a preliminary hearing. And the second point is the rules don't require expert notice before the preliminary hearing. Look at Article 1, Section 12, Rule 16, Rule 7B, Rule 1102. They don't require expert notice before the preliminary hearing. Now, I want to start with that first point, which is the real standard, the salient principle from whether it's Longcrier or Lopez is you don't grant a continuance unnecessarily, right? Axiomatic, right? That's the salient principle from those cases. That's what common sense says. You don't unnecessarily continue a hearing, right? Why? Well, because it causes delay in the proceedings. In this circumstance, this is not a nominal delay. We're talking at least 6 months for the defense to get this material, review it, and consult their experts, and for their experts to be ready to present expert testimony. But more likely, even more than that, because there's litigation surrounding some of this expert investigation. One of the tests right now has not been performed because there's an objection to it, and we're waiting to litigate that issue, depending on what some of the expert discovery shows.
Let's talk about bullet lead.
In addition, we're probably going to object to some of the expert discovery requests the defense has made and that they made on March 25th. So this is at least a 6-month delay, probably much longer than that, because some of these expert issues have to be litigated. And when you consider the purpose of the preliminary hearing, right, it's an initial stage of this process, right? It's designed to protect a defendant from having to sit in custody and wait for all the trial preparations without there being any showing of any evidence, right? The Rule 16 The preliminary hearing is designed to ferret out groundless prosecutions. Probable cause is a very low standard. Reliable hearsay is admissible. The court doesn't weigh the evidence at this stage. And that's because this is a very early stage of the proceeding. And the rules contemplate discovery and investigation ongoing throughout and even past the preliminary hearing and even all the way up until trial. So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand two things. One, what is the purpose of the preliminary hearing? And two, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to three, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are, or what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence, and it's certainly not a 702 hearing. It is only one thing, a probable cause hearing, and that's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial.
Here's Erika.
As well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period.
You're not allowed to zoom in on him. You're not allowed.
The next stage in understanding whether or not a continuance is necessary is, one, understanding the purpose, the limited purpose. Two is, what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants to present, is that going to affect the probable cause determination, right? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. And I think the same analysis applies here. Listen to the evidence first, then you ask the defense, well, what are you going to present, and will it be necessary, will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing.
Yes, let's do it.
There's really 4 categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming onto campus at about 7 a.m. or I think about 8 a.m. Okay, it's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They captured his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon T-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs to the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence is the video surveillance that shows the defendant on campus.
That's a lot of
taking
detail.
the shot. The second point is circumstantial evidence tying him to the rifle. Right in that wooded area, police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds, and these are 30-06 Remington rounds. That one has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, there's a search warrant that's executed on his house. In that house, police find a Dremel tool. And they also find the same make and model of ammunition, Remington 30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions.
Oh boy.
The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Cook and I took it, right? This note was written before he left St. George and came to Orem and was left in his apartment. His roommate finds it, roommate/lover finds it. And this initiates a text message conversation back and forth between the lover and the defendant, where the defendant says, yeah, I shot Charlie Kirk, and I'm summarizing, shot Charlie Kirk. I left the rifle behind. I had to leave the rifle behind, but I'm going to pick it up, and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey, guys, it was me. I did it. Thanks for all the good times. Goodbye. And the final confession is an acquaintance is a former law enforcement officer, and he helps arrange the defendant turning himself in to the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right? So there are 3 categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The fourth category of evidence is that DNA evidence. And you have to understand what that DNA evidence is.
Yes, tell us.
The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires. And it comes from a variety of sources. And so the defendant cannot show that the material he wants to present at the preliminary hearing would defeat probable cause. And in his reply, he says, well, that's circular, because how could we make that showing if we don't have the underlying data to be able to attack the DNA evidence? Well, first of all, that attack wouldn't even affect those first 3 categories of evidence, right? The confession, the circumstantial evidence tying the defendant to the rifle, or the video evidence, right? But even if they were to find some expert that would say both labs independently got this wrong, and even if they're to find that kind of expert, which I think is speculation and probably against the grain, but regardless, you take that assumption, it still wouldn't defeat probable cause, because at this stage, the court doesn't weigh contrary evidence, right? The standards are very clear. At this stage, because it's such an early stage with such a limited purpose, the court views all evidence in the light most favorable to the state, right? That's State v. Virgin. So in summary, the defense has not shown that the motion to continue is based on the purpose of the hearing, a fair determination of probable cause. They just haven't shown it, and they haven't even tried. And I think one of the reasons they haven't tried is because they know that these are experienced practitioners. They know what the standard is here. It's low. The evidence is viewed in the light most favorable to the state. They're not going to be able to defeat a confession, multiple confessions nonetheless, or DNA evidence, right? And if the continuance was granted, it would affect the victim's right to a speedy trial. And frankly, like the Lopez case, it would obviate the repeated and express admissibility of reliable hearsay at preliminary hearings. And that leads me to the second point, which is a textual analysis. So the defense says, well, Article 1, Section 12, Rule 16 require expert discovery before the preliminary hearing. I'm going to try to see if my computer will present again.
It's not outputting the video.
Let's see. I'm showing it's connected. Oh, there we go. Great. Okay. So let's look at the text of the rules, right? Utah Constitution, right? Here it is. Article 1, Section 12. Where the defendant is otherwise entitled to preliminary examination, the function of that examination is limited, right, to one purpose, as I said earlier, to determining probable cause. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule, in whole or in part, right? In any preliminary examination to determine probable cause, if appropriate discovery is allowed as defined by statute or rule. Is it allowed? Well, Rule 16 allows it. That's the end of the inquiry. Well, the defense says, well, no, but it has to be complied with, and that's fair, I guess. So let's look at Rule 16. So here's what Rule 16 says. Look at the mandatory disclosures, and there's a distinction here that I think is important. One is the use of the language here, prosecution team. When we talk about mandatory disclosures under A1, we're talking about what the prosecution team has, right?
That's going to
prosecution
include their
team has been
investigators.
interpreted in the case law to mean the prosecutor as well as the law enforcement people who are working on this case.
Like the FBI.
But if you go down to the
ATF.
timing of mandatory disclosures, it's different language that's used here, right? And I've highlighted the portion that applies here. 8, there it says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination.
There's
Okay?
a different word.
The different language is the prosecutor versus prosecution team. Had the Supreme Court Rules Committee, and as approved by the Supreme Court, had they wanted this to mean full discovery of everything in everyone's possession before the preliminary hearing, they would have said so, right? The rules of statutory construction say you presume all omissions are intentional, right? They use distinct language here, and they did it for a reason. The reason is because the preliminary hearing is such an early stage of the proceedings, right? We all know investigation at the preliminary hearing stage is continuing. We all know the state, the prosecutors are still getting material from the investigative agencies. We know investigative agencies have processes for getting reports and approving reports and disseminating reports. We know expert witnesses, oftentimes by the preliminary hearing, haven't even started their work, right? The Rule 7B says the preliminary hearing has to take place within 14 days where it's requested. Right? This is a very early stage of the proceeding designed to protect the defendant from having to sit in custody where there's no showing of probable cause. And the rule itself, Rule 16, makes clear that discovery is ongoing. It foresees that discovery is going to be ongoing throughout the trial. So the defense argument that Rule 16 requires full discovery of this material before the preliminary hearing is a contra-textual reading. But even so, you look under A1, and what does A1 actually require as mandatory disclosures? Well, there's a specific provision that talks about scientific tests and experience. It's A1B, reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. We provided those reports, okay? What the defense wants is complete and total expert notice and expert discovery. We've even complied with A1 as it relates to what the prosecution team has with regard to the reports. Okay, so Article 1, Section 12 doesn't require discovery before the preliminary hearing. Rule 16 doesn't require full, complete discovery before the preliminary hearing. Well, is there any other provision of authority we should be looking at here? Well, how about the provision of authority that is directly on point with regard to expert notice? Let's take a look at that. 77-17-13. 1A, if the prosecution or the defense intends to call any expert to testify in a felony case at trial or at any hearing, excluding a preliminary hearing held pursuant to Rule 7, the party intending to call the expert shall give expert notice, right?
Specifically excludes.
It's hard for the defense to make an argument that expert notice is required before the preliminary hearing when that's not even an against the grain reading. That's a completely contrary reading to the statute directly on point.
That's a problem.
The court would have to find that this section does not apply, and it's just impossible to do that. The defense may say, well, we're not requiring expert notice. What we're asking for is just discovery here. Well, no, what they're asking for is, in fact, expert notice. Rule 77-17-13 talks about what expert notice is. If you look at B, right, it's the CV of the expert, the report, written explanation, and then 2 says an expert's anticipated, if it's based on specialized data, the witness shall provide the opposing party the information of that specialized data upon request. Well, the expert notice request, let's see if I can find my list here. What's this one? Let me give you a list of what the defense requested in their March 25th request. And I should mention, the defense is right. This was not the first time they asked for this material, but when they asked for this material, this specialized data underlining the report, I responded by saying, look, I don't know exactly what you want. You know, you talked about like certain software files and stuff like that. Will you please put it in writing so I don't lose what you want in the translation? And so they did. So on March 25th, they gave me this supplemental discovery request, and that's what I've relayed to the agencies. But what they want is lab case files that the government intends to use in its case in chief. I should note that the FBI has provided a lot of this material already. I provided a case file that's 380 pages long. I think clear back in October, as well as about 77 other files that list their policies and procedures. And those are listed in that 225-page document that I attached in my April 3rd filing. But they list CVs of analysts, accreditation documentation of the labs, accreditation documentation of the programs used to interpret data, standard operating procedures and protocols, STR databases and frequency tables, chain of custody documentation, data files underlying the analysis, software names and software versions used, developmental validation of instruments and processes, internal validation of instruments and processes, proficiency tests of analysts, audit records. All of that material may go to expert qualification, the qualification of the labs, the methodologies, may go to 702 issues, but it doesn't go to probable cause, okay? Especially when you've got to view this evidence in the light most favorable to the state. And the final reason why we know that expert discovery, expert notice is not, I didn't finish my point here, which is this material they're requesting is expert notice. Like that's what they're requesting here is expert notice under 77-1713, which
sounds like
expressly does not have to be given before the preliminary hearing. And I should say, regardless of the fact that we're not required to give expert notice before the preliminary hearing, we're doing our very darndest to do so. And we shouldn't be penalized for being on the ball and getting ahead of things by trying to get the expert reports and investigation done as soon as we can. To the contrary, we should that's the kind of behavior and due diligence that should be encouraged and incentivized. And if you say, no, you can't have a preliminary hearing until all of that is done, it does create chaos in the system, because it says, if I want to have a preliminary hearing early, I'm going to stop my investigation once I hit probable cause, because then I don't have these discovery problems before the preliminary hearing. And that is not the type of conduct we want to incentivize. And the rule doesn't incentivize that conduct. And this comes to my final point. The defense knows it. Okay. I know that Mr. Novak has made his argument here, but the defense knows that this kind of material is not required before the preliminary hearing. And how do we know the defense knows it? Because the defense has said so. In one of their earliest pleadings in this case, docket number 16, I think it's 16, the defense counsel filed their request for discovery. This is the formal request for discovery that's filed, I think, docket 16. And in that docket, they recognize the discovery is an ongoing process. You get down to page 11, and the defense cites Rule 16 saying the prosecutor's duty to disclose material is ongoing. In every case, all material that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, right? But here's the key phrase that I think shuts the door on this argument the defense has made, is highlighted in red there. And I quote, defendant acknowledges he does not have a right to discovery prior to preliminary hearing pursuant to Article 1, Section 12 of the Utah State Constitution. That's it. The defense concedes this point. Now,
that's not helpful.
The point I'm making is what the defense makes right here in the next sentence. However, defendant relies upon this initial discovery request through trial, post-preliminary hearing, to enforce their rights encompassed in the Utah Constitution to a fair, speedy trial. That's the point I'm making, is the state should be pursuing expert investigation, their due diligence, getting the investigation done as early as possible, and providing that discovery as it comes in on a rolling basis, right? And that's what we want to have happen. We shouldn't punish the state and the victims and everyone else by delaying the proceedings when the state does exactly what has been done here, which is getting on top of those things early, right? I think that's all I have, Your Honor. Do you have any questions for me?
I will. I'm going to turn to defense for their rebuttal and then have questions for both parties. Thank you, Mr. McBride.
Thank you, Your Honor.
That was pretty strong. Law is on their side, and kind of seems like the facts are too.
Forgot one piece of equipment.
Thank you, Your Honor. I do want to respond directly to a number of the arguments that Mr. McBride made, but I also want to refer the court back to the accusatory pleading which initiated this case, which is the information. The information specifically relies upon two types of DNA evidence. First, the information, and it's actually the probable cause statement in the information, docket number 1. At the bottom of page 3, the probable cause statement alleges that DNA consistent with Robinson was found on the rifle's trigger. Second, the probable cause statement in support of the information says in the middle of page 6, the rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice, I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information. We are not talking about the broad scope of expert notice, of expert discovery that Mr. McBride is talking about. We're talking about physical and electronic evidence, which first, the information was based upon, as I just said. And then second of all, as Mr. McBride acknowledges, the state intends to present the limited DNA evidence that it has without even having the data files been made available to us. And I want to drill down on this very specifically because I think it's appropriate, but the state sent us, but did not file with the court, a memo outlining the witnesses they intend to call at the preliminary hearing and the exhibits that they intend to offer at the preliminary hearing. And I'm going to respect that it's their present plans, and it's not something that necessarily should be filed under seal, filed publicly. But as Mr. McBride acknowledges, that includes 3 DNA reports. We have those reports. We just don't have the data that the authors of the reports relied upon for those conclusions. And I'm not talking about their CVs. I'm not talking about their published writings. I'm not talking about their prior testimony. I'm not even talking about all of the things that Mr. McBride acknowledges we've asked for and that there may be a fight about later in terms of discoverability under Daubert, under 702. We're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102B4. So we're not talking about the slippery slope and months of litigation of Daubert type expert notice. Mr. McBride is right that at a certain time and place, there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects.
But you're flailing a little.
We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work, as far as we know. They've generated reports The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available and that they should be produced to us. Mr. McBride, probably because he can't, still hasn't told the court why we don't have the data files. So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, goes, is he goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion, as the court knows, is that they couldn't say either way where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And
you want us to know about it.
I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional and legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable. Thank you, Your Honor.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands, have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, But have counsel reviewed that discovery and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution. 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to, and we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. Because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So for example, we received a couple months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not. My clients, so there's a huge download of my client's cell phone. There are downloads of many, many, many digital devices. No. Absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all. You just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing that you have in your possession now?
I can only speak for myself. I'm not going to speak for other counsel, but the answer is no. The answer is no. But I am not able to, maybe this isn't the court's question, but I'm not even able to approach this fourth category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying
have you reviewed what you do have?
Data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No. And I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know that if we move forward with the preliminary hearing, either next month or a different date, that there's effective assistance of counsel moving forward. And that's one of the factors is, have you reviewed the necessary discovery? Typically in criminal cases, defense attorneys say, hey, I haven't been able to for whatever reason. And the court recognizes that, right? Like, I get it. But I need to check that box and say, okay, defense is saying we're ready to go forward. with the discovery that has been provided, that's a part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can present that information verbally, we can present it shortly thereafter in writing, however the court wants to present it. But I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that, reviewed significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as, sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. It's a thing.
Sure.
Right? So I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my co-counsel and not speak for them.
I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not ever need. So I respect it. And you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been trying to focus on the very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim. And the court is asking, I think, very helpfully, a broader question. And the court is not challenging, the court is not really confronting us on the question of diligence, so I'm not even going to go there. But obviously, there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. No, and I appreciate that. And the court's intent is I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And I recognize, and I can do so, that both sides have been very diligent and have worked extremely hard. Obviously, I'm not in your offices. I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is that's just a checkbox I need to know to move to that stage. And only your team has that answer. And again, and I recognize the amount of discovery that's been is out there. And so it is no way to impugn defense at all, saying, well, you're not doing your job, you're not working hard. Not at all. I just want to know that answer. And so that's the sole purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Counsel don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of the victim representative, Ms. Kirk, in her right to a speedy disposition of the case? For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hangup of, well, we can't move forward until we comport with their timeline, and that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question, and I can't answer that question, and obviously Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump, lowercase t, the defendant's constitutional rights. We do not want the victim representative and her family to have to wait any longer than we have to wait. But it isn't sufficient for the state to say, we've turned over gigabytes and gigabytes and the defense doesn't really need to review it before the prelim. That's not, obviously, and the court, I think, tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the data that their law enforcement partners have and have had for 6 months, we can't be constitutionally effective. And, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And so
prepared.
going to the state's argument that there's these 4 prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin. And so my question for you is, if the state's presenting evidence that can meet the standard in any of the 4 prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
I'm not going to speculate about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3, nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence, that they that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses who wrote the reports, not through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3. I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. But it's the state's decision to present 3 different DNA reports, at least at the current time, according to the memo that they gave us earlier this month. And it's their federal law enforcement partners who have not complied with that reasonableness test. And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at counsel table or over there of stalling out anything. And I think the court deserves to know why the FBI and the ATF haven't turned over these data files.
Well, I mean, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, the why might tell us when. I mean, Your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my final, I'm sorry.
No.
My final question is I'm trying to avoid a slippery slope of, wait, we need one more thing. We need one more thing. We need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's 2 different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. And yes, with respect to the court may be asking me a question that is better addressed by Mr. Burt because he's the one who specifically crafted the discovery request. And I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the results of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all important, but we don't even have the data files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September of 2025 that Mr. Gray relied upon for his information.
I guess what I'm trying to do is I want a bright line of saying this is exactly what we're requesting, and it's the court's decision if that's necessary or needed to proceed with a preliminary hearing. I just want it to be so clear that we know, okay, it is, hypothetical. We need a blue pen that is Bic or whatever, that is so definitive there is no question, because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this is not exactly it. And I respect your position. I understand it. I just want to make sure there's no ambiguity And that's why I'm trying to distill this to its finest point so I know exactly what you're asking. When you say data files can be anything. I want it to be clear as day so nobody can say, well, I didn't realize it was that. And you're saying the FBI hasn't turned over the data files. That is a very broad statement. And so I want to make sure we distill it to it is this exactly. So the prosecution can say, okay, well, if we need to communicate with our their federal partners, then they can, and they can say this is what we needed. But if it's just a broad, we're missing data files, that's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that there's going to be a continuum from what data we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice, 702 Daubert issues before a trial. And as long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court and we can give the court our view of where the line is between what is data that should be reasonably available to us now versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth, but if the court's saying, I'm not going to go that far, but I need to draw a line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has these pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere, or maybe it's yes, no, yes, no, yes, no, or you know what I'm saying.
No, but to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that. Okay. And we can tell the court, these are the things that we think that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery. And then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right. Thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side
always open to questions, Rob.
to have that same experience. All right. All right. Turning to the state.
I'm telling you, Mr. Novak can duck and roll, but it doesn't mean he can miss all the punches. Very, very evasive.
All right. So the defense has emphasized that this is a capital case, which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfied this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Well, my tendency is to say Well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should. And we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
All right. One of the other issues that's been brought up is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case law is very clear that obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And that because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no. The state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there. And we asserted at that time we provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't give us anything else, guys. We don't want to know. No, we're saying, give us everything. And as soon as stuff comes over, we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking, sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor? What does the prosecutor have in his possession? Those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your line of inquiry with Mr. Novak just a minute ago raises the importance of this. Yes, the defense, I can't tell you the first date that we had a conversation, an oral conversation where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Burt, if it was with you or Mr. Novak, and I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication. We had a communication about that this week with both ATF and FBI. And And I think a lot of this material they've requested, we have provided it. You know, some of this material was provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, debate stamp 79, CVs of 3 of the analysts from the FBI. There's case notes were provided October 24th, that's Bates 122, and Bates 845 to 848. 73 files of policies and protocols, validation, testing procedures, analysis, proficiency procedures, provided October 24th and 12 on December 9th. Now, the ATF lab, they were continuing to do investigations, or excuse me, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. It takes, you don't snap your fingers and have them all together. It takes time to put them together. Once they got them together, they sent them to the SBI for processing, make sure that the detectives, investigators are aware of the materials, and they provide them to us. We bait stamp them and send them out. And those are the materials we received this week. Okay, so there's been no delay here. And we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is, have we completed full expert notice? I mean, I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice under 77-17-13, not under Rule 16, and certainly not under there's no mention of when this material has to be provided elsewhere. So I just don't see how this is necessary for the limited purpose of the preliminary hearing, particularly in light of all the other 3 categories of evidence here.
Well,
I think this is why, and
those.
Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important, is because you can hear the evidence, you can listen to it, and you can say, you know, there's the confessions, there's the circumstantial evidence, there's the video evidence, and then there's the DNA evidence. I don't even need to consider the DNA evidence. Mm-hmm. And there's probable cause here. And that's the state's position, is that there's probable cause regardless. And there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence. And there's all this other evidence anyway, a confession, that's clearly probable cause. So I would ask the court to hold off, deny the motion for now, hear the preliminary hearing evidence, and then let the defense make their showing. And if they can make a showing that undermines probable cause, fine, give them their continuance. And at the same time, have them tell us exactly what data files are talking about here, because that's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, you know, I know the other thing the defense has said is, well, look, the state doesn't have to use this evidence. They're right, we don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument that's meritless in our view. We're entitled to use it, we're going to use it. If the court decides not to rely on it, that's fine. You know, so that's my position on that, Your Honor.
The final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
Well, I think there's 2 components to that in my mind. First is, you know, in a lot of cases, we will stipulate to a continuance, you know, out of professionalism, preparation. You know, there's a lot of things that we stipulate to continuances on, but generally we're talking a 2-week, you know, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice in the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances. This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fell, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. You know, I mean, I'm thinking of a recent case I had where defense counsel's father died right before trial. I stipulated the continuance, okay? Sure. Something like that happens, of course, we're going to extend that professional courtesy to the defense. You know, as it relates to preparation, I don't think the defense needs to, and this kind of goes to your question to defense counsel, hey, are you going to render effective assistance? And I'm thinking, you know, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I would I agree to a continuance for them to be prepared under certain conditions? Absolutely. You know, for example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, you know, given greater notice than is required by the expert notice statute. In fact, you know, more than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided, maybe I've got it on a list here, but I know you have it in that letter I sent, Mr. Novak. But the last one was provided there's a tool marks report that was provided March 12th. Okay, so under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports. There's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, those type medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this. They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Your Honor, may I go back to the request that the court made for a little more clarity? Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and I have both been speaking about. And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any DNA evidence at the prelim, and which pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
All right, and I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on to my first question about the discovery that's been reviewed?
Yes, I think that would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so, and I'm sure others would appreciate it.
All right, well, let's turn to Mr. Burt, and then the court will take a 15-minute break, recess. Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That technician processes the sample, puts it into a genetic analyzer, and what he gets is electropherogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, and I don't know, I've done probably 100 cases with either the FBI or the ATF, and when you ask for electronic discovery, you get two things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things, and you typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be analyzed by the experts. And that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning. We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly by file extension names exactly what that meant. And in the discovery letter we sent to him, to answer the court's question of what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and process data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope. And as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
But let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have. But the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using this software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. Mm-hmm. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So, and I appreciate that, but my question is, have you received the lab notes? I understand, it sounds like, in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes. Where,
right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample, or how they sorted out, how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I have reviewed the lab note files that tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with? And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Burt. I appreciate that.
Thank you.
It provides a lot of clarity. All right, let's go ahead, and we're at the 12 o'clock hour. Let's break for 15 minutes, come back at 12:15 to confer with defense in regards to discovery. And then we're going to transition to talking about the media in the courtroom. As indicated, the court, it's not the court's intent to issue a ruling about continuing the preliminary hearing. I want to weigh the evidence, the oral argument, the information today, but I am also cognizant of the timelines. And so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
All right.
Oh, boy. That was quite a busy morning. My goodness, a lot came out of that hearing so far, hasn't it? I've got a ton of notes already and so many little stars in my margin about things to come back to. Oh boy. So, I think the thing that is really the attention grabber in all of this is the outline of the evidence that the state is anticipating presenting at the preliminary hearing. We got these categories of evidence that they say that they have. First off, volume of surveillance from UVU. Says they have a great system. They show Tyler Robinson coming on campus at 8 a.m. It is clearly him. He's wearing the maroon t-shirt and same clothing that they say he surrendered in when he turned himself in Washington County. It's clearly him. He's in his gray Charger. He's there 250 miles and a good three and a half hour drive from where his home is. He scouts the campus, and then they say he returns later on foot. This is the part that I think is already a little bit better known because we've seen some portions of that just through the investigation. The little clip of the guy jumping off the roof, for example, and the screenshots from the part of the video where he's on the stairs and so forth. Now concedes it's not as definitive at this stage because he's got a hat and sunglasses on. It's what they're referring to as a kind of pseudo disguise. But they believe it is still, he's still able to be identified from those photographs. And ultimately that is the kind of question of fact that in this particular context, it sounds like it isn't really an issue at all because the standard at the preliminary hearing just assumes all of these facts in the state's favor. So if there's a question about is it Tyler Robinson or not, they assume at this hearing that it is. But assuming this case gets to a jury trial, that's the type of decision that ultimately the jury makes. Is it him? Is it not him? Then there is a circumstantial evidence tying him to the rifle. The rifle was found in the wooded area with the 430-06 rounds. We already know most of this stuff. And then after he turned himself in, they found the Dremel tool, which is there. It's identified in the ATF report as the likely tool used to create the engravings, a rotary tool like a Dremel tool. So they did find a Dremel tool. It's consistent. They're not saying it's the same one, although won't be surprised if ATF does a little analysis of the Dremel tool, a little comparison to see if there's tool mark similarity. They found the same make and model of ammunition, the Remington 30-06, and a test, quote unquote, test shot, a cartridge with a similar etching on it. So these are all circumstantial that tend to show that the firearm belonged to Tyler. Confessions, they've got the written hand note that they talk about. This is the one described as being left under the keyboard, where he says he had a chance to take out Charlie Kirk and I'm going to take it. And then that triggered the text conversation, which we've also already seen at least portions of in the probable cause portion of the information. We know it's, or at least we have long suspected, it's not the entire thing because it's got ellipses in it. It tends to indicate portions of it have been excluded, but at least parts of that conversation. Now we have confirmation in court about a Discord confession to a group of friends. So this is an item that has been kind of floating around in the commentary about this case because it was given to a journalist. I think it was Ken Klippenstein who got it. And basically, yes, it's out there. It's time stamped at like approximately 7 p.m., maybe a little bit after 7 p.m. The night of the 11th. And it says, you know, like he said, I don't have it on hand, so I'm not going to be able to quote it exactly, but basically, you know, sorry, it was me at UVU. I'm about to turn myself in. Thanks for all the good times, kind of thing. So we have confirmation that that is a piece of the evidence that they anticipate to use in the case. The report from Mr. Klippenstein does appear to be corroborated by this statement that is a real thing. It is actual evidence, and they do intend to use it. And then also statements from the former law enforcement officer who helped arrange Tyler Robinson surrendering himself, where he says, I got rid of the clothing I wore. This is what is kind of an implied admission. It's obviously not an overt, yes, I did it, but you're implying you did when you say you wore clothes to do it, and you changed those, got rid of those clothes and so forth. So all of those things above and beyond the DNA evidence that they recovered, they're identifying as the towel, the screwdriver, the rifle, and the cartridges and the cartridge casing that were found inside the rifle. Now, interesting little tidbit as well from Mr. Burt in that last part there, because we heard at the last evidentiary hearing about the 5-person mixture from the, found at the crime scene, and been a big question about, well, what is that? And what sample are they talking about? And it seems that Mr. Burt has just told us it's all the samples. All of the samples are mixtures. They seem to not have a single source sample from any of the items that they took. And so that is definitely going to complicate the DNA type of situation. So it's a 5-person mix, and I'll just, I can just tell you, Mr. Burt is absolutely correct. There are lots of technical issues that go into interpreting complex DNA mixtures. It's complicated because in this type of analysis, they're looking at limited portion of the genome. And so it just gets very difficult to sort out who contributed what. And how do we even know how many people are in the sample? Like, how can we make good conclusions about how many people are in the sample? It gets very complicated. My best, like last I saw when this type of issue was being litigated, is the STR mix has been validated for up to three person mixtures. And beyond that, many labs will not interpret a sample. They will consider it too complex to be able to draw meaningful conclusions from. What STR mix will do, which is kind of helpful, is assign a likelihood ratio. They calculate a likelihood ratio that compares the probability that the defendant, the suspect, contributed to the sample versus the likelihood that a completely unrelated unknown person contributed to that sample. And so it can give some statistical strength to the conclusion that the defendant is a contributor. And so presumably, although we don't have these details, the more complex the mixture, the less statistical strength the conclusion is going to have, because there's just too many other possibilities of how that mix can be interpreted. So all very, very interesting, very complex stuff. This, if this is the case, guys, I'm just gonna reiterate. I've been kind of saying this for a little bit, and it now, I think, increases my confidence of where this case will go and the investigation will go. If every single mixture includes a 5-person mix, I don't think we're getting out of this case without next-gen DNA testing being done. And the reason why is because next-gen DNA analysis looks at the genome very differently, and they look at a lot more of the genetic information. And a lot of these processes are specifically helpful in the context of dealing with mixtures, because you aren't dealing with like a limited, very small universe of, shared puzzle pieces or whatever, however you want to think of the alleles that make up the sample. You're looking at like millions to billions now, and you have a lot more code to be able to deal with, so you get a lot more information from it and can draw stronger conclusions about who contributed what. But these are also very novel technologies. They have been admitted in some courts. We just saw some next-gen technology get introduced not introduced, but get validated for use against Rex Heuermann, who then promptly pleaded guilty. It's come up before in a case in California, in Kern County was the first next-gen DNA case where it was allowed. In that case also was for the purpose of interpreting a complex mixture. So this whole issue with the validation of the STR and so forth, by the time we get to trial, it may be moot, because they may not even be relying on this particular testing anymore. If they can get a better result from DNA tech, from next-gen DNA technology, then they would just use that instead. So just something to look down the road for by way of a kind of prediction about where things may go. Obviously, this is sort of a long term, because we may not know for quite a long time what, if anything, they do. But that just makes a lot of sense to me in terms of an investigative step, given what has been discussed during this hearing. Boy, that was the big part. The whole kind of bottom line for the defense here, very legitimate question: why on earth won't the ATF and the FBI just turn this stuff over? Well, I do have some thoughts about this, because, I was a state level practitioner, not in federal court. And these guys, I think, just from what I've seen, a lot, if not most of their work is maybe in federal court. And so in federal court, you are dealing with federal prosecutors who use federal law enforcement agencies to do their investigation. When the feds assist the state in a prosecution, it introduces this whole level of jurisdictional complexity, a lot of territorial piss marking and dick measuring and things like that just kind of invariably come up. anytime you have a bunch of different bureaucratic agencies and they're kind of jockeying for seniority and precedence and things like that. It's just kind of what happens. It's, I don't know, not really unusual that these agencies are extremely territorial and not very good at information sharing and don't want to be told what to do and so on and so forth. The reason it gets complicated in state prosecutions is because the feds have the supremacy clause that basically make them immune to any kind of court order coming out of a state court. They don't have to comply with discovery requests or court orders or anything like that coming out of the state. And so the only real leverage that a state court or a state prosecutor or whatever, a state defense attorney, has to compel the FBI or the ATF to provide any information at all, the only leverage they have is the threat that, well, maybe we'll just exclude all of that evidence if you don't provide the discovery, and then the case is going to fall apart, or whatever. So they don't have a lot of power to make it happen. And if they don't have a lot of power to make it happen, then it just implicates a couple of things. One, it's a low priority compared to the folks that they are serving in the federal system that can compel them to do X, Y, and Z. The ones that can't back up their requests are just kind of naturally going to fall to the bottom of the priority list. But the second reason then is just, that, like I said, there's a lot of territorial dick measuring in bureaucracy. These are bureaucratic agencies that we're really talking about. So, they don't want to be told what to do by anybody that they don't think has the power or the authority to kind of compel them to. They'll do it how they want when they want to and stuff like that. Is any of this legitimate? Not particularly, but it's also very predictable and it happens all the time. That's just really the main point I want to make here is that kind of become routine at this point when you watch a state case, a state criminal prosecution in which the feds have participated in the investigation. This is always an issue. Just navigating the whole bureaucratic nightmare of getting the federal investigative materials provided in discovery when you don't have the tools to compel them to do that. And they've got their whole other bureaucratic process that Mr. Novak mentioned here, the TUI process. Karen Reed folks remember TUI. Brian Koberger folks remember TUI. It comes up all the time. So, I don't have an explanation for why they don't. And it seems to me like, yes, they should. They absolutely should. And just is, if it's like Mr. Burt is saying, how hard is it to drag and drop, an icon onto a thumb drive and give it to the defense? It's not that difficult, so it shouldn't be that hard to do. Completely agree with that and recognize that. At the same time, recognizing that isn't necessarily how it works in practice. So the fact that it hasn't been done, it's a little bit, from my perspective, it's a little bit of a now I'm going to space on the name of the razor, Hanlon's razor, right? Never attribute to malice what can be adequately explained by incompetence. It doesn't indicate to me necessarily that there is anything more going on here than just bureaucratic complication and the types of things that sort of always happen. It doesn't inherently indicate malice to me, just because it's not unusual. This is not a unique situation that's being present in this case. At the same time, that it's a perfectly legitimate question to be asking, and there should be a reasonable answer for it. And I would love to see, the ATF and the FBI need to provide that answer. Why the fuck's it taken you months to drag and drop a file? So that's my thoughts about that issue. He mentioned the bullet lead analysis. guys, the bullet lead analysis. I'm looking forward to this. I really am, because many of you who have followed my channel for a while know that the pseudoscience in the courts, this is one of my hot button issues. Just the junk that gets presented in courtrooms as evidence of guilt and used to justify, generating convictions against people is just, it's often really shocking from the standpoint of the logic behind it, the validity of the conclusions and so forth. This has been a problem for decades. It continues to be a problem. At the same time, scientific technologies are getting far more sophisticated, forensic technologies as well. And this is no longer like a novel observation, the nature of these problems with a lot of these techniques. And so there has been some effort to kind of rehabilitate some of these practices, just by recognizing what the critiques have been and responding to the critiques. Very few of the critiques are insurmountable. They're things that like fundamentally undermine the entire premise. The critiques are pointing out things like your conclusion is overstated. When you say, I can chemically match this bullet to that box of ammunition, that is overclaiming. That is attributing strength to a conclusion that can't be drawn. That's what led to the comparative bullet lead analysis originally being abandoned by the FBI when it was criticized as being unscientific. It's not that the process of examining the chemical components is unreliable. It's highly reliable. It's the meaning of okay, you've got this bullet has this composition, this other bullet has this other composition. So what? If every single bullet in the universe has the same composition, then it doesn't matter at all. It's not significant that they share. So you need to know how significant it is. And that's what they didn't have a real foundation to be able to establish. Now, this is an issue too with toolmark analysis. Toolmark analysis is in many ways way worse than the comparative bullet lead analysis in terms of the scientific foundation for it, because we're in the same problem if we have no like real world validation of the range of difference in marks that a single firearm will produce and that multiple firearms will produce. So we don't really know how similar is similar enough and how different is different enough to be able to distinguish marks produced by a single gun down to the individual level. We have additional problems with the observation itself. With the chemical bullet lead analysis, we're looking at a really fancy tool that produces basically wavelengths from the different elements in that sample and tells you exactly in how much of those elements are present. Toolmark analysis is a human being looking at a microscope under, comparison microscope, two things side by side, and saying, those look close to me. It's a freaking eye test. It's like literally an eye test. Literally an eye test. And then you have the problem with the standard itself. The standard for the comparative bullet lead analysis is, here's the it's usually seven elements that they're looking at that are alloying materials in bullet lead. Here's the amounts, here's the proportions between them. And then here's this other sample, and here's the amounts, and here's the proportions between them. We have two very specific things to be able to compare to each other. With forensic, with the toolmark, the forensic toolmark analysis, they're looking at this bullet. Okay, looks like this. Looking at this other bullet. Okay, looks real close. What's the standard for deciding if these things are identical or not? The standard is literally, I, the analyst, think it's close enough. I think there is sufficient agreement. And what's the basis for my determination that there's sufficient agreement? My opinion based on other bullets that I've looked at. that's not replicable. That's not an objective standard that any other analyst is going to be able to recreate, because they don't live in your mind and in your world experience of the bullets that you've looked at to be able to replicate that. So the the tool mark analysis that is now, like, by and large, the main, like maybe even the only, for the most part, method that is used to connect a bullet to a gun in terms of the scientific foundation is so much worse than the basic foundation of the comparative bullet lead analysis. And yet it comes into courtrooms all the time. So you can see why this is a little bit of a hot button issue for me. So the reason why I'm particularly interested in this is that the reason why the bullet lead analysis was dropped in the first place was because of the difficulty in understanding what's it mean. Who cares? So what? If we have a whole universe of possible sources of lead and we want to know how can we draw source conclusions based on this sample that we have, you have to do a ton of real world study about, lead composition and how much is produced. And you just basically have to know what's the likelihood that I might get a coincidental match because another vat of lead that was used to produce bullets just happens to be compositionally identical to the vat of lead that was used to present this bullet. We need to know that. And we need to know how many bullets anyway. If, I've got one vat of lead and let's assume it's all compositionally homogeneous, which is not actually a good assumption, but let's assume it is. If that vat produced 25 bullets, then there's a lot more significance than if that vat produced 50 million bullets. Okay, one bullet out of 50 million is a lot less significant than one bullet out of 25. So they don't know how to do that. But there have been steps taken to close the universe and to find ways to be able to draw conclusions that are not so wide-reaching. And one example of that is if you aren't trying to compare it to just the whole universe of possible bullets out there, but are just trying to create more of a closed universe of samples. And so one example would be, instead of trying to compare it, bullet lead, to say a box of ammunition, a random box of ammunition, what if we compare it to this gun and this cartridge and see if there's a corresponding match there? If we can swab the cartridge to get a sample of the lead that cartridge, originally held in the projectile, and the projectile fired it, and there's going to be gunshot residue that's produced, that's going to be in the barrel. We can sample all that stuff, and then we can compare the compositions of those two things, and we can see, are they identical? Do they match? And you're going to have an easier time trying to establish something like these things are consistent than trying to compare it with But we're waiting. They're probably bringing Tyler into the courtroom.
Testing. That works. Thank you. Court is now back in session. I wanted to give it a little bit extra time to ensure defense had that adequate time to have that discussion. What we're going to do is I'll hear from defense about that issue, and then we're going to take another brief recess. We have a technology issue that we want to address that will assist when presentation of the evidence from both sides for the next portion, and I want to make sure that's seamless. All right, Ms. Visser.
Go Phils.
Thank you, Your Honor. Our intention is for each attorney to briefly discuss where they are at as far as rendering effective assistance of counsel at the anticipated preliminary hearing dates. I just want to note a few things. For my part, I have been doing my very best to keep up with all of the discovery productions. I certainly have not read everything. But I think it's important to note that we are just starting to find what we're missing. Although the state has indicated there are 35 exhibits for the preliminary hearing, as this court is well aware, we'll have law enforcement witnesses that also testify to hearsay from other law enforcement witnesses, which means we need to read all the law enforcement reports, right? We need to review all of the interviews that are likely to come up in that testimony. So we are in the process of determining what reports we're still missing, and there are some still missing, and what interviews we are still missing. And we are still missing interviews. And we haven't sent an updated list to the state as of today because we don't want to piecemeal it. We don't want to just ask for one thing at a time because we know it's a process to go to the law enforcement partners, get it to SBI get it to the state. But we are creating a list. And the discovery in this case, the only way I can really describe it is that it is like a living, breathing organism, right? Every time something comes in, we have to check our list, see if it's something that we've been waiting for, something that we've anticipated or requested. So if the court is asking me personally if I feel like I'm ready to render effective assistance of counsel in May at a preliminary hearing, the answer is no. Both because there is not enough time to determine everything that we are missing and get that requested and review it in sufficient time to render effective assistance of counsel, and just the sheer magnitude of what we're dealing with. We're dealing with dozens of law enforcement agencies, hundreds of reports. We are going through it as quickly as possible. But of course, the most important thing to us is rendering effective assistance of counsel. So if the court is asking my opinion of me right now, the answer is no.
So, Ms. Visser, I appreciate that. When will you be ready? With what you have right now?
With what we have right now? So this is one of those things where you're ready when you have to be ready, right? Based off of my calendar and what I believe I need personally. Well, we need the DNA. So
let's focus
outside
only
of the DNA,
on what you have, what's before you now.
I would say I need at least 4 months to finish processing what I have based off of my calendar, my trial calendar.
All right. Thank you.
Thank you.
Okay.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. I don't know if you recall, it's been a long time, but when we were first setting this prelim, I mentioned to the court that for the months of February and March, I would not be available. I was involved in a murder trial in Summit County. And so for the entire months of February and March, I was not able to work on this case. The trial ended, I think, March 17th or 18th. Then I got sick for like 10 days. So I have not been able to turn back to Mr. Robinson's case until the beginning of this month. In the time that I was in trial, we've had 7 disclosures from the state. Many of those disclosures involved thousands and thousands of pages. One of the biggest disclosures we got was on March 5th while I was in trial, and it consisted of the entire FBI file, which was massive. That's what I've been focusing on the last 2 weeks, reading it as fast as my eyes can read it, because a lot of the reports I think that are going to come out through the SBI originated through interviews with the FBI. So I've been trying to get my head around that file. And that's just one portion of one of the 7 disclosures. And there were thousands of pages. And I think I've made it through the FBI file now, but I haven't even touched any of the rest of it. And as lead counsel, I do expect to have at least a portion of the witnesses at the prelim. I share Ms. Visser's concern about, even though there's only 35 exhibits they're going to introduce, that doesn't limit the testimony that's coming in. And I feel like if I'm going to do a job a good job, that I need to be able to be familiar with everything that officer has touched, and really what the SBI has done generally. We went to examine physical evidence this past week, this week. It took us 6 hours. We did finish what the SBI has. However, we still have never seen the gun. The gun is at Quantico. So we've never been able to look at the gun. I actually think that's really important for purposes of the hearing. So I have some concerns about that. I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive. We had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important. So I would share Ms. Visser's request for 4 months. I will tell you, I handle quite a few murder cases in the state. I think my last murder case that we had a prelim, we continued it, I think, 3 times, and there was 2 terabytes. This case has over 200 terabytes. So I think in the scheme of preliminary hearings and timing, this is not unusual or out of the ordinary for a homicide case in the state, especially one this complex. So personally asking for a little more time, setting the DNA completely aside. Even if they get up and say, forget it, we're not going to introduce the DNA, even if you say I'm not going to listen to the DNA, the rest of it is still significant. I also have some concerns that we do have a notice of intent to seek death with an aggravator. So I assume we're going to go forward with that at the prelim. No one's discussed that. If that happens, that does require really careful review of the scene itself, which I don't know that we're there yet, but we're close. I mean, we definitely have looked at so many videos. I think I've memorized the face of everybody in the crowd. But if we're going to go forward and the court has to make a decision, if you're binding over on whether or not it's capital, whether or not there's an aggravator, that's a whole nother section we have to get into. So for all the same reasons, I would ask for 4 months at least. Thank you, Your Honor.
Thank you, Ms. Nestor. Mr. Burt.
Yes. I've had 2 primary assignments in the case. One is dealing with the media litigation, which has taken substantial amounts of my time. And I'm responsible for putting the hearing on today and working with the experts. And so a lot of my time has been devoted to those kinds of preparation issues. In addition, I've been assigned the task of dealing with all forensic issues at the preliminary hearing. And those efforts so far have involved me sorting the discovery as it comes in, because it's not come in discrete packages. Discovery dump 1 might have some DNA discovery in it, and the next time we get something on DNA is in discovery package number 4. So part of my process has been going through everything as it comes in to sort of sort and get organized the various areas of discovery. And so far we have information coming in on the following areas: autopsy experts, canine deployment, crime scene photographs, DNA, fingerprints, firearms, footwear, laboratory intelligence unit discovery, question documents, state forensics, and trace evidence. So I have set up files for each of those areas. I'm uploading and organizing and reviewing discovery as it comes in each of those areas. We are retaining experts at the point in time when we feel we have enough information so that we're not paying experts to have to duplicate or do discovery review in batches. We're taking on the burden of getting it organized so that we're not spending a lot of expert resources on reviewing discovery. So we have retained the DNA experts, and we're stuck on that issue, as you've you've already heard, we've retained a firearm expert who is awaiting the case files from the ATF. We just got in the second to the last discovery batch the autopsy photographs that were produced in September. I think we got those just in March of this year. So those are being reviewed and organized so that we can hire a forensic pathologist who will review the autopsy report and prepare us to do whatever cross-examination we need to do on that report. But we have not yet retained that expert. So that's kind of an overview, and happy to answer any questions. I don't feel, given the state of discovery and the complexity of some of these forensic areas, that I'm in a position to render effective assistance. The expert, the DNA expert, estimated 6 months. I think if we got the minimal 2 categories of information that I outlined for the court, that we could expedite that down to approximately 4 months so that they'd be prepared in that time period.
Thank you, Mr. Burt.
Thank you.
Mr. Novak.
I've already been told I used too much of the court's time, but I think I can supplement.
No, I appreciate all the efforts of every party, and I know it's important, and so that time is necessary and needed. So I appreciate hearing.
Oh, you guys dunking on him, calling him Slovak?
Represent
How dare
that I'm
This man's a genius,
responsible
don't you
for
know?
all of the motions and pleadings that have been filed, but I've really devoted my time to writing. And obviously the court has held many substantive hearings on issues so far. Obviously everything that we write is a collaboration, but I think that the vast majority of the time that I've devoted to this case has been the legal writing and frankly coordinating the mitigation investigation, which I'm not going to talk about beyond saying I speak almost daily with the people involved in our mitigation investigation, reviewing mitigation materials. That's where I'm focused. And obviously that's not part of the prelim. So if we were shifting to fulsome preparation for the preliminary hearing over, say, the next 30 days, I would have to basically put aside all of the writing that needs to be done and direction of the mitigation investigation, and figure out where with my colleagues they need me to fill in so that we are all constitutionally effective when it comes to the preliminary hearing.
And so if, as it relates to what you are maybe assigned to as it relates to the preliminary hearing, how much time would you need?
I think the estimate of my colleagues of 4 months is appropriate. And I also think that what we are all saying is whatever time our DNA experts need once they see the data that Mr. Burt so eloquently explained to Your Honor, we don't have, that's really going to be the controlling time period. We're not, in other words, we're not going to say, oh, our DNA experts are ready, but counsel are not, because I think that 6-month estimate by our expert, which was provided in a declaration, is going to be the outer limit, but that's going to be from when they actually get the data. And as Mr. Burt said, there may be a refinement of that once they see the data that's available to them. I mean, that was sort of a best assessment based on past experience, not based on what the data in this case presents in terms of the challenges for analysis.
Thank you, Mr. Novak.
Thank you.
The answer is dozens.
Anything just turning to the state,
Dozens.
any benefit of the record that's
You guys
needed?
are public defenders. They have massive caseloads.
I would just add, I haven't seen everything in the file either. That doesn't stop me from being prepared. This is a massive file. Probably, 70, 80% of the file is running down leads that did not lead to any fruitful evidence. And so a lot of what this is categorizing evidence, and the core evidence that's required at the preliminary hearing has been provided for a long time with the intent that I could help the defense. And this is exactly what I said in my letter that I wrote to them with the witness and exhibit list. I provided very explicitly the witnesses we would call, the Bates numbers of the reports that talked about the witnesses that we would call, including the Bates numbers of the reports of the witnesses we would use 1102 statements for. I included all of the exhibits, the Bates numbers for those exhibits, the dates on which those exhibits were provided for the defense. I see no reason why the defense can't review that material. We could probably review it in an hour or two with them, and they could sit down, look at those exhibits, look at those reports, and be prepared for the preliminary hearing, Your Honor.
Thank you. All right. Thank you to all parties. I appreciate that guidance. I made note of it. As indicated before, we will take another brief recess. We just need to get technology set up to ensure that it's seamless as you're making your presentations. And we'll break and come back at the 1 o'clock hour. Counsel also uses time to prepare. So when we start at 1, we're ready to jump in. We'll start with defense, and that way we can be efficient with our time. Thank you. Court is now in recess.
All right.
All right. So another quick little break while they get ready to move on to the next issue. So let's talk about this. Let's talk about these continuances and the preparation and stuff like that. And so first off, the defense saying we'll be ineffective if we have to go forward now. This is normal and predictable, particularly in cases involving public defenders. And the reason why I say that is because it's just the nature of the beast that people who do public defense tend to do it more often for ideological reasons than because it's extremely lucrative. It's not. It's like the lowest paying legal job that exists. So they do it because they believe in it, not because they're going to become millionaires or whatever because of being public defenders. So when they believe in it, there's just kind of certain patterns that you see. They do take very seriously, wanting to do a good job, but they're also going to be perfectly happy to make a record of how they might be ineffective so that would potentially help their client out in the future in, some type of appeal or post-conviction litigation or something like that. Ideological defenders tend to not really mind the idea of being found ineffective. And I'm not saying that these guys are just throwing that out because no, I think they sincerely believe there's a kind of a floor of preparation that needs to be met. But then that's what gets us kind of into the issue of what does it mean to prepare? What does it mean to prepare for something? Because it's kind of like writing and kind of like art, where like there's no obvious, okay, I've done everything that there is to do. You just have to stop at some point. And typically what makes you have to stop is the freaking deadline. If you didn't have the deadline where tomorrow is the trial, and so I've run out of time and there's nothing else I can do, you would find other things to do and other avenues to explore and stuff like that. You're really never done. You just reach a point where you have to stop. So that's, I think, what the kind of core of the conflict is here between the perceptions of the state that you're prepared enough and the perceptions of the defense that no, we're not. And that's what the judge here is having to navigate, is to decide as a matter of the constitutional floor for effective assistance, how much is enough, how much is not necessary. And that's why he asked them to sort of take out this whole issue of addressing discovery that hasn't even been provided yet, the DNA files. Let's just talk about what you already have been provided and where you're at with that. Because that seems to be just where his thoughts are going in terms of what level of preparation is necessary. No, you don't have the right to the full exploration and independent investigation and so forth that you have at the trial setting in the preliminary hearing. But it also doesn't mean you could just show up at the preliminary hearing not having looked at the file ever before and be competent. So there's somewhere in the middle where the line is drawn, and it's going to be his responsibility to figure out where that is. So if they have all of this discovery, they have the exhibits, they've looked at the exhibits, I think the argument the defense has made, probably the best one I think that I've heard, is that just because they introduce an exhibit and present testimony from a law enforcement officer doesn't mean that that's all the testimony is limited to, especially given this rule that allows certain types of hearsay to be presented at the preliminary hearing. So if the law enforcement officers can just go in and talk about everything I learned from this guy and that guy and this other person, then they have to be prepared to address everything that those other people said. And so just because I'm only calling this one law enforcement officer doesn't mean I don't need to be prepared to address his claims about the information he got from maybe 100 other officers. That to me is frankly the most compelling argument that I think I've heard for a continuance. But the idea that you need 4 more months to do that, not sure the judge is going to be real thrilled with that. 4 more months to go through all of the reports, make sure you have them all, interviews, etc. I don't know that he's going to be real pleased with that. Yeah, on the one hand, it's murder, and so you just expect things to take a little bit longer, particularly capital murder. Just makes it all the more detailed that you're going to be. But I mean, I have to kind of be like, yeah, 4 months is a long time. But the argument, look, there's dozens of different agencies, hundreds of different investigators involved. It's true that the scope of this particular investigation is significantly larger than you see in just a run-of-the-mill homicide, where you might only have one law enforcement agency involved. You might only have a couple involved, limited number of officers that are participating in it, and so forth. So I'm kind of leaning towards that's what I think is going to grab the judge's attention more than really anything else. Ms. Nestor's issues, she was in trial and then she got sick. These things are also very normal and come up all the time and are pretty routinely grounds to continue these types of things. Schedule conflicts happen. It's part of being a lawyer. They have to be worked around. And no, you can't be expected to be working on every single case at once all the time while you're also, spending, I don't even remember how long the Corey Richens trial was. Wasn't it like a month? It was like a month. It was a while. It seemed like for a while it was all that we were hearing about. So yeah, it's just part of the job that while you're focusing on that one, you can't be doing all the work you need to do on this other one as well. Yeah, Mr. Burt talks about they still need to hire a forensic pathologist. That's one that I maybe I missed in his explanation why they haven't done that yet, because I don't think that's new information. I don't think it's like they only just got the autopsy report or anything like that. I would have expected that's the type of thing that would have been nailed down pretty early on, because you absolutely know you're going to need somebody to take a look at the autopsy. Basically, as soon as you know that you have a murder case, you can kind of predict that. So I missed the explanation for why they haven't done that already, but that is something that they say they need to do. And then Mr. Novak, you guys are so, I mean, I get it. It's, I fangirl Mr. Novak from the perspective of, the defense practitioner. As defense attorney, my entire career, I look up to other defense attorneys. I see what he's doing and how he's doing it. And I admire it because I understand and appreciate how very difficult the job is. And particularly when you're in a position where the judge is asking you a question that there's no real good answer that isn't going to destroy your position. What do you do with that? And he's got his method of dodging and weaving and slipping. Like, everything to avoid that question hitting him right in the fucking nose. So he's really good at it. And I do admire that. At the same time, recognizing doesn't mean he's going to win. I see what you're doing, dude, by not answering the question. Anyway. And the state's point, look, I haven't seen everything in the file. It doesn't mean I'm not prepared. Yeah, I get that. And it is, however, a bit of a different standard for the state in that regard than it is for the defense. I saw a question go through the chat earlier that I wish I'd starred to pull it up, but I didn't because it's a very, very good question, I think, and an important question. And it was about, does the defense have the obligation to investigate exonerating circumstances as part of their duty to defend their client? And the answer is absolutely yes. Absolutely. A fundamental part of the Sixth Amendment is the obligation to conduct a reasonable investigation. The qualifier is, as always, that word reasonable. What does that mean? What does it mean, reasonable? It does not mean you have to run down each and every possible avenue. You are allowed to make reasonable judgments that I don't need to go down this road for whatever reason. And as long as your basis for doing that is, something legitimate, something more, substantial than just like, well, I just didn't really feel like it. I didn't really want to. I was too busy. It would bore me. Those are not good reasons. But if you've got a legitimate investigative reason why you don't think it's going to be helpful, because there's a gazillion other things that already corroborate the same point that this is making. And so the chances of some kind of, benefit to the defense coming out of the effort of pursuing this avenue may not be worth it. So they get to make strategic decisions like that to forego investigations. And as long as those are based on reasonable justifications, they're going to be upheld. But it's there's also always risk in that, right? Because you might think it's a reasonable decision, or the decision is based on what you know at the time, but what you know at the time might be incomplete because you haven't read the entire file, you haven't seen all of the stuff. There's always new information, new case law, new scientific techniques and things like that developing all the time that could change your evaluation. Okay, this week we don't know about a technology that we could maybe use that would shed light on this very important question in the case. So this week I'm prepared and we go forward. And then next week we find out about this technique. I didn't know it at the time, but boy, now I sure do wish I would have been able to have used that. So there's a lot of layers that go into that question. Yes, they absolutely 100% have a duty to investigate, but it's not like an absolute duty to, clear the field of each and every possible, theory and fact and interpretation and all of that. As long as they make reasonable strategic decisions about what, warrants additional investigation and what doesn't, then that's going to be fine. And something that I have to continue to emphasize when it comes to those decisions and our ability to engage them from out here, and even the state's ability to engage them, or a reviewing court, a reviewing attorney's ability to do that, is the information asymmetry that the defense team has in this case is massive. It's massive. They have so much more information about this case than anybody else in this entire process, simply because they have access to the accused that nobody else does. And so they have the ability to talk to him, to question him, to find out, is this going to be a productive avenue for us to go down? Or can we expect this is, going to corroborate the state's position? It doesn't mean they aren't going to still do that for particularly important evidence, things like DNA and these bullet analyses and all of those types of forensics. It doesn't mean they're not still going to do that. All I'm really trying to say is that that's a perfectly valid reason, should they not go down some type of investigative track, for why that could be, because they have been led to believe by their client it would not be helpful. And we will never know that. We reviewing people, even like attorneys down the road looking for ineffective assistance and stuff like that, very real possibility they will never know about whatever information has been passed between Tyler Robinson and his defense team, because it's confidential, highly confidential. And not always going to keep a record of all that stuff, not always going to write it in your notes so that it ends up in the file. Just a thing to kind of bear in mind as you're thinking about kind of this whole process and what they're doing and so forth. Well, I mean, gosh, we've been in court now for 3 hours, and all we've dealt with is the continuance. We still got a ways to go to just get through the camera issue. Court had calculated for 30 minutes aside. Court thought it was going to take 1 hour to deal with the motion to continue the preliminary hearing. Instead, it's been 3. And then the pending motions about the cameras, they're supposed to each get 2 hours. If they do that, that's going to take us to 5 o'clock Utah time. So we'll see. We'll see how they do. Oh, he's back. He's back. Hang on one sec. Where's the sound?
By way of introduction and to expedite things, we've prepared for the court a binder with all the exhibits in it. I've had it marked as A, Defendants A.
All right.
And within that binder, there are 12 exhibits. And I think because of the time limitations regarding the hearing, we do have an agreement that there'd be no objection to introducing these exhibits. And I believe the state also has a report that they want to put in evidence. We have no objection to that. So I'd like just briefly to review with the court what's in this exhibit binder, so the court has an overview of where we're going and what the evidence involves.
All right. So, Mr. Grunander, I notice you standing.
I was simply going to just indicate that is an accurate report with respect to the stipulation from the state.
Thank you. I appreciate the parties working together to streamline. That makes it easy for the court. So thank you.
So, Your Honor, in light of the agreement, I would move into evidence the exhibits that are in the binder. Exhibit A, it would be A1 through 12.
All right. And per stipulation, they are admitted into evidence and may be published at your discretion.
Thank you, Your Honor. Second of all, we have put on a hard drive that we're marking as Exhibit B all of the PowerPoints that are going to be displayed for the court, all of the scientific studies that are going to be cited by Dr. Ruva, as well as the underlying videos that are going to be displayed. Some of the videos are, because of the time limitations, have had to be edited. So we get to the gist of what we want to show to the court. But the entire video clips are on the hard drive if the court wants to look at it. I've also provided a document of all the transcripts of all the electronic media coverage from September 10th through today. It's about 6,000 pages.
I see.
But I just, in case the court wants to look at any of the material, the actual full context of some of the clips we're going to show the court, it's there. And in terms of what else, so I move that into evidence as well.
So that would be Defense Exhibit B?
Correct.
All right. And
No objection for the purposes of this hearing. And I would just say, Judge, that while these are being received into evidence, the state has no objection for the purposes of this hearing. If we move to another sort of challenge with respect to venue, for example,
I see.
we may have to revisit any sort of stipulation.
Thank you, Mr. Grunander. And just for the benefit of both parties, I meant to start with this. So we have a monitor set up here for a court reporter. I just want to make counsel aware that it could be picked up on the camera, the transmission. So if there's something that should not, please make the court aware and we can adjust accordingly. But I just want to make aware so our court reporter can look and accurately make note of what's happening in court. So just FYI.
Thank you. And Your Honor, just in terms of what's in front of the court in Exhibit A, tab number 1 is the CV for Dr. Edleman. He will be our first witness, a social psychologist and the person who conducted a survey of the community opinion. He's going to talk about that. The survey he conducted is tab number 2. Tab number 3 is his PowerPoint, which is very lengthy, and there's no way we're going to be able to get through it in the time allotted, so I'm going to do the best I can to summarize it for the court. Tab 4 is Dr. Ruva's declaration, and Dr. Ruva's, Christina Ruva, R-U-V-A's CV. She will be our second, and we're only going to have 2 witnesses. We're originally going to have 3. We've condensed it down to 2.
Okay.
So you have her CV on tab 4. Tab 5 is the report she submitted in support of the motion that we filed back in December. Tab 6 is a supplemental report that she wrote after the state and the media filed their opposition to the motion. Tab 7 is her PowerPoint, again, very lengthy, and because of its length, we're not going to be able to present the entire thing to the court. 8 is a document that is currently under seal. It's a declaration of Amber Robinson, and the court has sealed that. So one of the issues is whether it should remain sealed. And it relates to the issue of the privacy prong of the rule that indicates the court has to take into consideration privacy concerns of witnesses and others. So that is currently private. 9 is the declaration of Matthew Robinson, also private. 10 is a declaration of Ms. Nestor regarding some threats she has received. And that's, we're not offering that as private. That's something that the court can consider. 11 is a declaration from a prosecution witness whose name is Samuel New, N-E-W, indicating his objection to being televised and the reasons for it. 12 is a declaration of another prosecution witness, James Rawlinson, indicating the same thing. And Your Honor, just to let the court know, there are over 3,000 witnesses, so we have not been able to survey any of them except the 2 that we're providing to the court in terms of whether they have privacy concerns. When we get to the argument, I'll be addressing that issue, but I wanted to alert the court that we do have witnesses who are, at least these 2 who so far have stated their opinions.
Thank you, Mr. Burt.
So I'm prepared to call Dr. Edleman at this point.
All right, and just before we do, and this may not be applicable, but just to be thorough, is either party invoking the exclusionary rule?
Your Honor, we've discussed that, and I think with the agreement with the court that we would not invoke the rule, and the prosecution's expert or witness will be allowed to attend, as well as Dr. Ruva would still listen to Dr. Edleman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness, but nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burt,
Call Dr. Edleman.
State's witness is a fact witness. Very interesting. The 2 Robinsons, I suspect, are Robinsons who received all kinds of abuse after they were believed to be related to Tyler Robinson somehow, but in fact are not.
Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations that when we get to those, I will be asking the court to take them in camera, explaining why I think so. And we just, for the record, ask the court for a ruling.
Thank you. I appreciate that heads up.
Sure.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in. Oh, sure, go ahead. Well, either way.
Actually,
You're
just going to stand right here to be sworn in, and then we'll have you come to the stand.
You do solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Thank you. Now you can sit over there.
All right, so if you'd like to get seated, make yourself comfortable. Looks like you brought your own water bottle, but generally we have water bottles. So go ahead and get situated and then bring that microphone close to you.
Sure.
You just want to make sure that the audio record picks you up, so.
okay.
Pretty sure the beard is new.
I feel so tiny in this chair.
All right.
All right, Mr. Burt.
Thank you. Tell us your name and tell the court what you do for a living.
Sure. My name is Bryan Edleman, and I am a trial consultant based out of California.
And what is your educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more of as an advocate, I would say. And I do pretrial research such as focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, a lot of post-trial interviews after trials are over, so post-verdict interviews. And I also work as an expert, which is different hats. So when I'm doing this type of work, it's more as an objective person. So I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in, Mike? I'm sorry.
Sure. What were you asked to do in this case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do isn't change of venue. I would not classify this as a change of venue study.
Okay. Now, there's a binder there in front of you. Would you take a look at tab 1, please?
Sure.
Is that your resume?
It is.
And does it set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case?
Yeah, for the most part. I mean, I'm probably not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I did.
for this case? And is that in tab 3 there in front of you in the binder?
Let's see. Yes.
And I've informed you we have some time restrictions here, right?
Yes.
Do you think you're going to be able to get through this whole?
I'm going to talk really fast. I've had a lot of coffee, so I think it will be good.
Okay, good. So
Let's go,
if I
let her
could
rip.
bring that up.
All right.
So none of us get to see the PowerPoint. There's no display for the courtroom.
Okay. So why don't you walk us through what you were asked to, or what you're going to present here in your presentation?
So I'm not going to talk about the social science literature just because Dr. Ruva is going to do that. So, but primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of the from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? And what impressions they have at this point. So I would consider this like the baseline. This is a floor of where we're at right now. And we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Right. So you said on the first area, the social science literature, that's something Dr. Ruva is going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this. And the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So all I'm going to say is because it'll come up later.
Okay. So I'm going to skip ahead.
Okay.
To the extent of the coverage, and has the coverage impacted the jury pool?
Right. Okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in the courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral nature that, people watching live streams and things like that? And then what impact has this coverage had so far on the jury pool?
And question 2 is answered by your survey?
By telephone survey, yes.
All right. So let's take a look at the first area, the media coverage.
Okay, so I just wanted to touch on the extent of the coverage. So the data here come from two different sources. The first source is called Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed, but I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697. And I believe it looked at like 15 sources primarily, 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different. And it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News. It doesn't include, I think, MSNBC, NBC. So it's not an exhaustive list. It's only certain.
I'm sorry, to include
networks.
CNN, the major
It has
networks.
CNN, I think it has CBS, NBC, or maybe ABC or something like that, but it's missing some of the networks.
And I told the court that on his thumb drive, or on his drive that we provided, was the 441 transcripts,
Okay.
6,000 pages.
Yeah, that's right.
You've seen that.
I have seen that.
Okay. Next, I think you're going to look at the nature of the media coverage, and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is this is the American Bar Association rule, so 3.6 about pretrial publicity. It's not the rule, whatever the Utah one. This is just the ABA. And the thing that stood out to me initially is when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know. Will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, when I mentioned defendant character evidence is particularly prejudicial, we have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at. Are things crossing that line? Because those things are particularly prejudicial. And I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does this show us?
So The reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the, I guess the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is then disseminated, and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like here, he's reading it, but when you see it in the graphics, it shows text message that implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you say on your slide, this serves as sort of a megaphone and a distributor of certain information.
Yes. And
is within the categories you set out.
Yes. And when it's being distributed, just to point out, it's not like it's only distributed on conservative media outlets like Fox. It's on CNN, NBC, all of the networks. So it's widely being distributed to all types of viewers.
And in terms of other sources of this megaphone effect, your next, and by the way, you've got the actual video of the press conference.
Yeah, this is a clip of it.
We're not going to play that because of time limitations, but it's there if the court wants to look at it. Are there other sort of megaphone factors here?
Yeah, so this is a unique factor in this case in the sense that people who are very influential, obviously the President of the United States, or former Attorney General, these are people that have a lot of influence and power, perceived credibility, and they're making strong prejudicial inflammatory statements. And I think that's unique. I don't usually see that in cases. And calling for the public execution of the defendant before there's been a trial, things like that are unique in nature.
Right, Your Honor, this is one of the slides I would like the court to see, and it's, as he just indicated, expressing opinions, strong opinions about whether Mr. Robinson should be executed. So the court wants to take it in public. That's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it and the substance, I think, is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive. The court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in its entirety.
If we're not going to play, just one thing that's unique about it, if we're not playing it, is there's inflammatory language in there that also creates in-group, out-group identification. When I think,
could you explain that?
Yeah, so it's like a lot of people identify with a political side. Unfortunately, I'm a member of the Democratic Party or or Republican Party. I'm liberal. I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like that are doing this. So it creates this, the out-group is dangerous, they're lunatics, maniacs, or whatever phrase was used, which creates more of danger, the perception that members of that group, that out-group, are dangerous, and there's a danger there. So that's something that comes up later as well.
And how is that kind of information more or less prejudicial?
Well, it creates, again, in-group, out-group identification, and we think members of the out-group are not like us. They tend to, they're all the same. We have to attribute stereotypes that of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high. Versus members of our group, we see as individuals or complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
All right. Now, did you actually take a look at the court appearances that have so far taken place in this case to see what was discussed so that you could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced?
Yes.
Yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing. And you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right? Mm-hmm. And the same thing when you have like the waiver hearing, appointment of counsel. There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function.
If they were educational, transparent, a summary of what occurred, these are very procedural, technical things, are not necessarily sensational in any way.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson? Right.
So this is a brief, short hearing. Where, I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay. So let's take a look at the clip. And this is from NBC
You have been
News
watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speak.
I think we got a problem with the audio.
To thank all parties for being here. And this concludes to thank all parties for being here.
So I need to...
We can hear it.
Let me check and see. That's in settings.
Is this source? The volume for the source might allow for amplified volume.
I don't know, guys. They're still really focusing on the secondary processing of all the information, which they clearly don't like, but there is no way they're going to be able to stop that.
That's the way it happened last time.
Crystal clear black letter case law that if nothing else, we get the court filings, and there's going to be, secondary communication about that. So don't know how this is going to tie into the live stream itself being the problem.
Speaker. Oh, it's not coming up.
Yep. People are going to talk no matter what. They can't be shut up. So do we want them talking about good information that we see directly from the court ourselves? Or do we want them talking about like bullshit that they're fabricating and making up in their minds and so forth hasn't been vetted at all?
Okay, so is this first slide from it's not in there? All right, let's try that out.
There we go.
There we go. Okay, let me escape. Slide. Okay.
Did you skip the previous?
This seems to track.
There we go. So is this, as you indicate on the slide here, this is ABC's coverage of the September 16th, 2025 WebEx appearance?
Yes.
And in this clip, are you picking up the coverage right after the court says we're in recess?
Yes.
Okay.
I understood exactly what you meant, and I agree. I do not purport to be a Charlie Kirk expert. Didn't watch him, didn't really follow him. Politics are not my thing. But very consistent with my total outsider perspective on Charlie Kirk and the kinds of things that he believed and stood for and advocated. Tyler's lawyers are all court appointed. I actually have the contract, something I got from a grammar request not too long ago. They are court appointed, paid for by the taxpayer. And not a luxurious amount either. I think you're absolutely correct that this is what they do want, but they're not going to get it under black letter First Amendment case law in the United States. Our courtrooms are open,
No audio at all.
particularly in criminal cases.
I tried different laptop.
I'd have you read that laptop first before you try this one.
I'm sorry.
I recommend rebooting the laptop.
Okay. Apologies to the court. Thought we had this set up. Let's do.
No, capital attorneys are few and far between. We use a private contractor, as are the other. Well, Ms. Visser is another one from Utah, and then the other two are from California. Mr. Burt and Mr. Novak. They have all contracted with the county to provide these services as public defenders. This is a very valid point. When I say luxurious, I mean relative to what lawyers earn in pretty much every other type of practice and in pretty much every geographic area. What they are being paid is less than that, considerably less. And they all, still have their overhead and everything like that too. So we can't just assume, oh, they receive X amount and it's all going in their pocket. No, it doesn't. It goes to the cost of running an office, being insured, etc. You don't have to ask my permission. Good Lord, look at you guys. You've been giving my Mr. Novak all kinds of crap all day. I haven't even like super fangirled about Mr. Burt yet. This is a mess. Like, is this clip so important that we are going to sit here and like this and not just move on?
I've rebooted.
Pull the cable out one more time, and then plug it back.
Say again.
Pull that HDMI cable out now that you're doing it. And plug it back in.
Okay. That work?
There we go.
There we go. Okay. Yes. I think we're good. Okay. My apologies. So you're picking this up from the point in time right after they've shown the whole hearing.
Yes.
And this is kind of the aftermath.
Right.
A little love tap, like getting the starter going. Just whack it with a
You
with
have
a
been
hammer.
watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speaking, wearing what appeared to be some kind of green vest, as the judge read out the 7 charges against him, including, of course, aggravated murder. The state making clear that they are seeking the death penalty and putting in place, the judge did, a protective order, apparently at the request of the state, for Erika Kirk, Charlie Kirk's widow. I want to bring in Danny Savalos. I want to bring back Steve Patterson, who's live for us in Utah. Dan, here too, some of the paperwork is just into us on that protective order that the court finds the defendant represents a credible threat to the physical safety of that person here being Erika Kirk. Danny, stand by for a second. I want to go back to Steve Patterson here. And Steve, it has been a remarkable series of developments over the course of the last several hours as state officials, the Utah attorney there earlier in the day described, and the charging documents, some of these probable cause documents showed step by step, almost minute by minute in some instances, how they closed in on this 22-year-old as their suspect.
They did. And in doing so, we got the TikTok, we got the charges. Also, these, the exchange of text messages between Robinson and his roommate. These are details that we simply didn't have before. One thing that sort of gels with what we saw in the text messages, this exchange again, before and after between Robinson and a roommate who believed to be romantically linked, is how cognizant and lucid Robinson appears. And I would say that for looking at this video, although unblinking, so unblinking and eerily at times that it almost appears like the video is frozen. Just want to comment a little bit more on the physical appearance of Robinson, appearing over WebEx on video, appears to be wearing what is described to me as a safety smock. We know he's on a special hold, right? They're going to hold him there in a separate unit before they evaluate his mental health, before they put him in maybe a more different location, a more general location. They do that as a matter of procedure, right? But it is sort of interesting. He did say,
So that's what they want. That's it. Talking about the text messages and the unblinking, eerily.
One thing, which was his name, which was stated clearly and firmly. And again, I want to say gels with sort of what we saw in that exchange of text messages, because he's talking to his roommate who clearly appears to have no idea, the roommate, what is going on or that he is the suspected shooter. And yet he's sort of talking a TikTok of what he's done and why he's done it and admitting to do it, essentially shocking this roommate through these series of exchanges, which sort of gels with his physical appearance today. Obviously, we also heard during the hearing, the Utah County following the course of action to introduce the death penalty as well. That was filed as this was being read in court. So definitely some developments here today. And just the amount of information that we got, the blanks that were filled in. That's right. Not only that, but also on the apprehension, the involvement of the mother as well, and sort of bringing him in. And also the physical evidence, the DNA found on the actual trigger of the rifle, which was tied to not only what was found on the screwdriver, but also the towel used to wrap the rifle. So an extraordinary amount of information that we got, especially with this charging document that's now in.
What's also clear from these text exchanges laid out, Steve, is that Robinson had no intention of being caught. And I say that because he said he had hoped to die of old age with this being his secret, according to what the state had laid out in this text exchange. Almost seemed panicked when describing trying to go back to return to retrieve the rifle that he allegedly shot Charlie Kirk with, not being able to do so when essentially caught out by his parents, when his parents approached him and said, we think this may have been you, tried to get in touch with him, tried to reach out. The state says that Robinson suggested or implied that he may try to take his own life here. So you can get a sense of his mindset, at least based on some of these text exchanges and what law enforcement has laid out over the course of some of these documents here. All of it, as we should note, these are the state charges here. It's possible federal charges could come.
Yeah, federal charges possible. One notable sort of omission is we didn't see any federal officials. We don't know if federal charges will be filed, although it's heavily implied that they will. One thing also is sort of the level of deceit, both with the parents. The father did something that sounded very clever. It was heard the description of the rifle that had been described by authorities, federal authorities, state authorities, and that he assumed, obviously with the pictures of Robinson himself on camera at the university, assuming this is his son, tried to get in contact with his son, trying to ask, hey, could you send me a picture of the rifle that I gave you? And of course, the son sort of ghosting him, seeming to imply, again, involvement. And also about the rifle, there was a lot of investigative work to try to figure out, was the rifle traceable? Was it bought legally, illegally? Would have been hard to trace, we now know, because this was essentially a family heirloom, something that's common in hunting families, passed down from grandfather to son, and that was the case here. So again, much more stark relief that we're seeing this case in Hallie.
That's right. Robinson also telling his mother he had been out sick, had stayed home sick over the course of the 2 days that she had inquired about. Steve, I know you're going to stand by for us later on as we get potentially more on this. Danielle, let me go back to you here briefly, because Steve laid out what could come next here. Obviously, the death penalty that the state is seeking. What about this protective order for Erika Kirk? Is that something that is typical in the course of an investigation like this, a prosecution like this?
Sure, yes. As to prospective victims, it's usually not entered against someone's spouse, but it makes sense here because this is not some street crime or a crime of passion. This is someone who was apparently, whether by this defendant or not, targeted. And so it makes sense to say, well, close members of the family may also be targeted as well. So it's not unusual for judges to enter those kinds of protective orders as sua sponte on their own or in response to a request from the prosecution.
Danny Savalos, thank you very much for that. I appreciate that. We have been talking now about the developing news that has occurred over the course of the last several hours, with prosecutors laying out in detail how they say Tyler Robinson carried out this murder. We're going to play a big portion of that in case you missed it earlier. We want to basically roll that tape so you can hear for yourself how the state laid this out. Take a listen.
These are the allegations.
And let me stop it right here. At this point, does she play essentially the entire press conference by Mr. Gray?
Yes.
Okay. And we didn't include the entire 27, 30, or 45 minutes, right? We clipped it to get to the end of the coverage.
On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action 30-06 rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, 2025, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office.
You have been listening to Jeff Gray, the Utah County Attorney, earlier laying out those minute-by-minute details on how they caught the man accused of assassinating Charlie Kirk. You saw the court hearing for suspect Tyler Robinson live before that. That was that virtual hearing. As prosecutors say, they will seek the death penalty. Robinson will remain in jail, no possibility of bail. He'll be in court again in just about 2 weeks.
And again, just to reiterate, we cut 27 minutes out of the press conference, right?
Yes.
So how does this coverage line up with what was happening in court?
Well, I think, like we said, there's an implication that there was, like, the text messages were part of the court hearings, because he implies that was part of the hearing. And then it's bringing up all of this new information or old information that has nothing to do with the hearing. So it's just rehashing. Let's remind you about the text messages, DNA, the deceit of the dad because he was suspicious of him in terms of the gun, and all of these things have nothing to do with this hearing.
I noticed the reporter when he put that graphic up of the text. By the way, was that graphic the actual phone of Mr. Robinson?
It's not. No, and it implies, and then you see that throughout a lot of the coverage, like text messages. There's YouTube reels where somebody like creates a reel and reproduces text messaging, so it looks like it's the real text message.
And when he's putting that up there, he says, as we heard in the hearing, words to that effect.
Yes.
But there was no mention in the hearing of text messages or anything else, was there?
Correct.
Is he confusing what he heard in the press conference with what he thought he heard in the hearing?
Well, I think he's confusing the viewers with what happened in terms of now that, there's a belief like evidence is being presented in these hearings that imply guilt when that's just not the case.
So as you say in your slide, is this coverage sort of advancing the prosecution narrative?
It always has been.
As opposed to an educational
That's not
function?
news.
Yes.
All right.
They don't know what they're watching.
Did you also take a
They get
look
wrong all the time.
at ABC's coverage?
Yes.
And by the way, the last slide was, I think, the longest slide, right?
I think so.
All right. So this is the same day.
To thank all parties for being here, and this concludes this hearing at this time. Court is in recess.
So the suspected shooter there of Charlie Kirk, the hearing has now just concluded. We know that the state is pursuing the death penalty here. We have just learned throughout this proceeding that they are going to try to find him counsel. They deemed he is indigent, so they will be providing an attorney for the alleged shooter. And the next time that he will make a court appearance will be September 29th. And then again, as you heard the judge there say, that will happen on WebEx. A couple other things that we learned here throughout this quick hearing is that he will remain in custody without bail, and that the state was also present there, and they asked for a protective order on behalf of Erika Kirk. Of course, that is Charlie Kirk's wife. A reminder to everybody that, yes, he was a conservative activist, but he was also a young husband and a young father of 2 children, and a protective order has been granted on behalf of Erika Kirk. I do want to bring in our ABC News chief national correspondent, Matt Gutman. He's in Spanish for Utah there for us. Matt, thank you here for being here with us. And so we just saw this proceeding play out. No surprise, right? This is not the proceeding in which this person would enter a plea. But Matt, prior to this, there was a lot of evidence that the prosecution sort of laid out for the public, including text messages, DNA, things like that, that they do plan to try to present to the judge to be admitted here in trial. But perhaps, Matt, you can just gauge for us, since you've been covering this now for so long. Tell me about your first reaction here in seeing Tyler Robinson sit down there, if you were able to see it, sitting down in this court hearing.
He was sitting down. It was via WebEx, so he wasn't physically in the courtroom came up with the judge. But you could see that people were watching. You could see he was wearing this padded vest, and that's because he's been in what's called special watch in this jail here, which is essentially in isolation. He's being held to prevent him from harming himself or from others harming him. We heard from the prosecutor earlier today in his announcement of the charges that the suspect's mother had said that he was suicidal and that he wanted to kill himself allegedly instead of turning himself in. So you see him in that protective garb. The bulk of this hearing that we just saw was the judge reading the 7 charges. Of course, they are aggravated by the fact that the suspect allegedly committed this political assassination of Charlie Kirk in full view of children. So that's one of the things that has enhanced the charges against them, and one of the things that makes this a capital case, according to prosecutors here.
And I'm hoping we can just quickly go through some of those text messages that you mentioned there, again, with this roommate, with who prosecutors say that he was romantically involved with. And one thing they touched on in this hearing too, Matt, is the fact that in this text message exchange, we're showing some of it, but Matt, they pointed out to the fact that they believe the shooter asked his roommate to delete the exchange and then to not speak with the media, and then it's shown in these charging documents, Matt.
Yeah, we have not seen these text messages. We have heard them for the first time from the prosecutor. They also put out this charging document in which these messages were revealed. And it appears to show this exchange between the suspect and his roommate, with whom he was romantically involved, apparently. And it's very, very detailed. And in the text messages, the prosecutor says that the suspect was talking about the murder weapon, talking about where he stashed it, talking about how he stashed it, and yes, allegedly allegedly advising his roommate to delete the messages and not to cooperate with law enforcement, to get a lawyer and not talk to the media if there's blows up, and eventually it did. What also struck me about these messages, at least initially, is that the suspect appeared to think that he could get away with this. He was hoping that he would never have to mention this to anyone ever again, and that they would never be able to find him. And it was only, as we've learned through these text messages presented by the prosecutor, when he realizes that he can't get back to that rifle that he stashed and take it somewhere else, and he realizes that police is right in that vicinity and he can't go get it, that he is in trouble. And that's when things start to spiral out of control for the suspect, according to these text messages. And at that point, he does appear, at least afterwards, to talk about being suicidal, not wanting to turn himself in. Eventually, he's convinced by his parents that he should not do any harm to himself and that he should do the right thing and turn himself in. Kayla.
Right, and the prosecution revealing this was his grandfather's rifle. It was a very important piece of family property.
Right.
Matt Gutman, thank you, as always, for being here with us today. I also want to bring in our ABC News, Washington, D.C. Bureau Managing Editor, Catherine Falders, for more on this. And Catherine, again, no real surprises here in this initial court appearance. I think everyone now marking their calendars here with September 29th to see what kind of counsel this alleged shooter does get ahead of time. Also notable, again, a protective order has been granted on behalf of Erika Kirk, Charlie Kirk's wife, throughout this hearing. But Catherine, I think really the prosecution made a huge effort here to lay out as much of their case publicly as they could. And they made it very clear, Catherine, in this hearing that they are ready to give over all of this discovery to the defense, the state really making an effort to have their ducks in a row here ahead of this court appearance.
Yeah, exactly. You did hear them say that, all of that information that they've gathered that we've heard about, obviously, through the press conference earlier and these charging documents. There is a lot of evidence that they have. There's mountains of evidence that they have that we've learned through public documents like the one we received earlier and also through our sourced reporting. We know they're doing forensics, for example, on the weapon that he used, which you just discussed a moment ago. So, yes, they said that they're getting fascinating, Kana, to see him for the first time from sitting there from jail. He stated his name in that clip that you're playing where you hear him talking. That was him stating his name, Tyler James Robinson. And I noticed at some points when the judge said, I'm looking at my notes, but when the judge said to him that he was going to remain in custody without bail, you could see Robinson shake his head yes. When he said that he was going to read the charges, remember there's seven counts here, 6 felony counts. When he told Robinson he was going to read the counts, you could see him shake his head a little bit of movement there, but he hasn't said really anything else, of course, other than stating his name, and he will be provided an attorney. But I do think that it is quite striking to hear and see all of that evidence that it appears that the prosecutors have gathered. Looking at the charging documents again, we of course have been really focusing on those text messages that Robinson and his roommate exchanged. It appears they exchanged on the 10th, so shortly after the shooting. Now, it's unclear whether these are all of the text messages in the possession of prosecutors. We don't believe so. There's probably more, but those were quite striking to see.
So how does that coverage stack up with educating the public about what was going on during the initial court appearance?
Well, I think you can see he's trying to, in the beginning, lay out what occurred, and she actually stops him and says, I want to get to the text messages, and brings it up again and moves it there.
Right.
And implies again that stuff came out in the hearing.
So
it's kind of blended that sometimes it's mentioned in the charging documents, sometimes it's the prosecution made an effort and implies in the hearing again. In just focusing on the evidence. It's not focusing much. I mean, that's like a 5-minute clip, and there's very little about what happened. It does mention what happened. I don't want to act like they didn't talk about that at all, but they blend quite a bit of evidentiary information in there. And at the end of the day.
And when you say evidentiary information, are you talking about incriminating evidentiary information?
That has not been determined to be admissible or anything. So, right. It's just, here's the text messages and calling it a mountain of evidence and all that kind of stuff.
Yeah. Okay.
To thank all parties for being here. And
but also, you have a very stoic.
How CNN was covering this initial appearance.
Yeah, this is the same hearing.
And
you gotta watch the same.
Your understanding is the person in the CNN clip is a former prosecutor who's CNN's chief quote legal
This is like
analyst.
the worst
right?
coverage they can point to. This is
Okay.
so anodyne.
Let's take a look at that one. That's your
This
next
is like
clip.
not getting the judge's attention as being a
24,
problem.
I believe.
But also, you have a very stoic defendant who I was looking to see any emotion that he might be displaying. Hearing that the death penalty may be requested for you is a very monumental seismic moment. He had no reaction, nodding in essentially understanding alone. But then there was also a protective order that was asked for by the prosecution on behalf of Erika Kirk, now widow of Charlie Kirk, that entails that there might be an element of fear that she is experiencing, or the thought that she wants no contact either from him or anyone around him that would make her feel more secure. Of course, she is a mother of 2 young children. You understand that. But here you've got a speaking, essentially, indictment of sorts from the prosecutor earlier today, which laid out so much evidence. It's all allegations, the statements of counsel, not evidence in a court of law. But what can come in a court of law?
Yeah.
The statements of the defendant, including all these text messages.
Well,
So according to CNN in this clip, the evidence that she hasn't looked at is admissible, right?
And again, mentions it was laid out today, implying that it was laid out in this hearing, and discusses his demeanor. He didn't react properly, according to her. His body language didn't, whatever the appropriate way to react is.
Didn't say anything about it.
So,
just that she was looking for
focusing
it.
on him, focusing
Information.
on these text messages, calling them admissible without ever.
And I notice in all 3 of these nationally broadcast clips, there's a real focus on the protective order and tying that to Mrs. Kirk's fears, correct?
Yes.
How is that furthering the prosecution's narrative?
I mean, to me, it just goes to future dangerousness of impressions of the defendant. So it kind of talked about earlier, negative character evidence is prejudicial. And also we know from the research that pretrial publicity in fact affects verdicts and the perceived credibility of the defendant, likability and sympathy. So it kind of goes to that.
Okay. Did you also look on that for that court appearance on what the local media was doing?
Yes.
Right. And before we turn to that, did you also look at how Fox 13 captioned the importance of the hearing on the 16th?
Right. So transcript reveals Robinson's alleged confession to shooting Kirk and messages to roommate with a screen capture of the court proceeding.
So the gist of what happened in court, according to Fox, is the confession.
That's what it implies. Yes.
Yeah. Okay. Now at the local level, did you look at this clip from
Following
KUTV?
Robinson's initial appearance in court today, we did speak with a body language expert who has been part of hundreds of high-profile criminal cases across the globe.
And some of the most compelling cases include Brian Koberger, Lori Vallow Daybell, Casey Anthony, Karen Reed, and Alec Baldwin, Scott Peterson, P. Diddy, Gypsy Rose Blanchard, Amber Heard, Prince Andrew, Nicholas Rossi, to prolific serial killers, Ted Bundy, John Wayne Gacy. Tonight, Chief Investigative Reporter Wendy Halloran talked to Scott Rouse, who helped break down Tyler Robinson's body language. Wendy.
Well, Jamie and Mark, Scott Rouse dissected the nonverbal cues, analyzing gestures, expressions, and demeanor after Robinson learned prosecutors will seek the death penalty against him in the assassination of Charlie Kirk.
Look, if you put weight on
Tyler
stuff like
James
this, it's
Robinson.
kind of on you.
Thank you for being here, Mr. Robinson. I'm Judge Graf.
Tyler Robinson appearing virtually from the Utah County Jail in a suicide robe.
It's really odd behavior for someone who should be stressed in that situation.
Scott Rouse is a world-renowned behavior analyst and body language expert. He holds multiple certificates in advanced interrogation training and has trained alongside the FBI, Secret Service, U.S. military intelligence, and the Department of Defense. He serves as an expert consultant for law enforcement and the U.S. military, among others.
But I'm going to tell you from my experience what I see going on here.
I asked him to analyze Robinson's demeanor.
No big, deep breaths. We saw a couple of breaths that weren't deep breaths, but they were breaths from just, it looked like they were almost from boredom.
Oh my God, they're
So
all
that was a
breathing.
little bit odd as well.
Rouse says when he looks at people in situations like this,
Things like this, other things that are missing, and those are all the things that are missing right out of the gate. And this is odd behavior for someone who theoretically should be fairly stressed at this point.
Rouse says it could be that he hasn't slept much.
Even though it doesn't look like a whole lot going on there, that's odd behavior for a situation like this. I've seen these 1,000 times where someone is being in the same situation, you're talking to them, and they've done something horrible. And they don't know what's going to happen next. They don't know what to expect. They don't know how to act during that. And this guy just looks relaxed.
Rouse recounted what facial expressions he would look for.
And you've got things called adapters where you try to get rid of built up stress and tension. Don't see any of those. We see a little bit of clenching of the jaw, and his jaw goes over to his left. I think it's his left. And that's about it. In my opinion, he's pretty much resigned to whatever's going to happen is going to happen. There's nothing that tells us he's frustrated. There's nothing in his face from an expression perspective that tells that he's worried or frustrated or angry or anything.
Rouse says there were no jerky, tense body movements, and he meticulously watched his eyes.
We can't see his blink rate very well. The blink rate tells us if someone is concerned or thinking about something or is stressed about something, because your blink rate goes up a lot. Because the normal human will blink about 15, 20 times a minute. And from what I could tell, it was a low blink rate because I was catching maybe 10 times a minute. It wasn't a whole lot. So I think from an emotional standpoint, he's given up.
Now, Rouse said if Robinson was concerned about something, his eyebrows would raise. He says he didn't see that happen at all in this hearing. Mark?
All right, interesting. Wendy, thank you.
What stands out to you about this kind of coverage?
Well, now we're completely speculating with sensational conjecture because he didn't blink properly and his eyebrows didn't go up enough or whatever it is. And now it's creating this impression that this person has no emotion or empathy, like he might fit I think later it becomes a sociopath, and we all heard the story of they have no emotion and all that. And this is all based off of him watching a WebEx for a couple seconds and just making these ridiculous statements because he's the body language expert now. So he can now make an assessment from this hearing that he didn't respond properly because he's, quote, given up or whatever he said. And this is all, obviously, none of this is informative, and it's all speculation and sensationalism.
And by the way, you're aware of the fact that the court has moved the camera from the front of the courtroom to the back.
Yes.
Right. And moving it to the back, does that still allow some room for these so-called body experts to maybe analyze how his shoulder was tilted?
If his jaw doesn't move right, or controlling if somebody turns around for a second. I mean, it's a courtroom. Things happen over time. So the fact that anytime there's a movement, it might spur some ridiculous story about somebody's nonverbal language is incorrect.
That's fine, but you can't block the body language guy from the courtroom.
I think
just do it in person.
Sensational and ridiculous.
Okay.
Following Robinson's initial.
Now, did you also take a look at the September 29th hearing?
Yes.
And what was your understanding of what actually took place at that hearing?
So this was primarily, from what I remember, it was appointment of counsel in this hearing.
What's called a waiver hearing. You got on your slide waiver hearing, appointment of counsel. Mm-hmm. And again, Mr. Robinson is appearing on WebEx at that hearing.
So it hasn't been in the courtroom yet, still so WebEx.
Was it your understanding at that appearance, counsel got appointed?
Yes.
Essentially. All right. So how is that covered, first of all, by Court TV? And before I show you the slide, are you endorsing the criticism that Court TV in the slide makes against the court and the prosecutor?
I'm sorry, endorsing what?
Are you endorsing the criticism that in the slide, the court and the prosecutor?
No, that's just what was said by one of the commentators.
What were you trying to assess and looking at this slide, what the perception of the public is to the in-court proceedings?
Yeah, I mean, I think it's commentary that falls on the sensational side, right? So now it's these people are pandering to the camera and it's creating a performative experience. So it's turning into like outside the courtroom, like a reality TV show in a sense, like, this, I don't like what this person said or that person said. So not informative as to what's happening, but it's sensationalism. And it's just the kind of thing you want to avoid.
So let me play this for you, and then I'll ask a question about it.
Be live, Matt Johnson alongside my friend Kelly Graf in today for Ted and Julia. Busy day here. Let's begin this hour in the state of Utah, where the suspect in the Charlie Kirk assassination is due back in court today.
22-year-old Tyler Robinson is accused of murdering the conservative activist during a rally that was held at Utah Valley University. This took place earlier this month.
Robinson is expected to appear via Zoom during that hearing alongside his newly appointed defense attorney, where we're likely going to hear a discussion as to whether or not they want to schedule a preliminary hearing.
While we wait for that hearing to begin, let's go ahead and take a look at a backgrounder on this case. This is Court TV affiliate KSTU with a closer look at the suspect, Tyler Robinson.
Robinson had confessed to them or implied that he had committed the incident.
From his apartment to his family's home, the FBI and police combed every inch of Tyler Robinson's life, his family expressing to law enforcement that he had become more political in the last few years.
Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Why don't we go ahead and bring in our guest this hour to discuss as we wait for that court appearance to begin out there in Utah. Joining us now from Los Angeles, California, former Deputy Public Defender for LA County, Philip Dubé. Philip, nice to see you on this Monday.
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
All right, and that concludes that hearing. Philip, let's go ahead and bring you in on this.
The only criticism I had was that those closing words about how we're all here to seek justice, like the warriors of justice. Attorneys and judges don't speak that way in open court. It's presumed that everybody will act with integrity, with honor, and to articulate it on the record, in my opinion, is pandering to the cameras.
All right, Philip. So
you're familiar that one of the criticisms of the court coverage in the O.J. Simpson case was that everybody, including the judge, was pandering to the camera. You familiar with that?
Yes.
And this guy from L.A., he's probably familiar with that case. He's accusing the court and the prosecutor of pandering to the camera. And then this first part of the video, where they refer to the backgrounder, are you familiar with what's referenced there?
Yeah, again, it's kind of going into the background stuff again about evidence and then jumping in while they're waiting and so on, and then jumping into that.
And who is giving the backgrounder there? What the clip is of Governor Cox, is it not?
Yes, the governor. Yeah.
Okay.
Yeah, reading another press conference.
So that's a sort of an incriminating narrative. And then the second part of it is, what is the perception of the public to the court proceedings being televised? And at least according to what Court TV is putting out there.
Oh, that it's a show. It's pandering to the camera.
Pandering to the cameras. Yeah. Does that further the reputation of the judiciary, or does it detract from it?
Is it what?
Does it further the reputation of the judiciary, or does it detract from it when the perception is right or wrong? And I'm not in any way endorsing what he's saying, but in terms of what's getting put out there to the public.
I think it creates pressure on everybody to have cameras in here, from the jury to everyone involved. I think this is a very high profile case, probably one of the more high profile ones I've ever been involved in. I think there's pressure on the prosecutor, the jury, everybody involved in this case. There's a lot of people watching, including the executive branch, everybody's involved. So I think just those comments and everything else is just pressure.
But those kind of comments, like a comment that a prosecutor is pandering to the camera, if that gets to prospective jurors, and that prospective juror is sitting in court as a juror and is asked to evaluate the arguments of a lawyer, and he or she already has a preconception that, oh, this is a guy or this is a court that is pandering to the camera, what does that do to the reliability of the fact finding?
I'm just gonna. It is what it is. I don't have anything else to say.
Be live, Matt Johnson, alongside my friend Kelly.
What was on the September 29th? What was CNN's sort of capsule of what the hearing was about? The appointment of counsel hearing. What was their headline?
Yeah, so confessions, DNA, and his grandfather's rifle. This is the evidence so far on the Charlie Kirk shooting suspect.
What did confessions and DNA have to do with what was happening in court on the
Nothing.
29th?
And again, this is just in every hearing and everything you see, it triggers the same information and the implication that this stuff is part of the hearing. So people aren't necessarily watching the live stream. A lot of times in these courts, you're watching the coverage of the live stream, not the live stream itself.
Okay.
You know, like in the survey, not a lot of people,
what about all us?
25% watch the live stream, but people are seeing this stuff on TV, and this is what the media coverage is. So it's not showing the live stream, it's screen captures, it's high profile, like a short summary of what happened, and then going into this information and the perception that this was evidence presented in the hearing when it was not.
And the substance of it, confessions, DNA.
Exactly.
Is sending a message, is it not?
Yes.
Now, is this, again, on the December 11th court appearance?
Oh,
When I
Lord.
ask you how Fox News covered it, and with one of their talking
Just
heads
add
here.
to our comments about his demeanor in court earlier. You know, we talked a little bit about don't try to understand the mind of a monster. Well, we do know a little bit about the mind of this monster in that I believe he's incredibly proud of his handiwork. It makes us think a lot about Luigi Mangione. These two men inscribed notes on the bullet casings that they used to commit murders, murders that were to send a message. He committed an assassination in a very public place against a person that he had ideological differences with, entirely politically motivated. That is a person who's proud of their handiwork. So I think that when we see him loose and calm, relaxed, and smiling in court, I think that's an outer manifestation of his inner feelings, that he is very proud of what he's done, stands by what he's done, has no remorse for what he's done, and is looking forward to the world watching.
Jonathan, I see you nodding in agreement.
Real trouble. Yeah, I think that's exactly right, as Josh put out. When you have cases of this kind, you are off the map. You are where monsters dwell, to use pirate terms. This is where you find monsters, are in these cases. And you find people that don't think the way you do. This is one of the reasons jurors often stare at defendants whenever they can get away without being impolite. They look at these defendants to try to figure out something not just about them, but themselves. How can someone go off the map to this degree? The evidence here is overwhelming, and a lot of attention is likely to be what possesses a person like this to treat someone like Kirk as a trophy, and that is what happened.
Well, if it's true that he did it and he gets convicted of it, I guess you could say that, you know, he thought in his own twisted mind that it was something that he needed to do, and you could never understand, as you were pointing out earlier, Professor, you know, Trey was pointing out, you know, the person who drowns their children and the person who bludgeons someone to death, you could just never get inside that mind to even begin to understand what's going on.
Is it your understanding?
That's right. I think that's absolutely true.
Yeah.
Really, we can take judicial notice that the media is a bunch of idiots.
You're understanding the first commentator, the first talking head there is an ex-prosecutor, right? And is he sounding like a prosecutor talking about the mind of a monster?
I mean, to me, it's more sensationalism. First of all, again, negative character evidence is some of the most prejudicial pretrial publicity that you can have, emotional negative character evidence, particularly in death penalty case. And you're hearing mind of a monster, he's a trophy. I mean, he's smiling. Like, what is the basis of any of this? Like, there's nothing from that hearing or anything that is relevant here. Like, this is just pure speculation and sensationalism.
Now, the second speaker, the guy who chimes in and says, yeah, this is the evidence is overwhelming. At this point in time, had any evidence been disclosed to anybody, either in the court hearing or, as far as you know, any place else?
The only thing we've had is a press conference with the charging document.
So the second guy, a law professor, from Georgetown in Washington. What would have been the basis for him commenting that there's, all kinds of evidence here, agreeing that we're dealing with monsters? What is the factual basis for that?
I guess from the charging document.
Okay.
Just add to our comments on that.
Now, did you also take a look on that same date of the Fox coverage? And this is from the ex-FBI agent. Is there talking head here?
Yeah, and the sociopath stuff feeds into what we've heard earlier.
Well, my first reaction is looking into the courtroom and seeing what's happening. Again, talking about Robinson, it's disgusting. He's a true sociopath. It's someone who has absolutely no empathy. They have no remorse. They have no conscience. He killed somebody. He doesn't care. He's smiling. But again, that's not going to serve well. When the trial comes to pass and the death penalty is on the table, again, jurors will not be okay with that. The other thing that I think is very important to understand is that working with these victims, I know myself when I was an FBI agent, I wanted a victim-centered approach. Erika Kirk and those in her surrounding sphere, her family, her loved ones, Turning Point family, they are the victims of this. And frankly, the American people who have had to watch this absolute catastrophic tragedy and evil live on television. I mean, it's disgusting, it's heinous, but she has a right to know. And I do think it's very important in this process that you are working closely with the victim. And I assure you that they are. She deserves to know what is going to happen. She didn't wake up one day and become a legal expert and a law enforcement expert. She is the victim of this most heinous crime. And again, God bless her. God bless her family. And I do appreciate that there are people that will step up to the line and will hold her hand and walk her through this process, as that is what she deserves. There's several other things that come to my mind in this trial, but it does come down to the judge's decision. But the conspiracy theories are despicable, they are disgusting, and you are profiting off of someone who has been murdered. And that is wrong, that is sick. And if you think that you're helping justice to be served, you are wrong. You are doing no favors for the prosecution team. There are solid law enforcement officers on these investigations. Trust that they are doing the right thing for the right reason. Look, I come from the FBI. I understand why people are in a position where they do not always trust the criminal justice system because of things that we have seen in our country. But rest assured, on this investigation, no stone will be left unturned. All eyes are on this, and there will be no mistakes made. And so please do not take the liberty to go and make up and fill in the gaps where you do not have answers. It is inappropriate. You are not helping things. You are making things worse. And if you want justice to be served, you need to let the process work the way that it should and stop putting these lies into people's minds, because you are hurting people. And most of all, you are hurting Erika Kirk, her family, and her loved ones. It is unacceptable. It cannot be tolerated. And anyone that has a clear conscience about making money and creating clickbait, that is sick.
Yeah. Now, what about that segment educates the public about what was happening in court on December 11th?
Yeah, clearly it's not, and it's in the backdrop of you see just, in the corner of the courtroom, but it's just, again, an opinion and a diatribe basically about, there will be no mistakes, no stone will be left unturned, and that the prosecutor's doing everything correctly and so on, so.
Does the literature tell us anything about what impact it has in terms of who the person speaking is? Like, this is an FBI agent, ex-FBI agent. So do people listen? Does research say anything about that?
It's just like a source credibility question. Law enforcement, people know who she is. It's not always the case that a stranger is seen as credible, but definitely when you hear more prominent people saying it, absolutely. And just you think about how people passively consume information. So you're not really, when you have this on, you're not necessarily highly critical of what's being said. It's passive consumption of news. So you're not questioning the source per se or thinking, well, this is maybe not appropriate. None of the evidence has been presented yet. It's editorial masked as news, basically.
I notice in this clip, she's critiquing the conspiracy folks from trying to profit from their commercial ventures.
Yeah.
And as she's making this critique, you notice the advertisements running on the side of the video. You get a loan for a car loan.
Yeah.
4.99%.
I mean, it's an ad because it's online. I mean, yeah, there's an ad there for sure. So they're monetized. Is that the point that they're monetizing it? Sure.
Right. Is that typical of the coverage you're seeing here? In other words, especially on the social media, if you go to social media and try and pull up these clips, you get the clips, but you get a lot more, don't you?
Yeah, I mean, you're always going to get ads on social media. That's how they make money. Are you asking about more like in terms of how?
I assure you,
like,
the mainstream media is going to get revenue as well.
Well, we'll get to that. Okay. That's a separate issue. Okay. This is the, I'm going to skip.
And accused of assassinating right-wing political activist Charlie Kirk
was there also at the December 11th hearing quite a bit of focus on the tie that Mr. Robinson was wearing?
Right. So to me, the thing that stands out is you could see the impact of some of this stuff that's irrelevant. So there was a reference to his tie, and it was like trans tie, and then a pro-trans tie, whatever that is, and that becomes a search term. So people want to know more about that, or just following his court appearances and so on. So people are more engaged. They're actively searching, which is different from passive consumption.
Okay.
And just to be clear, I mean, there was an increase. I don't know what the numbers were before, but yeah, there was a significant increase in those searches.
Hey, Mr. Burt, I don't mean to interrupt, but I just want to give you you have 45 minutes remaining.
Somebody just passed me a note.
All right, good deal. Thank you.
I got it. Thank you.
Clock is ticking. I was just noticing
Yeah, the
that
country,
myself.
even the world watching as Charlie Kirk's accused assassin made its first in-person court appearance today.
Is this another segment from our body language expert?
Yes.
Where he talks about he didn't see any grief muscle?
Yes. So
what is a
apparently,
grief muscle?
do I know what a grief muscle is? I don't know. So apparently the grief muscle wasn't functioning properly to imply grief by looking at the clip.
And that was the focus of the coverage. It wasn't who got appointed, who the lawyers are, what the next procedural step is, whether he was showing a grief muscle.
Right. So again, we're just back to this conjecture of, well, nothing interesting happened in this hearing, so let's find something interesting to talk about. And it's staring at the defendant and making an assessment of what he's thinking or whether he has grief for what he did based off of his grief muscle, whether it was, I don't know if it was not doing the right thing. I don't know.
Okay. Was there also in this hearing sort of a focus on what a high level of security was necessary to manage Mr. Robinson?
Yes.
And the local KT.
New video showing what we believe is Tyler Robinson's police escort leaving the courthouse in Provo just in the last hour. Robinson accused of murdering Charlie Kirk during an appearance at Utah Valley University back in September. Thanks.
And what kind of message is that sending to prospective jurors?
Well, I think in a case like this, like I could see it creates anxiety among prospective jurors. Like this is dangerous potentially. Like there's always pressure, on a high profile case in terms of juror serving, and then adding cameras to the courtroom, risk of somebody being disclosed as who they are. And then you have, news stories about SWAT teams and all these things just to kind of at the courthouse.
And how about the inference here that Mr. Robinson has to be transported in a SWAT vehicle?
Sure. I mean,
in terms of his dangerousness.
I think it's just the nature of this case, the danger of it.
Okay. We're going to skip that. And I want to ask you, did the court coverage then cause responses that sort of are connected with the court appearance? And in this case, you have the court appearance on the 11th. Mm-hmm. And then 2 days after, is there sort of a responsive appearance by Mrs. Kirk to the events that happen in court regarding whether the defendant should have discovery or not?
Right. Yeah.
So was this coverage on December 13th a nationally televised town hall?
It is on CBS.
Let me play you just a little segment of that. And I have a question.
What is going on? Why are there so many conspiracies spreading about what seems to be a pretty open and shut case?
This is the first time that we have seen evil on display where we have social media at our fingertips. Something so evil that happened, people are wanting answers immediately. They are wanting to figure out how to wrap their mind around this.
Yeah.
Egyptian planes.
Egyptian
Egyptian
do you
planes.
believe that Tyler Robinson murdered your husband?
Yes, I do.
Why do you think it is so hard for so many people to believe that reality?
Because it's too simple. Again, everyone always has. I've been in constant contact with our lawyers, the process team. I've seen it all. And let me tell you this, why in the world, why should we, prior to the trial, lay all of our hands and cards on the table for the defense team to see, to somehow then, I don't even know what they would do with it. But what I will say, and I want to get on the Egyptian plane thing, we'll take a flight on that for a second. What I will say is what I'm worried about, and I'm fascinated, just from a legal standpoint, to see how the United Healthcare trials pans out. And I say that because this is the first time where we are seeing the implications.
You're talking about Luigi Mangione.
Correct. I prefer never to say any of their names. They do not even deserve the ounce of oxygen and breath out of my body. But what I mean is it's fascinating to see how social media will impact that court case. Just how it might impact mine.
Are you nervous he's not going to get a fair trial?
I'm nervous that there could be, they'll say we can't find a fair jury. Like they're going to taint the jury pool. And in that case.
That's how widespread you think these conspiracies have gone?
Yes.
That's how mainstream they become. Okay.
Egyptian planes.
So one of your categories was inadmissible evidence, right? And I know you're not a lawyer, but you're generally familiar with, there are certain things in a penalty phase of a capital case that a victim impact witness can say and certain things they can't say, right?
Sure.
Like you can't express opinions about the defendant, as an example. Why is this sort of coverage prejudicial in relation to her commenting on court appearances and whether Mr. Robinson should have the benefit of discovery and her opinion about guilt and the narrator's opinion about the evidence being overwhelming?
Yeah, so I mean, I think there's a lot there. I think one, obviously, there's a lot of empathy for the victim's family, and I think that's very appropriate. So she's a credible source, I would say. I think it's not ideal to have a victim saying that due process shouldn't be complied with, the idea of discovery and why are we sharing, exchanging information, which is the way that due process works. And then the references, I've seen the evidence, I know, it's an open and shut case, essentially commenting that he's guilty and the evidence suggests that, would definitely be prejudicial and create a presumption of guilt among prospective jurors. So it's kind of like, a lot of that. I think the thing about the conspiracy theories, this is not the first time. I mean, if you look at like the DePape case when, David DePape attacked Paul Pelosi, trying to kidnap Nancy Pelosi, and Elon Musk was spreading rumors about his relationship with the victim and implying they had all that. So it's definitely not the first time. It's unfortunate it happens, but it happens a lot.
Okay. Now you have many more examples in these clips of similar things.
Yes.
Like the basic point being, we're not getting information about the court proceedings, educating the public about how the law works, but we're getting a lot of opinions going to the issue of whether Mr. Robinson is guilty or not.
Yeah, and I'm not saying this was triggered by the court hearing. I mean, I get it was in the sense that she's commenting on what happened.
So it has nothing to do with the live stream.
So I want to talk to you about and we're going to skip the other examples because we're running out of time here.
Yeah, you got 35 minutes left for your
let's
entire
talk about
argument.
Your survey.
Okay.
So walk us through that. First of all, what was the methodology of the survey?
Sure. So again, this isn't a change of venue survey, but it follows the standard practices put forth in the ASTC, American Society of Trial Consultant Professional Standards. So we're using a random digit dial technique. Everybody has a known chance of being selected. So it's not a text message sampling approach or email or anything like that. It's phone calls, cell primarily.
This is its focus exclusively on Utah County.
Yes, they have to be jury eligible. So they have to either be registered to vote in Utah County or have a driver's license with a Utah County address on it to be included. And then the survey is designed for initially you're just capturing general impressions of the criminal justice system to get people familiar with the study. And then we're going for this one, it's case awareness, like we would do typically, case recognition, prejudgment, just to get a feel of what's the baseline, where we at today in terms of that question, a fixed opinion question. I call it like a presumption of guilt question. Would the defendant have a difficult time convincing you that he's not guilty? So it puts the burden of proof on the defendant. And then where their source of information is, like is it getting it from local news, social media, national news, things like that. And then a couple basic recognition items, how they watch streaming, which was probably, if I did another survey, I probably wouldn't ask it that way, because I think based on what we saw, like people aren't per se seeing streaming of the hearings. It's the commentary and post hearing stuff that's really coming out from that. Whether they knew about a confession, I think it's probably better text messages, because that's primarily what I'm talking about, and a few other things. So
what were the key findings of the survey?
Yeah, so high level, so the recognition rate is pretty much everyone, 99%. This is based off a sample size. It's a smaller sample. Again, this is just a snapshot of 200, not the typical 400 that we would do like in a change of venue survey. And then guilt was high. So 64% believe that he's guilty of murder based off of what they've read, seen, or heard about the case.
That's not that
only
high.
People that answer that question are those who know about the case.
Over
the
hella
three
higher.
people that didn't know about it didn't answer that. Only 7% reported that he's not guilty. That fixed opinion question, you can see over 50% already believe that the defendant would have a difficult time convincing them that he's not guilty. And 35% believe he should be sentenced to death at this point. And 65% have a somewhat or very negative opinion of the defendant, which fits into all that negative character evidence that we just walked through for the last.
So based on the results of this, would you conclude that there's been so much publicity in this case that it doesn't matter whether we get any more, because the jury is already, or the jury pool has already been so tainted that adding more to it is really not going to change the equation?
So the idea is Utah County is so saturated that you can't get a fair trial here. So just
right.
play
At this
more
point,
coverage?
it's so saturated, the court should do nothing to try and control the publicity, and because it's basically a done deal.
Well, a couple things. One, there's also a lot of media coverage coming out of this in Salt Lake City, which would be the largest county, which is where you would typically move it to. So then what you're saying is, well, there's so much coverage here. Let's just have a free flow of sensational, prejudicial media coverage. And then down the line, when it's time for a change of venue, you can say, well, there's nowhere to move it because Salt Lake City's just as bad. So I guess you're sorry. So there's that as my first reaction to it. And then I think, look, this is the baseline of where we're at. So you still have, like for the death penalty question, it's only 35%. You're not seeing above that 50% mark yet. We don't know, a lot of it, a big one is case knowledge. So you might find that recognition rates are high here, and I'm sure they're high in Salt Lake City and everywhere else. But it doesn't mean people identify with the case, went to the university, have personal connections, know all the case specific facts. We don't know any of that yet.
So in your survey, only 35% of those polled indicated that Tyler Robinson should be sentenced to death if he's convicted?
At this point, yes.
And in terms of whether
That's
he was
low.
guilty or
I'm
not,
here to
you've
tell
got
That's low.
64%.
Right.
Okay. What else about the survey?
So as you'd expect, people are following the case. So people are following it somewhat or very closely. Sometimes in big counties, those numbers are lower because you'd expect in big counties there's so much else going on that it takes a lot for a case to capture people's attention, unlike smaller communities where they're shocked and they follow it very closely. Kind of back to the Koberger case in Idaho. And then you can see everyone's talking about it. So 96% reported that they are talking about the case or they've heard others talking about it in person or online, which also suggests that the big county is taking on characteristics of a smaller community. And you, in terms of source, so 53% are getting the news about this case from social media, and we kind of skip that, but there's a lot of sensational stuff that's being created and clips and reels and inflammatory comments and screen captures from these hearings with comments on them as well. And then people have seen something on social media about this case, 69%. And then they've seen something on YouTube, 34%. And then 45% have seen something about the case on local television as well.
Okay. What is this slideshow?
Yeah, so just high level, again, this case is capturing this community's attention. Despite the size of the county, 99% recognition rate. That's very, very, very high. I don't see that very often. And they're following it somewhat or very closely already, and nothing's really happened yet. We haven't had a preliminary hearing. We haven't had the big things happen. We've had pretty procedural-esque hearings about, counsel in terms of gag orders and things like that, and they're already following it closely before the really sensational stuff starts coming out.
Okay. I think this is summary of what you've already said, correct?
Yeah.
So you mentioned this before, but in terms of where people are getting their information from, are they picking this case up from watching live stream or through other sources?
They are not. So if you go back to the prior slide, which is from the survey, this is specifically about the case. They're picking it up from social media, local television. Those are the big ones. They're not watching live streams. I think it was like 25% said they've seen like a clip or part of a live stream, but they're seeing news footage on local TV, which we already went through, that has prejudicial commentary about these hearings, whether it's the body language expert or the lip reader or any of this stuff. All that stuff is coming out in those sources, and that's what they're saying.
Okay, I'm afraid I'm going to have to stop here. I hate to do it, but I have to. So.
Very simple from the prosecution. So none of this is about the live stream itself. The problems are with the secondary processing of it, and that's going to happen with anything that happens in court, whether it's live streamed or not. That's the bottom line. Oh, I had high hopes.
Good afternoon, Dr. Edleman.
Good afternoon.
You mentioned that in your employment, you work as a trial consultant.
I do.
And with respect to that, it's more of an advocacy-related position.
When I'm wearing that hat, yes.
When you're wearing that hat. And this hat, you're more of an objective witness.
Absolutely.
Correct? We've talked a lot about today, you've talked a lot about today, we've seen some slides about the negative pretrial publicity towards the defendant. Mm-hmm. Did you research negative pretrial publicity towards Charlie Kirk?
I'm familiar with it. Yes.
Did you research it as part of this assignment?
No.
This employee. Did you do any research with respect to negative pretrial publicity towards Erika Kirk?
Towards who?
Erika Kirk.
I did not.
Are you aware of the negative publicity that's out there?
I'm aware of the awful conspiracy theory stuff.
Okay. What about, did you research negative trial publicity towards the prosecution's case?
I've seen what that stuff is, and most of it is not from what would be considered mainstream sources. You're talking about people who support conspiracies all the time about windmills killing whales, and that Winston Churchill was the true villain in World War II. So I don't put much stock in that kind of stuff. I know it's out there. I don't think it's comparable.
Okay. What about pretrial publicity, positive pretrial publicity towards Mr. Robinson? Did you look into that?
No, and I don't think there's much of that.
But you didn't specifically look into it?
No, and there's social science literature on that positive pretrial publicity does not mitigate or eliminate the effects of negative pretrial publicity.
Are you familiar with Professor Christine Ruva?
That's her research?
Her research?
Yeah.
Because she would say otherwise, wouldn't she? That positive pretrial publicity towards a defendant would tend to mitigate.
Positive mitigates? You're saying she says that?
Sure. That positive pretrial publicity towards a defendant would tend to mitigate guilty verdicts.
There is very little pretrial publicity that tends to be positive, and from my experience and what I've seen, no, it does not. You have a mountain of negative pretrial publicity, and you might have 3 stories that are positive. That does not mitigate a mountain of negative pretrial publicity.
Okay. But it would depend on what that juror was exposed to, correct?
what he or she paid attention
most
to.
of the pretrial publicity in cases like this is negative. So if you're implying that it's balanced, I would say absolutely not.
Okay. In your survey, I'm going to turn to a few of these questions. I believe it's number 2 in the binder there that you have.
Yeah.
Contradicting the defense's other expert is really classic.
The question was asked on question 6A, if you want to go to that question.
Give me 1 second here. Which tab is it? Sorry.
I think if you go to number 2, tab number 2.
Okay, got it. Which question?
6A.
6A. What 3 words best describe Charlie Kirk?
Yes. You identified, there were a number in your survey, correct?
I think that's fair.
For example, multiple people referred to him as a racist, correct?
Okay.
This is your survey.
Yeah. Again, the question above that is 64% or so have positive opinions of Charlie Kirk. So you can cherry pick comments in there, but in general, overall, people have positive opinions of him in this community.
But there are people within this community that have a negative attitude towards Charlie Kirk.
Yes, I'm sure, and nationally.
Okay. He was called inflammatory in your survey, correct?
Inflammatory?
Uh-huh.
Which comment? Oh, that's what someone said?
Yes.
Okay.
As a misogynist.
I'm not disagreeing with you. You could cherry pick as many as you'd like.
Asshole.
Well, let's talk about the cherry picking. Vis-a-vis
Harmful.
the press you looked at.
Did people respond like as if he were that he's a bully? Did you see that? A bigot.
Okay.
Homophobe or homophobic. Multiple people put that.
Okay.
Divisive. Prejudice. Sure. Evil.
Guys, don't fuck with
On the other
Grunander.
hand,
It doesn't come to play.
you asked what 3 words best describe Tyler Robinson, correct? And that was question 5A.
Yes.
And isn't it true that a number of people responded with not guilty or innocent until proven guilty?
Sure.
Okay. We would
Wait,
like
his
people to
voice
respond
breaks
that way, correct?
when he knows.
I what?
You would
he's
like
getting
someone
hit.
to respond that way.
They can say whatever they want. Again, this isn't a change of venue survey. This is just measuring awareness of the case and where we're at today.
Okay.
So why'd you do it? It's meaningless.
Multiple
then?
people responded with respect to what 3 words best describe Mr. Robinson as scapegoat, correct?
Multiple out of the 200. How many you got there that say that?
More than one.
More than one?
At least more than one.
I can see plenty of confused, radical, guilty, mentally incompetent, messed up person, lost, confused soul, very confused. I mean, I'm sure there's a array of many different things in there, from mental illness to evil to...
Let me take you to page 21.
Page 21?
Survey, correct.
Next to, okay.
Do you see scapegoat about maybe a quarter of the way down or so?
I see piece of shit, sad, so bad, selfish, guilty, suspicious, troubled.
What about scapegoat? Do you see scapegoat?
I do.
Okay. A few lines down, maybe 10 lines down, do you see scapegoat, victim?
Scapegoat, victim. Okay.
Okay. That would imply that some of these conspiracy theories out there are taking hold of people within this community, correct?
Among the friends, I'm sure there's people that believe that. I never said there weren't, but I don't think that outweighs the majority of people who think he's guilty and all the other awful things. And remember, Charlie Kirk is not the one on trial in this case. It's not going to be about whether Charlie Kirk is guilty or whether he should be, what that punishment should be. It's about the defendant. So in the majority of opinions towards Charlie Kirk in this community are positive.
If
So
you don't
there are
think
people that have
it
negative.
coming is always
Would you agree
implied.
that negative publicity towards a victim has an impact on prospective jurors?
Not in the guilt phase, maybe in the sentencing phase.
Not in a guilt phase.
Not in the guilt phase. I don't think that whether or not they have a positive opinion of the victim implies whether or not the defendant is guilty.
I mean a negative opinion towards the victim.
Towards the victim?
Yes. Does a negative opinion towards the victim
does that mean
play into the mind of prospective jurors when they come in?
So if someone thinks that Charlie Kirk was a divisive figure because of what he said publicly, that the defendant's not guilty?
Yes.
Sure. Well, could that have an effect on the verdict?
I don't think it will in this, no.
Okay. What does the literature say?
I don't know of any literature that would fit that scenario.
Okay. Question 6B asked about whether someone has what's your opinion of Charlie Kirk? Two of the potential responses was somewhat negative and a negative opinion.
Right.
25% of the people in our community in this snapshot have a negative opinion towards Charlie Kirk, correct?
63% negative, 25%, or I'm sorry, 63% positive, 25% negative.
So 25% negative. Thank you.
1 in 4 people don't like Charlie Kirk.
And just clear, I'm not saying change of venue.
Objection. It's non-responsive.
Doctor, this is not where you get to make statements. You can respond to questions, and that's something we do to make sure it's balanced. So I'll ask you to respectfully do that.
You think you're talking to?
Now, question 2A reads the following. Now, I'd like to ask you about an upcoming jury trial in your community. Back in 2025, Charlie Kirk was shot and killed during an event at Utah Valley University in Orem. Tyler Robinson was later arrested and charged with intentional first-degree murder. Have you read, seen, or heard anything about this case?
Yes.
You asked that question.
Yep.
And that's where 99% of the people, there's case awareness, 99%, right?
So did you?
But
did
that
you know
question
Charlie
doesn't
Kirk
really
got
help
killed?
us with respect to can Tyler Robinson get a fair trial in this community, correct? Case awareness?
I didn't ask that question. That's not the purpose of the question. The purpose of the question is to identify what the recognition rate is, how many people are familiar with the case.
Okay.
That's the purpose of that question.
Okay. So it doesn't relate to whether or not he can get a fair trial. People's awareness of it.
Don't think I said that.
Okay, fairness. That's fair.
Thank you for clarifying that point, sir. There's nothing to do with them getting a fair trial.
Dr. Edleman, what is your understanding of the purpose of this hearing, of the motion in question here today?
To the question being towards whether or not there should be television cameras in the courtroom.
And why does it matter if there are televisions in the courtroom where there's pretrial publicity?
Because it creates sensational, misleading media coverage that undermines the defendant's fair trial rights.
Fair trial rights?
Yes.
Okay, because of the media coverage. That's why we're here. And isn't it about impaneling a jury that could sit in judgment on Mr. Robinson? Isn't that the ultimate question we're trying to get to?
The ultimate question is, can he have a jury who has not been prejudiced and comes in with preconceived notions of his guilt that don't have case-specific knowledge, that as the trial goes on is stimulated and activated by hearing new information. There's a difference between a jury that in a community that doesn't know the evidence and hears it for the first time and maybe convicts a defendant, and a jury that comes into a courtroom somewhere else and all the information confirms what they already know and they convict the defendant. The outcome's the same, the process is very different, and that's the problem.
Okay, so it comes down to, can he get a fair trial with a jury here in Utah County?
In Utah County? Again, I'm going to keep saying this. This is not a change of venue survey. I didn't recommend for a change of venue. My limited purpose was to assess where people are getting information about this case. Are they following it closely? What sources are getting it from? And are they developing negative impressions and a presumption of guilt? And this stuff here we're talking about, this data are the baseline, and the questions are going to get worse, or it's going to stay here.
But we end up at the same point. Can we seat a jury to sit in judgment on Mr. Robinson? Can he get a fair trial?
Not based on this. Maybe that comes down later after, when we're closer to that. The question that this survey was designed to measure is, where are people getting the source of their information? Are they seeing prejudicial pretrial publicity? Are they following it closely? And what impact it's had so far? And what's the baseline? So leave cameras in the courtroom, and then you get more of the stuff we just walked through. And then the preliminary hearing comes out, and then witnesses testify, and all of that prejudicial stuff comes out. And then there's more negative pretrial publicity. And now we're back here in 6 months or a year, whatever it is. And we are talking about change of venue because everybody in this community has been saturated. And the numbers you see in the survey, like guilt is now 70-80%, and prejudgment on sentence is over 50%. And everybody knows prejudicial details. That's what we're trying to avoid.
Fair enough. But the ultimate risk that we're getting to is whether or not we can seat a jury here. That's why we're asking these questions about what are the effects of cameras in the courtroom.
Correct? I disagree with that. I think you can always find 12 people in any venue to raise their hand and say, yes, I could be fair and impartial. If you look at Rideau v. Louisiana, it was the most prejudicial confession the Supreme Court could imagine. It was recorded in the sheriff's office, put on TV, and all those jurors, 12 of the jurors, all of them said they could be fair and impartial. 3 of them had seen that confession, and the Supreme Court said no. So just getting people to say they could be fair and impartial, I see it all the time. I do it as an advocate when I do jury selection. It's a common thing. It's easy to get people to say, I can set it aside. That doesn't mean they can, and there's no evidence in the social science literature that supports that they can, particularly when they have case-specific knowledge. But you can definitely explain to them the law requires you to be fair. Can you set it aside? Yes. So yes, you can find 12 people here or anywhere else to do that.
Thank you.
He's picking a fight that he
question 3AI. If you could take a look at that.
Sure.
This is the question about, you referred to this earlier on direct. Given what you have read, seen, or heard about this case, would Tyler Robinson have a difficult time convincing you that he is not guilty of intentional first-degree murder? You asked that question, correct?
Right. So it's based on what, yes.
Now, you would acknowledge that this question shifts the burden to Mr. Robinson, that he has to prove his innocence.
Oh, I'm sorry. Which one? Oh, you're talking about, yes, I'm sorry, 3AI. Yes. So that is a question that a judge in Tennessee came up with. Yes. And it was a measure because people would say they could be fair and impartial in the jury selection. They expressed bias and said they could be fair. And then he said, well, could you put the media out of your mind, or would the defendant have to prove that he's innocent? They go, oh yeah, he couldn't change my mind. But yes, so it was an inconsistent answer. I thought it was an interesting question, and it correlates better with other variables in surveys than can you be fair and impartial. So I use.
But it does shift the burden.
Well, for the jurors, they think it shifts the burden. It's not telling them the burden is shifting. I don't think the question shifts the burden. I think the question is, would people already hold the defendant to that burden?
What is the matter with you? You explained this.
And it's your experience that question was asked in Tennessee?
That question correlates with things like case knowledge, strength of opinion, and all these factors that you would expect the question to correlate with if it's a valid, reliable question. In contrast to, can you be fair and impartial, does not correlate with any of those things. So people with a lot of case knowledge are just as likely they could be fair and impartial as people who don't know anything about the case. So that would be considered a questionable, like the validity of that question is problematic.
Okay. I'll take you to question 7A.
7. Yes.
The prosecution is seeking the death penalty for Tyler Robinson. If Tyler Robinson is found guilty of first-degree intentional murder, which sentence do you believe he should receive, the death penalty or life without the possibility of parole? Are you familiar that before, if Tyler Robinson is found guilty of aggravated murder, which is the actual name of the charge here,
sure,
it would then go to a sentencing phase.
Right.
On a question of death, correct? And you're familiar that that the jury would be instructed that they would be required to weigh both mitigating and aggravating circumstances.
Is this a weighing state? So it's weighing the two? Okay.
Before deciding on the question of death or life without possibility of parole, correct? Is there a reason why you left that fact out, that the jury would be told that they would have to weigh mitigating and aggravating circumstances.
Yeah, so again, this is a snapshot. This is not, it's, for example, I wouldn't read an instruction in a survey about the presumption of innocence, and there's like, if you look at the ASTC standards, you're not supposed to do that. This is where people are at today. It's a snapshot of their bias. It's not, oh, I think you should get the death penalty, but you now explain the entire system to me, so I've changed my mind. I don't think you should get the death penalty. So
well, isn't it true that if you were to explain to them that there's mitigating and aggravating factors to be weighed, that the number of people who would support the death penalty that would respond yes on this question would go down?
Why do you say that?
Because you have explained further process.
So explaining the process means that they change their opinion? Do I then have to?
If they were instructed in this question that they are to weigh mitigating and aggravating circumstances before coming to a conclusion,
the question
wouldn't that tend to depress the number of people voting for death penalty in this snapshot?
I think you'd get invalid data potentially. First of all, you'd then have to explain how to do that. You'd have to explain, well, they don't know what the mitigators are. Then you'd have to ask like death qualification questions. Well, I think I could consider mitigation. Okay, under what circumstances? Oh, if it's self-defense. Okay, well, now let me ask you another question. What about a case of intentional first-degree murder? Could you consider life then? But well, no, now I can't. So all of that stuff you'd have to include, which creates complexity, and that's not the purpose of this survey. This is not jury selection. Survey is not designed to be jury selection. It's not designed to be death qualification. It's where are people at today? And people have opinions, and that's what this is capturing. This person has an opinion that he should get a life sentence. This person has an opinion that he should get a death sentence. That's based on what they've read, seen, or heard about the case. That's what I'm measuring.
Understood. But important critical details are being left out before someone would be charged with making that decision, death or life without the possibility of parole, correct?
I mean, that again, if this was a change of venue survey, maybe I would say like, here's an important mitigator that's coming out. And then when the juror says like, I think you should get a life or death sentence, ask a question about a mitigating factor and see if they could consider that or if they could weigh that. But that's not the purpose of the survey. And maybe if it comes to that, those are things that you would typically put in those kinds of surveys. But that's not the purpose of this.
Are you familiar that in the state of Utah, if someone is convicted of aggravated murder, that there is certainly the possibility of death, life without the possibility of parole, but also 25 years to life with the possibility of parole? Are you aware of that third option?
I wasn't, but sure. Okay.
Should you have put that, had you been aware of it, in your questionnaire, in your survey?
I mean, I think most people would be, from my experience of doing these and getting, the bigger thing is people are fearful that life without the possibility of parole is not actually life. And they're worried that that person will get out. So giving them an option to have a shorter sentence, I don't think is going to reduce death penalty numbers. It might take the life without the possibility of parole, and some of those people might say life for 25 years, but I don't think someone with death is going to say, no, I think I would just give them life, 25 years.
Okay, but it's another option that it probably should have been included.
You can, sure. I don't know if I would, knowing it. I still, maybe I would just say life or life without possibility of parole, or perhaps.
Okay. So you've talked about how surveys like yours, they're snapshots in time, right? And surveys can't predict future conduct. Is that fair?
Well, I mean, it depends on the survey. Like some surveys may, like if you ask people about if they're going to vote in the next election, and there's data there, it could predict whether they're going to vote or not, or something like that. It just depends.
Okay. But you would acknowledge that your survey here, it's a snapshot of people's awareness and feelings in the community today.
Yes.
It doesn't represent real world experience of what a juror would experience if they were summoned to jury and selected to be part of this jury.
So does this survey capture how a juror will react as a juror?
If they were to hear the evidence in a court of law.
No, I mean, I think I would think of this more as a snapshot of the community, and then what the social science literature tells us. So we know, for example, people who have a lot of case knowledge are much more likely to convict and process information to be consistent with how they see the world. So if they already think he's guilty and they already know all the evidence, they're more likely to interpret the evidence in a manner to support that position. So we do know that. So you can kind of look at extrapolate from the survey data
Definitely
in
know
that manner,
that.
but it's not designed to predict, okay, this means these 12 jurors will disregard the evidence and acquit him or convict him or anything like that. That's not the purpose of the survey.
So the purpose is quite limited in reality.
I don't think so at all. That's your opinion, I guess. I'm sorry.
But it doesn't predict future behavior.
The survey is designed to see where people are at today and make an assessment of whether or not cameras should be in the courtroom or not. And you're talking about like a change of venue survey and whether jurors will be fair and impartial in a year from now or what have you. I don't quite get the connection of how that question is tied to whether there should be cameras filming things and then making speculative conjecture about whether someone's grief muscle is flexing in the right way.
So let me ask a question. I've asked this various ways. What's the risk of cameras being in the courtroom if it doesn't ultimately turn on seating a fair and impartial jury to sit in judgment on Mr. Robinson?
Yeah, that's the point.
So what is the risk of inundating the jury pool with highly prejudicial, sensational media coverage that characterizes the defendant as guilty, a monster, a psychopath, a sociopath, and so on? What's the risk of that? I think it undermines that juror's fair trial rights. And I think there's plenty of case law where even when juries have been sat and they've served and there's been a conviction, those have been overturned based off of the pretrial publicity. So obviously there were 12 people in that trial that went through jury selection, were determined that they could be fair and impartial, were able to listen to the evidence and reach a decision, and then state Supreme Courts, United States Supreme Courts have thrown those convictions out based on prejudicial media coverage. So clearly there is an issue, and the question isn't, can you find 12 people somewhere in the county that will raise their hand and say, I can be fair and impartial? I don't think that's the standard.
Awfully defensive about that question.
You mentioned that these were randomly selected respondents. Digit dial, I believe you said. Did you add any numbers to your survey? Were these all truly randomly selected?
I'm sorry, adding numbers.
Did you add any numbers to be called as part of your survey?
Be called?
Yes.
So the survey vendor deals with the sampling. So I give them the county, and then they buy random sample. And then what they do is, so it's called replicates. So let's say they buy X thousand phone numbers, and they have to work maybe like 100 numbers, and they have to call each one like 3 times, different times a day, and all that stuff until they can reach a resolution like, no one ever answered, or it's a bad number, and then they have to open up other replicates.
Okay. Did you, as part of your survey, did you ask whether the respondents had any involvement with this case?
Involved in the case? I did.
Like media, law enforcement, anything like that?
No.
Okay. Did you ask whether they had a relationship with anyone that was involved in this case?
No.
The respondents?
No.
Okay. What screening procedures did you take?
I'm sorry?
What screening procedures did you take?
So the screening procedure is based off of age, right? They have to be over 18 years of age. They have to be able to speak and read English. They can't have a felony. They have to be a citizen of the United States. They have to be registered to vote or have a driver's license with the county address on it.
Okay, thank you. A few more questions about your survey questions. In question 8A, will you turn to that?
8A, yes.
You asked, have you read, seen, or heard of President Donald Trump expressed an opinion about whether Tyler Robinson should receive the death penalty or a life sentence without the possibility of parole?
Yes.
Killing Charlie Kirk. 81% responded no, correct?
To that one, yeah.
Okay. Question 9, you asked, have you read, seen, or heard of any other public officials have said that Tyler Robinson should receive the death penalty for killing Charlie Kirk, correct? And 65% responded no. Is that correct?
32% yes, 65% no.
Okay. Question 10A reads, have you read, seen, or heard of Tyler Robinson confessed to shooting Charlie Kirk? 56 responded no, correct?
Yeah, and I think that's a poorly written question because I think the bigger question is more about text messages than when I wrote it, I hadn't seen all the media coverage yet, and I think confession usually is like the person verbally confess, and this is more about text messages. So if we do another survey, I would probably change that, the way that question's phrased.
Question 10B. Have you read, seen, or heard if Tyler Robinson's DNA was found at the scene of the crime? 65% responded no. Correct?
Yeah. I mean, I think your point is great in that we're not at a point where everybody knows all these prejudicial details, and we haven't started yet. These are the numbers, the baseline, and the idea is to prevent these numbers from going up. I think that's ideal for you and the defense and everyone, is for jurors to be not aware of all the details and facts, and that they base their decision on the evidence, not what they've heard in the media. So having low numbers on these things is a good thing.
Okay. The media that we watched on your direct examination, almost none of it was live streaming from the court proceedings, correct?
Correct.
It was third parties' commentary on the case. Correct.
Which is what worries me, not the live stream where very few people are watching.
Sure. But that's correct,
Why
right?
are we here?
We were watching commentary on the courtroom proceedings.
Right. So they're taking video from the courtroom or images and then telling the story of what happened at that courtroom proceeding using the images or the lip reader to tell you what the defendant said or his body language based on his movements and all those things. Yeah. So that's what worries me. It's not a neutral, sterile, here's the live stream, no commentary. Come here if you want to see what's happening and take away. So you're educating the public. Here's an opportunity to create sensational media coverage.
And we won't have the facts to correct them.
For the person who wants to actually get accurate information, what's happening in the court, where is the best place for them to go?
I mean, to me, it's like we got accurate information for decades without live streaming. They're called journalists, and they would come and they would write stories, and we'd read about them and hear what happened. We don't need to create a circus-like atmosphere or reality show out of a trial.
What's the primary source that they would go to for accurate? To accurately see what's happening in the court, where would they go?
For who? What are you asking?
For the average citizen who wants to follow the case.
Well, I mean, that's complicated. So like a lot of people get their news on social media, right? Or podcasts, but that social media is also sharing information and content from traditional networks that now have to create more sensational content instead of maybe more quality content, because you have to get clicks and based on an algorithm that's like focused on sensationalism and reactions. So you're trying to create content to get attention there. So,
but that person that wanted the most accurate depiction of what's going on in court would be to come to court, correct?
To come to court? That would be great.
And watch the proceedings.
I guess. Sure. Yeah.
Well, that's where it's happening, correct? Yeah. And short of that, a live stream would also provide that if someone tunes into the live stream.
If it was live stream with nothing else, because you basically have about 25% or so or less watching the live stream. So, and the other interesting thing, if you look at the live stream, it's a forum. All these people are coming to it and just spreading misinformation and conjecture about conspiracy theories and you should get the firing squad and all these things.
And those are third parties that this court can't control, correct?
Mm-hmm.
That's on the live stream. That's not on third parties. That's just if you looked at I think it was like Court TV, just a live stream of it, and you watch waiting for the stream to start or during it. It's just a forum of just spreading information that is not
guys, we're talking about you.
I'm sure we'd all agree if you looked at it, it's not accurate. But again, it's not like the majority of people are coming. If you balance it and you said, okay, well, 80% of the people are getting their information from the live stream. That's great. And very few people are watching all the sensational stuff. So the costs outweigh the benefits. But that's just not the reality. The reality is most of it is sensational media coverage that's being created from the live stream video. And then you get what we saw. It's not like people are coming to the courtroom or watching neutral live stream and then, wow, I learned so much about the courtroom process today. That's just not what's happening.
But it's not the live stream video that's causing this content by third parties.
Well, how
we're pushing it out, correct?
How would the content exist otherwise? The video of it. That is the source of the information.
The whole point is they didn't even show
take the live stream video,
too much.
And then rather than reporting on what happened, we'll say all this evidence was introduced in the hearing today, which is false. It wasn't. And it creates the impression that there's all of this prejudicial evidence, which is not evidence, and no one's ruled on any of that stuff in these hearings when that's not what's happening. So people are being misled. They're not being given accurate information.
Okay, but that's created by third parties, not this camera that is behind me live streaming this proceeding today, correct?
I guess. I mean, I don't really get the point.
What do you mean you guess?
I don't quite understand the point. So you're saying, yes, there's all this prejudicial stuff is coming from the live stream and it's creating all this prejudicial media content, but it's not from the live stream. It's not that guy over there.
A third party is taking the live stream, which is the accurate recording of what's happening today. And then they're taking that and creating something of it, correct?
So they're taking accurate information and then distributing widely misinformation. So a small percentage.
That's what you're suggesting.
That's okay. I mean, yes, I think if you just watched the live stream and there was no commentary on it, and in a perfect world, none of those things happen, then yes, but that's not the world we live in. And if you say there's no limit on the third parties using it, then that kind of defeats the purpose of the idea of just having a neutral live stream.
Okay. And to your question, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on court TV, YouTube, or social media? 74% of the people responded no.
Well, that's my point, is they're not watching the live stream. They're watching the news reporting on the live stream, like on TV, like all the stuff we just walked through.
Exactly.
That's the stuff they're seeing about what's happening. They're not watching the neutral live stream. They're not just saying, here's this sterile live stream of what happened today. They're watching this stuff. That's the stuff they're seeing.
Okay. But again, it's not the live stream that's creating that negative content.
He knows. That's the
I
problem
feel like I'm
with
just
the
going to keep
argument.
saying the same thing. So, okay.
Yeah. Okay, just one moment, Your Honor.
He knows that's why he's so freaking defensive. He knows exactly what the
Nothing more from
limitation of
state
your
judge.
argument is. You're complaining about third-party commentary, not the live stream.
No further questions, Your Honor.
All right, will this witness be excused?
Yes.
All right, thank you, doctor.
I'm all done. Thank you.
The judge was
You want me
not
to leave this, sir?
impressed with you,
Yes,
dude.
please. Judge, in terms of a time allotment, I have discussed with the state that they are not going to take their 2 hours. So I don't know how that
So you want it.
would affect my time limits, if at all. But I just wanted to let the court know that. I think their witness is going to be very brief.
All right, I see. Well, to the parties, what are the thoughts so you were intending to call the other doctor as your other witness?
Yeah.
Exhibits have been submitted. I believe that the doctor's, she had a 36-page report in your original motion. Is that correct?
That's right.
All right. Well, I want to provide both parties the equal amount of time. So what I'm proposing is that we turn to the state to their presentation of evidence, and if there is time remaining, returning to defense to call the witness as well, and see what time we have and take it from there.
I still think I have some time left on my 2 hours, or no?
Well, including cross-examination, we're about 5 minutes over.
Oh, okay.
But that's from my accounting of time. But we can proceed in that matter, returning to the state, allowing them to present evidence. And if there's time remaining, certainly we return to you.
Thank you.
All right. Thank you, Mr. Burt.
Oh,
the state.
man. Guess he's not going to take an afternoon break. He's just going to power through.
Your Honor, the state calls Cole Christensen.
All right. Mr. Christensen, if you'd like to come forward, be sworn in. All right, have a seat. Do we have a water bottle for him? There should be water bottles for all of our witnesses, so. Perfect, thank you. All right, sir, if you'd like to make yourself, situate yourself, and then after you're seated, pull the microphone close to you. We want to make sure that all audio is captured. All right, counsel.
If you could state your name and spell your last name for the record.
Cole Christensen, Christensen.
Where are you currently employed?
I'm currently employed with the Utah County Attorney's Office, Bureau of Investigation.
How long have you been employed with that office?
About 7 years.
Sorry, give me 1 second. Have you been specifically assigned to this case, the Tyler Robinson case, in your capacity with that office?
Yes, I have.
Were you asked to conduct research related to media coverage in the Tyler Robinson case?
Yes, I was.
And who made that request?
Prosecutors assigned to the case.
Did you complete that task?
Yes, I did.
Did you write a report about your findings?
I did.
Your Honor, permission to approach the witness?
You may.
And I can do what will mark as State's Exhibit 1.
Okay.
Do you recognize that?
Yes, I do.
What is that?
That's the report that I created from the assignment that I had.
Your Honor, pursuant to a stipulation by defense, the state would move to admit State's Exhibit 1.
Defense, that's my understanding. Is that correct?
That is correct.
Thank you. It is so admitted and may be published.
And we have nothing further.
All right.
Here's a report.
Mr. to defense.
You have your report there in front of you.
Yes, sir.
Part of your report says that you were trying to, your primary focus was identifying negative pretrial publicity toward the prosecution, right?
And
Erika Kirk and Charlie Kirk.
Correct.
And how did you define negative publicity toward the prosecution, Erika Kirk and Charlie Kirk?
How do I define that?
How did you define that when you were doing your search?
I just defined that by the media coverage that was out there.
Right, but how did you determine, well, this is negative or positive?
Based on the way the media slanted, or the way the article or the interview went.
How the interview went.
Uh-huh.
And what did you look at? Did you look at newspaper articles?
I looked at newspaper article, traditional media sources, local, national newspaper articles, social media, podcasts, online platforms, that type of thing.
Did you look at any of the coverage by the major networks, the electronic media coverage sites?
Yes.
And what did you look at in that regard?
What did I look at?
What did you look at?
I looked at, for one example, I looked at KUTV 2 News, I think is a CBS affiliate.
Mm-hmm.
I found negative pretrial publicity there toward the defendant.
Toward the defendant?
Correct.
And was that generally true of the other major electronic media outlets, that the focus was on negative publicity toward Mr. Robinson?
I'm sorry, I'm not sure I understand the question.
Was when you were looking at the electronic media coverage, and specifically the national network coverage, was the tone of that in general negative toward Mr. Robinson?
No, I think the tone of it went both ways. I think some of the tone of it was negative toward the prosecution, and some of it was negative toward the defense as well. Some of it was negative toward Erika Kirk, and some of it was negative toward Charlie Kirk.
Negative in the sense of making some derogatory comment about Charlie Kirk?
Correct. I did find that, yes, sir.
Okay. And did you do some sort of quantitative analysis in terms of how much there was in each category you were looking at?
No, I just took a sample size. So as far as, I could tell you there's a lot out there, but as far as like a comprehensive review or to quantify it, I didn't do that. I just took a sample size.
How big was your sample size?
Well, I looked at trending high-profile media articles, whether they be in social media or traditional media sources from when Mr. Kirk was shot and killed up until the present time.
You cite in your report a study that says that 86% of U.S. adults say they get their news from smartphones or computers, correct?
Correct, yes.
What was the source of that number?
Do you mind if I refer to my report?
Yeah, sure. I think it's on page 1.
And the question was?
Question was, do you cite in your report a source which indicates that 86% of U.S. adults get their news information primarily from smartphones or computers or tablets.
Yes. That's according to a study that was conducted by the Pew Research Center.
Okay. And is it true that a lot of the what you refer to as negative publicity toward the prosecution, I think you list on page 2, was coming from podcast sources? Candace Owens, for instance, you list?
Correct. That's one that I had found.
And high political figure statements in your report, what does that mean?
That would be, for example, some of the information we just heard, high profile political figures that can be national or local here.
Okay, Israel theories, what does that mean?
Correct. Theories such as Israel or Mossad was involved in the assassination of Charlie Kirk.
You saw a lot of that on the national media?
I did see some of that, yes.
And where did you see it, say, on ABC or CNN, where they were advocating that somehow Israel was...
No, I apologize. That was on social media.
Right. Most of the wackier theories are coming from fringe groups, right?
Correct. There are a lot of social media conspiracy theories out there.
And you were not making any attempt in your report here to compare how much weight someone would give to sort of a fringe report versus a national media report, correct?
No, I couldn't. I couldn't determine that.
Great. That's all I have. Thanks.
Thank you, Mr. Burt. To the state.
Nothing further.
Thank you. May this witness be excused.
Yes.
Thank you, sir. To the state.
Judge, for this hearing, this is all we had as far as state's evidence.
Right. Do you cede your time to defense?
Yes, so long as we are able to wrap this up today with argument as well.
All right. So just to provide some guidance, it is 3:20. We've been going on for about 2 hours and 20 minutes. We're going to take a brief 10-minute recess to allow people to stretch. And how we'll handle this is we'll return.
Will be 3:30.
So we'll start oral arguments at. So we'll come back at 3:30, and we will go till 4:10, and allow each side 15 minutes for closing arguments. And then I have some matters that I need to address with the parties as it relates to scheduling a ruling from the court. So we need to coordinate our schedules because we need to end at 5 o'clock. All right. We'll go ahead and be in recess until 3:30. Thank you.
All right.
The state gives not a single shit. They're like, sure, take the whole rest of the day. How well is it going for you so far? Oh my Lord. Well, this was quite a different presentation by old Dr. Edleman in the Kohberger case. And I mean, I have to say, I think it's because he knows perfectly well the weakness of the position that he's being asked to advocate for, and the ability of what he did to substantiate the position that his client wants. They didn't study the live stream. They studied secondary coverage, and that it's all of this is resting on his kind of implicit proposition here that without the live stream coverage, this would all be better. And there's just no basis to evaluate that at all. I'm kind of like, really, like, does he really think that if you don't have the court camera, that this secondary prejudicial publicity you're talking about isn't going to happen? No, it's going to be so much fucking worse, because instead what's going to happen is Scott Rouse is going to go to Provo for the hearing, and he's going to sit there in the courtroom and do the body language analysis from there. And none of us are going to have access to the live stream to be able to critique it and call it out as bullshit. That's what's going to happen without a court live stream. You will increase the levels of bullshit that people are going to have to sort through in order to understand what is going on in this case, in order to be able to call out, what's legit, what's fact, what's not. Oh, wow. So he did not present well. Just, forget the substance of what he's saying for a minute, but just demeanor wise, his first go-to was that dismissive, oh, sure. The voice cracking like, like major tell for, I don't like this question and I'm going to try to minimize the fact that I have to concede it. But I don't actually want to concede anything. And that became crystal clear as the examination continued. And he is being asked very reasonable, direct questions by Mr. Grunander that he's refusing to engage with. And he's talking around and he's turning the question into something it isn't. He's arguing with points that aren't being made. He's jumping ahead of the question. Like multiple times he started to try to answer before the question is even done. So you're not listening to listen. You've already gotten into your combat mode. You're just trying to get your licks in as soon as you can. And then, just kind of refusing to concede points that need to be conceded. The bottom line is it's about the ability to select a fair jury. He asked this very reasonable question many times. Yes, that was what you said on direct. The whole point was, and then we get to cross and you won't make that concession. You turn it into a question about whether we can find people who say they can be fair. That is not the question that you were asked. So just a lot of combativeness that was very unnecessary. And I think ultimately extremely unhelpful. And it made the point that Mr. Grunander was implicitly making the second he stepped up to that podium, and the very first thing he's asking him is, so what hat are you wearing? Your advocate hat or your expert hat? And it made it so clear. He's wearing his advocate hat. He's just trying to call himself, trying to call himself an objective expert. So I think all of that came through extremely loud and clear, and it does affect his credibility. I don't think there's really any question about it. I'm impressed with Grunander. I have been before, but I am today because it's just we don't often see the style of lawyering, which is really the best lawyering, where it's just about the information. It's not about can I trick you with something? Can I get you riled up? It's not about like he was the one who stayed very calm and reasonable throughout of all. He's the one that looked less like an advocate. Okay, when the lawyer looks less like an advocate than a witness, that's good lawyering. Okay, that's very good lawyering. It's just much more common to get, what I think is a little bit more of like the Kathy Nestor style, where you're like snide and you're smarmy, and there's just this whole approach to cross-examination that involves you must treat the other person as an enemy, and the best lawyers don't do that. The best lawyers treat everybody as their friend. And then you might even be able to capture some of them over to their side. Clearly not this guy. This guy is going to resist any reasonable outreach by the prosecution. But other witnesses will. If you're reasonable with them and you're not an asshole, they'll absolutely, concede good points to you. And that's where you are at the top levels as a lawyer. When you can turn their witnesses into your witnesses, you're really getting somewhere. So he's got that skill set. Grunander clearly demonstrated that skill set to me today. He's going to be a force to be reckoned with. He is going to make an extremely good impression on the jury, because he's going to come across as reasonable and fair. And that's just part of the battle of the credibility. He looks so much more reasonable and fair than Dr. Edleman, the ostensibly objective expert, did. It's just kind of wild. So, I mean, yeah, boy, that was a lot of wasted time dealing with not the court live stream, everything but the court live stream. And I mean, sure, they had some examples of, yes, more of the salacious, more of the, just attention grabbing type of coverage. But also a lot of it wasn't. A lot of it was like so extremely normal. The stuff like the first appearance. Okay, you got to remember the timeline here. The first appearance was what? 3 days after the shooting? 3 days. I forget off the top of my head now, but within days of the shooting happening at all, where there's been no information. There's just been this manhunt. Everybody is waiting to find out who did it and why. And then you have the charge and the charging document. And shortly on the heels of that, you have the first appearance. Of course, they're talking about the information. It is still extremely brand new and fresh. And that's what everybody has been waiting for. What Tyler Robinson looks like and what he's wearing to court and so forth are like so low on the priority of what people are interested in at that time in this event, that of course that's not the primary focus. They're gonna keep rehashing the new information because it's new and because that's what people want to hear. Oh man, I am kind of disappointed because I don't think this went where it should have. Maybe it's just not possible, but given what they're asking for, it's that the focus needed to be on the live stream and not the people talking about the live stream. But that seems to be all they have, and that just doesn't seem to me to be a valid argument to get rid of the live stream, because as he kind of ultimately had to extremely resentfully acknowledge, yeah, that's probably the best source of information for people who are interested in true facts about what's going on in court. That's going to be your best source. Watch the live stream, because you can't go to court yourself. Entire country can't go to court themselves and sit there in Provo. Courtroom wouldn't accommodate it. It's not realistic, from a cost standpoint, all that stuff. Of course not. So you watch the live stream. It's the best source for truthful, factual information. It's just that's such the bottom line that I don't know how they're going to get out of that. I really don't. And now with Ruva, their issue is just going to be, that from the defense, it's I think largely going to be more of the same. And then the prosecution has already highlighted what their approach is going to be with Dr. Ruva. Oh, by the way, you've got research that says if there's negative publicity about the prosecution or the case or the victim or whatever, that's going to mitigate any prejudice from negative publicity about the defendant. That's what they implied is in her research. And, shocked Mr. Edleman, Dr. Edleman, didn't realize he was contradicting the other state's expert. If they can back that up, they have her research to show her that happened, that she's said that, she's made that point. Then, I don't know. I don't know what we're going to accomplish here other than just banging the drum that there's a lot of attention about this case. Yeah. We know. We're well aware. None of it goes to the point of, why we should or should not be able to watch this process for ourselves with our own eyes as it unfolds in court. Absolutely wild. Guys, I'm going to go through some of the chats just because I've seen some that have come through that I think are potentially a little bit time sensitive. Scott doesn't want his own testimony broadcast after that line of questions. I wonder if he's going to like watch himself, ever go back and watch yourself. No, don't. I don't watch myself. I don't even like to like edit videos that I make and stuff because, isn't everybody like that? You hate the sound of your own voice. You're like, oh my God, I look like an idiot, all that. Nobody likes it. But then particularly when you're like, oh God, I bombed. Does he realize he bombed? And is he going to watch that back to realize how badly that went? Dr. Edleman, if you're watching, I just want to encourage you to, to level up with your testimony by not treating everything as an attack. You don't have to. You really don't. And that's what will separate the wheat from the chaff when it comes to, just like with the lawyers. The lawyers don't have to treat every opposing witness as if they are the devil incarnate. Okay, you do a lot better giving people the benefit of the doubt. Listen to their questions in good faith and concede reasonable points. You will look like a more reasonable person than you did in this hearing today. So just if you're watching, you might consider the possibility of that. Lisa Loney, isn't this hearsay? This is referring to the media coverage that we were listening to. And so 2 points. One, no, it isn't, because it's not being offered to prove the truth of what the media is saying. It's actually the opposite. They're offering it to show the effect it's going to have on the viewers, which is going to be to cause prejudice. So for that purpose, it's not going to count as hearsay. But even if it was hearsay, typically admissible in pretrial hearings like this. They don't have the same types of evidentiary rules that apply in this type of proceeding the same way that they do when you're at trial. So just that explanation. Oh, let's go back up to the top. See what we got. Scorpid Black Dragon listening to preview. I see the Delphi murders, Richard Allen trial as a counter argument to have cameras in the courtroom. Do you agree? 100 million%. If Deb V. Heard hadn't already gotten me into, on the position of we need cameras in the courtroom because the media can't be trusted to tell us truthfully about what's happening, completely inaccurately and without misrepresentation and skewing things to fit a narrative and so forth, then yeah, absolutely. Delphi would have gotten me there because just trying to experience that. And, there were no cameras in the courtroom at Delphi. So I was there and kind of wore the hat of the fact reporter, which is not my normal comfort zone. I like to watch the things and talk about what they mean. I'm not primarily looking to be the reporter of fact of what's happening. But following that trial kind of forced me into that role. And it's just, I'm so aware of, even as like careful as I'm trying to be and everything, you can't catch everything. And there's going to be things that you miss, and there's going to be things that you miss here, and there's going to be things that you can't see, and there's going to be things that you can't write fast enough to catch. And all of this is just dependent on, do you even know what you're listening to, right? This has been the problem with legal journalism for decades. This is why I started talking about cases, is because generally speaking, legacy media talking about cases, they don't know what the fuck they're looking at. They're not lawyers. They don't know what matters. They don't know the process. They don't know the context. So they have no idea even what they should be paying attention to or what they shouldn't. So we're dependent on that to get our information about the case if we don't have the cameras. And then the backup is, well, we can just wait till the trial is over, and then we can spend thousands of dollars to get the transcripts. It's possible. It's not real feasible, but it's possible. It's been done before. You can crowdfund and things like that, make them publicly available. But you lose a lot in the transcript. You lose a lot. You don't get tone. You don't get timing. You don't get just the visual effect of everything. Very good example, this exchange we just had where, prosecutors asking questions and the witnesses like already jumping in, trying to cut him off. That all has to get interpreted. by a transcriptionist, and it doesn't convey what you're able to see, happening with your own eyes. So yeah, I think my personal experience with the Richard Allen case, it wasn't what made me think that we need cameras in the courtroom, because Dep v. Heard is what got me there. But frankly, even just the experience of finally being able to watch, some more cases live for ourselves that we're interested in, compared to, a lifetime of reading media reports that are inaccurate and biased and, all of that, not even like missing the point. I was already on the train of we need cameras in the courtroom. But Richard Allen, yes, another great example of how important that is to understand, what happened and why it matters. You can read the transcript and you do not get the flavor of how imperial and dismissive and sadistic Judge Gull was with her attitudes toward the defense team. And that's just one example of what the cameras would have captured. And frankly, probably part of the reason for why they weren't allowed to be there. Rage Bronson, this is for some peanut butter French toast. You deserve it. Still haven't tried it. I think I mentioned I'm not the biggest French toast fan. I would, if I'm going to go with some type of baked good for breakfast, I mean, number one, I'm going to, go straight for the croissant, like, hello. But if we're not going to go full patisserie, then I'm probably going to have a waffle, like me a nice waffle. But I have actually been making this actually reminds me, because we've been spending a lot of time with my grandma. Grandma's, getting a little harder to look after her own needs. I mean, she's 95 for heaven's sakes, and still lives independently and stuff, but needs a little bit more help. So we've been spending more time with grandma, helping her with her meals and things like that. And peanut butter is actually one of the things she really likes, and French toast, also likes French toast. So thank you for the reminder. I'm going to need to bust out some peanut butter French toast for grandma one of these days. Michelle 8190. Yeah, here's the question. It was a super. I should have noticed it was a super chat. Does the defense lawyer have a duty to investigate? Oops, we are back.
More minutes for presentation of evidence, and then turn to arguments of 15 minutes per side, and then we'll take it from there. Thank you, Mr. Burt.
Could I have the screen turned back up?
Wait, what happened?
Correct.
That's correct.
You're a cognitive psych.
Stream. Don't be glitchy. This is the stream glitching, not anything on our end. Come on back. Come on back. Somebody trip over a cable. Can barely see Ruva coming up to the stand there. All right. We might just go ahead and screen here, guys. Give me a second. Let me move over to this other one instead. And
making memory.
Go back just to catch a few minutes.
All right, Mr. Burt, returning to you. Thank you.
Thank you, Your Honor.
Let me get there.
Doctor, my question was, do you have a area of expertise within your field of cognitive psychology?
Yes, my expertise is in decision-making, judgment and decision-making, memory, and perception, and I apply that basic research to the legal system. So studying juror decision-making, specifically, I've spent a lot of time looking at the effects of pretrial publicity on jurors' decision and their memory, on how they interpret evidence, so a bunch of different things, how they deliberate. So that's what I spent predominant time doing.
When did you get your PhD degree?
In 2001.
What was your dissertation?
My dissertation looked at the effects of negative defendant pretrial publicity on juror and jury decisions. I actually looked at non-deliberating juries and deliberating juries to look at the different effects of those exposed to pretrial publicity who deliberated versus not deliberated.
Okay. And was your dissertation published?
Yes, it was.
Since that time, have you published a number of studies on the effects of pretrial publicity?
Yes, I have. And my most recent was published just recently in 2006.
How many studies?
2026.
How many studies have you published just on that topic?
I don't know. I could count them. They're not numbered on my CV. Let's say 15, 20. And I've also done a couple of reviews, book chapter reviews that have also been peer reviewed.
Okay. You, in addition to the two reports that are in evidence, also prepared a very lengthy PowerPoint presentation, correct?
Yes, I did.
And you know we're not going to have time to put that on.
I understand that.
All right. If I could bring up, I don't think I'm hooked up yet for some reason.
Uh-oh.
See the
Let's
screen.
kill another 20 minutes or so getting your computer to work. This is Michael Burt. Michael Burt is...
While we're doing that, let's answer the question that my opponent raised, which is, does positive pretrial publicity mitigate the effects of negative pretrial publicity?
And so I've actually looked at that, and I've looked at it in two different ways. One that's not realistic and one that is realistic. And so in a case like this, the realistic way, where you have a lot of negative or anti-defendant pretrial publicity come out first, we find that positive pretrial publicity that comes afterwards does not influence the verdicts. So that primacy effect, and what a primacy effect is that information that you receive first has priority. So for example, in a case where a juror has been exposed to pretrial publicity, that information will actually influence how the jurors then process the trial evidence, their memory for the trial evidence, and then ultimately how they deliberate in the jury room. And so positive pretrial publicity, if it's presented like a back and forth, like one negative defendant article, one positive defendant article, one negative, when we do that, like every other article, which is unrealistic, that is not how things work in the real world, but we wanted to see if we could remove bias. We are able to, what we call level the playing field, but when you front load the pretrial publicity with all negative pretrial publicity, then it's difficult to overcome that initial bias.
All right, and you looked at the pretrial publicity in this case?
Yes, I did.
How would you characterize it, just in terms of the tone and what we just discussed in terms of negative, positive, et cetera?
So I reviewed all the pretrial publicity that was in the motion. And so I have not, there's no way a single person could review everything in this case, but I reviewed that pretrial publicity. And what I reviewed was predominantly anti-defendant. There was very little that was anything other than anti-defendant, especially early on and in the mid parts of what I reviewed. It was predominantly anti-defendant, looking at the defendant, again, like Dr. Edleman said, painting the defendant in a negative light, dehumanizing language, accusations of guilt, and basically giving your opinions upon what kind of sentence he could get. So there was a lot of anti-defendant that went to the credibility of the defendant, which is really important, but also publicity that is likely to engage the public in moral outrage, okay? Because something morally wrong has happened, it's horrible, and again, we have high-profile individuals like the president, the past attorney general, the FBI director, the governor, so a lot of people that have a lot of power and influence coming forth and saying these things about the defendant.
What does the research show when you have a situation where high authority figures, the president, the vice president, the governor, the attorney general, the head of the FBI, are putting out anti-negative publicity on the one hand, and on the other, you get these wild conspiracy theories from fringe podcasters? How does that balance out? Does the podcaster conspiracy stuff swamp or overcome all the negative publicity coming from the authority figures?
And so now you're getting into more of the conspiracy theory research, which I am somewhat familiar with, and I've looked at it, and it is pretrial publicity tangent, correct? Because in this case, we can call these conspiracy theories pretrial publicity, right? Because they are a form of pretrial publicity. And the credibility of the source of conspiracy theories definitely has an effect. We have not, we don't look at the credibility so much in the research of the source of the individual, talking about the pretrial publicity, but they're published in reputable journals or, reputable newspapers or TV. And so that gives the impression that there's some authority, there's some credibility there, but actually looking at who is saying it, my research hasn't looked at that, but there's other research that has looked at credibility effects on people's willingness to accept something as true. And definitely in the social psychology and conspiracy theory research, they do find credibility matters.
So how does prejudicial pretrial publicity influence jurors? What is the mechanism?
And that really is what I looked at from the beginning, because it was already established, and I don't think anyone today would say it doesn't affect jurors, at least not in the research community. But I wanted to know how. So the first way that I looked at was how it influenced basically their memory for the trial. And so what we call source memory. So when a juror is exposed to pretrial publicity, they have two sources of information. They have the pretrial publicity that they get prior to trial, and then they have the trial evidence. They then have to differentiate between all of that information they got before trial from the evidence they got at trial. And this is a very difficult task. And it's a difficult task because many memories are not tagged with sources. Instead, individuals have to, and this is an unconscious process, look at external factors that have been basically remembered to the side and decide, was this memory formed when I was prior to trial, or was it formed when I was at trial? And so my research has found that jurors with a high amount of confidence believe that information that was only presented in the pretrial publicity was presented at trial. They then use that information to make decisions about guilt unknowingly. They're not aware of this because it's an unconscious bias. And that's really what I look at is unconscious biases. It's an unconscious bias. And then they talk about the pretrial publicity during deliberations as if it came from the trial, as if it is actually trial evidence, and other jurors fail to correct them for the most part during deliberations. And so we do this thing called mediation analysis, and we find that these source memory errors are actually the mediator, or actually the factor that is responsible, one of the factors that's responsible for these biased verdicts. So jurors make these errors make them more likely to find the defendant guilty, and that's one form of bias.
You were in court when the video clips were played?
Yes.
In two of those clips, the announcer says, "We heard from the hearing," and then they put out incriminating information, which actually had its source in the prosecutor's press conference. Is that the kind of source misattribution error that you're talking about?
Yeah, so when I talk, and I'm sorry, I would have more time to explain if I had more time, but what I'm talking about is that you believe that the source of the information is different from the actual source. So yes, they made a source memory error where they believed the information that they were discussing actually came from the live stream, when in fact it did not. It came from the governor's press conference. So they were confusing the source, which again is something that is not unusual, and it's something that we all do.
And in the situation in the clips, they were talking about a press conference and a court appearance, and they're broadcasting that all occurred on the same day. What is the effect when the pretrial publicity is followed by a long delay, and then you have the trial evidence, and then you have more of a delay because of the length of the trial, and then you get the jurors in deliberation trying to figure out where they heard the evidence from? What does the research show about that?
So memory for source and memory for the information are two distinctive processes. And memory for information lasts longer than memory for source. We sometimes discard the source of our memories, and we keep, though, the gist, the information itself. And so if there's a delay over time, we could discard that source. But also going to source memory, what's really important here is when you're showing these clips of, the actual courtroom where, I don't know if it's going to be this courtroom, but a similar courtroom where the trial is going to take place. You have the attorneys that are going to be here, the same judge. You're not giving prospective jurors any distinctive features to hold on to be able to discriminate. Well, this was something I got prior to trial, and this is something I got at trial, because the two sources now are basically entangled. And it's going to be a very difficult thing to do to try to discriminate those two sources of information.
Last area I'm going to have time for does research say anything about whether video or live streaming has a greater impact in terms of prejudicial pretrial publicity than other forms of pretrial publicity? And second part of that is, does repetition of the information play any part?
Okay, so first part, yes, there's evidence that video has a stronger impact, and a lot of that is because video, one, it catches our attention more, right? So you have more attention is going to be paid to video, but also it can result in more emotional responses, more visceral emotional responses, and so it will be better remembered too, because visual stimuli, because a lot of times it's not just the visual stimuli, there's auditory stimuli connected to the visual. It's going to be better remembered. And both meta-analyses and individual studies have shown this. And as for delay, in a trial, and I've seen this, pretrial publicity comes and goes. Yep. The best way to learn something is to learn it spaced out. And this is what we see with media that follows a case, making it to trial. It ebbs and flows, and so you'll see a lot of it every time something like this happens, a hearing happens, or just before you go to trial. And so it isn't like it completely spaced learning and this high repetition. Think about school. Space out your learning. Repeat. This will result in very long-term memory for the information, a very strong and long-lasting memory.
Thank you. I want to leave some time for cross-examination.
The state. Thank you, Mr. Burt.
So we got the clarification
Good
about
afternoon,
the
Professor.
mitigation.
We're talking a lot about the effects of pretrial publicity on jurors, prospective jurors, correct? Is it true that the effects of pretrial publicity goes both ways, meaning it can negatively impact the defendant, correct?
Correct.
And it can negatively impact the state?
Correct.
Okay. In your declaration in this case and in slides that we haven't gotten to, you've referred to a number of theories. For example, pre-decisional distortion theory.
Correct.
Emotion.
Yes.
Or affective PTP, I think?
Yes, emotional, because affect is a little different for us, yes.
Okay.
Emotion is more specific.
Thank you. The story model approach.
Correct.
You talked briefly about primacy effects.
Yeah.
Belief persistence.
Yes.
Confirmation bias.
Correct.
Source memory errors.
Correct.
And group polarization or polarization effects.
Yes.
Are those one and the same?
Yes, they are. They are the same. And I know on a slide sometimes it gets truncated, but they are group polarization. Yes.
Okay. All of those theories, as applied to pretrial publicity, can affect both sides, correct?
That is correct.
Negatively or even positively.
It's not positive for justice, maybe, but positive for the side that, yes.
Fair enough. Thank you very much.
Good.
If I could have you turn, do you have a binder there?
Yes, I do.
In your declaration, I believe this is tab number 6. I can have you turn to page, it looks like it starts on page.
This would be my supplemental material because my
I think
declaration.
it's your original declaration.
Okay, so that, yeah, I have it as 5 here.
Okay, tab 5. You could go to page 6, paragraph 10.
Okay.
You're talking about a study that you, a 2018 Ruva study.
Well, this actually is not a Ruva study. This is my peer review, one of my peer review chapters where I review the PTP research to date at 2018.
Okay, perfect. The second sentence in that paragraph reads, DeLuca, 1979, found that mock jurors exposed to 3 pieces of anti-defendant information were more likely to convict than those exposed to only 1 or 2 pieces.
That's correct.
Consistent with this, Daftery, Kapoor, Penrod, O'Connor, and Wallace, 2014, reported that jurors who read a high amount of anti-defendant PTP, 10 news stories, were significantly more likely to render guilty verdicts than those exposed to a lower amount, 5 stories, correct?
Correct.
And then you indicate, conversely, greater exposure to pro-defendant pretrial publicity reduced the likelihood of guilty verdicts compared to lower exposure.
Correct. And so if they're only exposed to, one type of pretrial publicity in these cases, correct.
Okay, thank you. Pretrial publicity, again, as it applies to both the defense and to the prosecution, can persist. The effects of that can persist through jury deliberations. Is that accurate?
Correct.
Okay. And negative victim pretrial publicity can hurt the prosecution's case. Is that accurate?
That's correct.
Okay. If I could have you turn to your slides, which I think is I thought it was tab 7, but it might be tab 8.
Okay.
Can I have you turn to slide 58?
Okay.
In slide 58, you write, quote, jurors exposed to anti-victim PTP are less likely to vote guilty after deliberations than before them, close quote.
Yes, and that's a polarization effect. Correct.
Thank you. If you turn to the next slide, slide number 59, you wrote, quote, jurors exposed to negative victim PTP discussed trial evidence in a pro-defense manner and favored not guilty verdicts, close quote.
Correct.
Thank you.
How an expert testifies, you want objective. This is objective. You get the bitter with the sweet.
And then if I could have you turn back to your declaration in the previous tab. Page 34 of that declaration is paragraph 59. And I think in this paragraph.
Hold on. I thought
Okay,
it was.
that's fair.
Oh, again, I think I'm I'm on the supplement. I'm sorry. There's too much stuff in here.
What was the page again?
Page 34.
Thank you.
34. I'm there now. And what?
Paragraph 59.
Okay.
I think you're sort of, this is page 34 of 36. So I think you're sort of summarizing some of the conclusions of your research. It states, these findings collectively indicate that the victim, PTP or pretrial publicity, can significantly distort jurors' verdicts, perceptions of credibility, interpretation of evidence, and memory accuracy, and that deliberations are not a reliable corrective mechanism. Instead, deliberations may perpetuate or spread bias, undermining the fairness of trial outcomes.
That's correct.
Okay. And again, it applies to both sides.
Yes.
Okay. I noticed that in most of the conclusions or your findings in your declaration and on the slides, which again, that we haven't referred to specifically today, you couch your findings or conclusions in conditional language. For example, you write, information processing can be biased by information that comes before the to be remembered event.
Yes.
In your declaration, you stated live streaming of all proceedings can lead to deep-seated bias. Is that correct? Why the conditional language, Professor?
So, as a scientist, we never prove anything, right? It's probable, there's a high likelihood, it's reliable finding, but we never say that something's definitive. We always, there could be other factors, and so we always say can, but there's overwhelming evidence. And again, we find this over and over again, it's reliable finding that pretrial publicity does bias how jurors interpret information, and is actually a mechanism through which, this primacy effect, this pre-decisional distortion, the story model, which they're different, but it's not important. The difference is they all basically lead to the same results. They result in biased verdicts. But again, as a scientist, I would never say that I proved something, but there's a good likelihood that this will happen.
Okay. So it demonstrates your intellectual honesty, correct?
Yes.
Okay. A couple of other examples. In your declaration, you wrote, cognitive bias can be unconscious.
Yes.
So not certain, but it can be.
There's cognitive bias, and we didn't get to my slides, but I talk about explicit bias, which is bias that's easier for the courts to deal with, versus implicit bias, which is much more difficult for the courts to deal with because jurors are unaware of their own bias.
Okay. Let's briefly talk about the studies. The majority of these studies, or perhaps all of them, you can correct me if I'm wrong, but your studies are based upon mock jurors and mock trials. Is that accurate?
My own studies, yes, but the research that I cite in here, there is some that is not. So there's some field research and some survey research, but my own research are all mock, what we call jury simulations, so experimental studies.
Okay, kind of a laboratory.
Yes.
Okay. Not the real world, but you're trying to get there.
We're trying to mimic it as much as we can.
You mentioned some of the studies are survey studies.
Not mine, but individuals. It's a mixture between a field and a survey study. So yes, there's studies that go out and ask jurors, for example, something similar to what Dr. Edleman did, but it's a little different when you ask jurors, prospective jurors in the venue where the trial is going to take place. And this is for research purposes only.
Sure.
How much pretrial publicity they've been exposed to, what they can, specific facts that they can recall. That type of research.
What are the limitations in survey studies? You speak to it briefly in your declaration, and there was even a slide about that.
And so the problem with survey research is that although it might be high in realism, because you're talking to people who might actually be a juror in that venue, the problem with survey, that particular type of survey research, is that we can't infer causation because nothing is controlled. We can't systematically vary how much pretrial publicity someone gets. We don't know exactly what they were exposed to, and so we cannot infer causation. We don't measure anything that isn't any implicit types of bias. Instead, we look at explicit bias. We can measure, explicit, but we can't measure the implicit bias, the things that I measure in my study. And so that's some of the weakness there.
You mentioned that implicit bias cannot be measured, or it's difficult to identify.
It's difficult to identify, but you see it in behavior. So, for example, when I see individuals who have a very strong opinion that information was presented in the trial that was only presented in the pretrial publicity, I know that they have no reason to lie to us, as a researcher, and they're doing this with a high amount of confidence. And that's a type of implicit bias where they truly believe that their memory is accurate, but it isn't. And then we also have this pre-decisional distortion paradigm where we can actually see them distort trial evidence that aligns with the slant of the pretrial publicity they were given. So in an empirical research study where we have control over everything, we can measure those things.
Okay. This probably goes without saying, but none of us can predict who is going to be summoned to jury service in the future, correct?
Correct.
Let alone which 12 members of the community will actually sit in judgment in a particular case. Is that accurate?
Correct.
Okay. In some of your writings, you talk about, for lack of a better word, remedies, or some things that we can do in the court process to identify bias.
That's correct.
Certainly explicit bias.
Yes.
And what might even help with respect to implicit bias. What are some of those tools that can be used?
So for implicit bias, the bad news is I really can't say that any of the tools that I discussed are really, I've done research on it too. Implicit bias is something that's really hard to remedy because jurors are not aware they have it. It's unconscious bias. So how do you correct something that you're not aware of? And I could go into more detail, but I know I don't have time. Explicit bias is different. If you use, well-prepared, thoughtful juror questionnaires, if you have, extended voir dire that is individual juror voir dire, so we don't have that social desirability effect, you can identify explicit bias. It doesn't mean it's going to be perfect, but you have depending on what you do, you have a better chance of identifying explicit bias. It's the easier bias to deal with.
Okay. And in a case like this, a notorious criminal case like this, your recommendation would be that we have extended pre-voir dire questionnaires, correct? Individual voir dire questioning of jurors.
Correct.
Turning to the implicit bias, with respect to these extended voir dire questionnaires, what can be asked that may help us identify implicit bias?
So one of the recommendations, and I know it's probably in here somewhere and I don't know where, is that you need to find out the amount and type of pretrial publicity that jurors have been exposed to. Okay. Because even if they believe that they can be impartial, and that's part, they want to please the court, they want to please the judge, and sometimes they do truly believe that they can set aside bias, it's asking those questions to get at how much have they been exposed to, what is the type of information they've been exposed to, that will tell you if they're biased. Asking them whether they are biased or they can set aside bias does nothing. Jurors will say they're not biased and they will truly believe it. And we find that they're biased in that we look at their verdicts, and those that say they can not, they're impartial, they're not biased, they showed the same bias when exposed to pretrial publicity as those that explicitly say, no, I'm biased. I know that I can't be impartial.
Okay, so extended questionnaires that asked about someone's exposure,
yes,
what they look at, how much could help identify
Zoom, camera guy.
potential problematic jurors.
Correct.
With respect to bias.
Correct.
From pretrial publicity. And it's not your opinion that someone cannot set aside their bias, is it?
When it's implicit bias, it's very, very explicit bias, but implicit bias, the problem is that in order to set aside implicit bias, you have to be aware of the bias. first of all. You have to be motivated to correct that bias, and then you have to know the amount and the direction of that bias. And those are rarely there for unconscious bias. For explicit bias, yes. But for unconscious bias, how does someone guard against how they're going to interpret all trial evidence? How does someone guard against the fact that they're now unable to discriminate what they saw prior to trial versus what they're seeing in trial? And so when they don't follow judicial instructions, because we do instruct them not to use pretrial publicity, and so when they don't follow instructions, it could be that they're, willingly not, but a lot of times it's because they're not aware that they're not following the instructions. They truly believe they're being good jurors, but they have this unconscious bias that they cannot remedy themselves.
Understood. Thank you. And again, the bias due to pretrial publicity can go both ways, correct?
Correct.
It's got a little
I can have you turn back to your declaration.
expert advice on
I think you're there
putting
still.
here.
If you go to page 26, paragraph 40. In this part of your declaration, I think you're talking about the survey data that was used in support of Utah's law, creating the presumption for cameras in the courtroom. And you're talking a little bit about what California did. They did some additional research here. They used some interviews and systematic observation to perhaps bolster the basis for their law.
Correct.
The last sentence, or last two sentences in that paragraph, you wrote, each trial, witness, set of jurors, judges, attorneys are different, correct?
That's correct.
You then say there is no control over any variable, and hence there is no way to conclude that cameras do or do not affect trial players' behaviors, memory, or decision-making, close quote.
That's correct.
Correct. Thank you. Nothing further, Judge. Thank you.
Mr. Burt. That's a strong finish.
In your PowerPoint presentation, you kind of summarize that there are three methodologies. One is survey research for studying effects of pretrial publicity. One was survey research, right?
Yes.
Second was jury simulation research.
Yes.
And the third was meta-analysis.
Correct.
And do those three areas of research kind of come together with some common understandings about the effect of pretrial publicity?
Yes, they all converge on the same finding that pretrial publicity influences jurors' decisions, and that there's also another that I don't explicitly list there. There's a shadow jury paradigm, which I believe the prosecutor, he alluded to, where we looked at, I didn't look at it, it was Daftari Kapoor. They looked at it where it's kind of both a field research and an experimental study. And in their study, they found that the findings once again converged, depending on what the jurors were exposed to, regardless of how they were exposed to it in the real world, out, in the venue, or, experimentally. They were biased towards the side that the pretrial publicity was against. So if it was negative defendant pretrial publicity, they're more likely to find the defendant guilty. And this is, again, converges over all of the methodologies. And if it was, I think in that case, in that shadow paradigm, if it was positive defendant, it was pro-defense.
Is the overall purpose of your study to try and eliminate bias on, if possible, on both ends of the spectrum? In other words, is your concern that both the defendant and the government receive a fair trial, not impacted by prejudicial pretrial publicity?
Yes.
A lot of the focus of the questioning by the state was, well, it prejudices both ways, but in either side of the spectrum, you're getting prejudgment, right?
That's
the
correct.
effect of the pretrial publicity. One is prejudicing the defense, the other prejudicing the state.
That's correct. And neither, like I say, neither is acceptable in my opinion. And, obviously I think in probably the court's opinion, you don't want that bias prior to trial. You would like jurors to come in that really can be impartial and not have a favored side. And that's, when they come to trial favoring the defense or favoring the prosecution, that is going to just result in a biased outcome.
I want to be clear on one point. Were you suggesting that there is a way to eliminate implicit bias by using jury questionnaires or doing open-ended questions or any other method that we know of?
It's not a way to eliminate, but it's a way to better identify jurors that might have bias. You're not going to eliminate the bias, but it might allow you to identify individuals that have bias. And so again, it's not asking, you find out that someone has been exposed to something
And then you just get rid of
at
those
that
jurors.
point, and you find out how much they've been exposed to, what they've been exposed to. There's no sense in asking them if they can be impartial. If they've been exposed to a significant amount of pretrial publicity from one side or the other, then we can just assume that they're going to be biased.
So what we were
Last
going
question,
to do
based on
anyway-
your review of the publicity in this case, do you believe that the negative publicity, and negative, I mean negative toward Mr. Robinson, has mitigated the anti-Charlie Kirk publicity has somehow remedied the negative publicity, given the nature and the timing in particular of the publicity?
No, and again, I think because predominantly early on, and there's just a lot more by credible sources that is anti-defendant than is, anti-Charlie Kirk or anti-Erika Kirk or any, and you have to remember when we look at anti-victim pretrial publicity, especially when it comes to murder, in murder cases, because we do look at different types of cases. In those cases, the anti-victim pretrial publicity kind of points that the victim somehow was responsible for their own death because they did something they weren't supposed to do. And I'll just give you an example. For example, they came into their ex-wife's house with a gun, and the ex-wife thought that they were an intruder in the house and shot and killed them. Versus, the ex-wife or the estranged wife, in this case, called her husband over so that she could. So it gives an ulterior view of what happened to the crime. So it isn't just credibility of the defendant, of the victim, or we don't like the victim. That is not what we manipulate in these anti-victims. It makes them look like some way they maybe could be culpable for their own victimology.
Like myths about rape victims, for instance. A lot of the studies have been done in that area.
And that has been done too, yes.
Is the publicity in this case easily characterized as pro-defendant or anti-defendant? For instance, there's some articles about suggesting, Mr. Robinson allegedly was involved in a conspiracy with others, Israel or whatever. Does that exonerate Mr. Robinson, that kind of conspiracy theory?
No, it still points to the belief that he was guilty. He was just someone else was also involved too. And so it doesn't absolve the guilt, and it doesn't point away from the guilt of Mr. Robinson. Instead, it says there might be other actors too that are involved in this.
Not the same thing as the sort of rape victim myth.
Yes.
Kind of things that are studied in the literature. Okay, thank you.
Thank you. Anything further?
Judge, I have two quick areas of questioning.
All right, Mr. Grunander.
In turning to your last slide that you prepared, it was slide number 82. The title to this slide is Expert Conclusions. And number one reads, based on my review of the empirical research literature, the pretrial publicity identified in the defense motions and the Utah County Public Opinion Survey, it is my expert opinion to a reasonable degree of psychological certainty that this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality.
Correct.
You wrote that, right? So with respect to pretrial publicity, you reviewed the defense motions pretrial publicity.
That is correct.
You did not do your own deep dive into publicity.
No, I was not asked to do that.
Okay. If respondents to a survey were responding with words to describe Tyler Robinson as a scapegoat or cover up or fall guy, would that indicate that conspiracy theories that or theories that he was not the guy who did this are taking hold in the community?
I mean, I don't know how widespread that is, but, and again, I would need to, maybe look more at what else was said, but it could. I mean, there's a possibility. There are some stories out there, but as I stated, there's just overwhelming anti-defendant pretrial publicity. And what happens with pre-decisional distortion is that we actually throw away things that don't fit our initial story. So if we don't think it fits our story, I'm going to think that that's just crazy.
The story model approach.
Yes, the story model approach.
But if people were listening to conspiracy theories that were advanced starting the day of the charges,
yeah, that's different. Yeah,
that could affect their story model.
Yes, correct.
Okay, thank you.
Yeah, like
Anything
what's
for
his
the-
name?
For this witness.
No, Your Honor.
All right, thank you, Doctor. Let me
The
step down.
lunatic guy, George Zen,
All right.
from day one.
So, counsel, we'll turn now to closing arguments, but I do have some questions for counsel. As you know, I ultimately need to make the decision on what's being requested, and so I did have some questions for you. The court is bound by Rule 4-401.01 in deciding whether to allow or restrict electronic media coverage. First, subsection 2A states that there must be a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. In assessing the predominant purpose, is the court required to consider the purpose of the requesting news media organization? For example, for today's hearing, the requesting media organization is ABC4. The court form does not require the media to represent the purpose for the coverage. So what criteria should the court apply in determining the predominant purpose of the electronic media coverage?
Unfortunately, Your Honor, there is no guidance in the case law. No court has interpreted this rule. The only thing we have to look at is the genesis of the rule, which is the final report in 2012. And if the court looks at that report, you'll see heavy reliance on a study, a law review article that was done by Ninth Circuit Judge Kaczynski back in the 90s. And one of the things that he emphasizes in that study, and the only indication I could see of what is meant by the predominant purpose, is he uses the O.J. Simpson trial as an example of what is not for the predominant purpose of journalism, but is rather sensationalism. And he uses how the camera is dramatizing events in the courtroom, and is the best example I saw of what could have been meant by that language. It's also noteworthy that that language was not part of the original rule when it was adopted. It was put in by amendment several years after the rule was adopted, I think in 2015, and I did diligent search on this. I could not find any indication in the Judicial Council proceedings or anywhere else of what was meant by this. So it's kind of an open question of how the court goes about and interprets it. I don't think it's governed by how the media represents themselves. I think it's more governed by the substance of it. Is it sensationalistic? Is it more focused on advertising? A lot of the coverage you'll see on the clips, even the live stream coverage, has commercial breaks in it. And one of the factors that the Supreme Court cited, Estes, Maxwell, those cases, is the effect of having court proceedings that include product advertisements and the kind of disrespect that could result from that, from putting the court in the position of at least appearing like they're advertising goods here as opposed to doing justice. So in the absence of any indication, and this language also is unique to this state. I could not find it anywhere else in terms of what that meant. So my best answer to the court of the question is that I think the court has to look at, is it serving an educational purpose? Is it, and that's what journalism is. You're reporting the news, you're not creating it. You are reporting on what's happening in court. You're not making arguments for the prosecution to show that Mr. Robinson is guilty. And one of the things we've tried to demonstrate in the hearing today is that at least the electronic media, the predominant theme there is advancing the prosecution's side of the case. It's not educational in nature. It certainly is affected by a profit motivation, but more importantly, it's sensationalistic and it's prejudicial.
If you
and
gave
I
us
would say that
anything to
that
work
is
with
not
evidence-wise,
within the
we'd talk
scope
about it.
of the language that the court is talking about.
All right, turning to the state.
Not our fault. You've given us nothing.
Judge, I don't know that I have a whole lot to respond to because these are unknowns. But the language of this, so there is a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the coverage request is journalism or dissemination of news to the public. So when I first think of that, I mean, we have all kinds of media coverage that is probably not journalistic in nature. Some of the podcasts, some of the different streamings that can occur that we can find on the internet, online. I don't know that you would couch those individuals as journalists so much, but ABC4, KSL News, these are journalists that are live streaming these proceedings. The difficulty here that we're confronted with is what is being done with that coverage by third parties, which can't really be controlled. But a news organization that comes in to actually live stream these proceedings, they're then streaming those proceedings to the public. It's very educational. It's very newsworthy. It's disseminating the news. And so I think if the request from the court was from a YouTuber, some sort of broadcaster, or some sort of podcaster, there may be problems there. But when it's coming from a traditional news organization, they are in fact disseminating this news. But it's about the best I can give you right now, Judge.
All right, and just two more questions and I'll ask you first. Subsection 2D of the rule states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. The court reads this as requiring individualized findings for each proceeding rather than permitting a blanket order prohibiting coverage. Is that your understanding?
I believe that is accurate, Judge. That is my understanding, and that's why I think a request to just simply eliminate electronic media coverage in this case is premature. It's not warranted. There are going to be times, probably throughout these proceedings, where a hearing should be closed for safety purposes, or if there's some sort of controversy that could prejudice one side or the other. But just a blanket exclusion of the media, I think, would go well beyond what this allows for.
All right, and so is this what the court must undertake this process for each hearing?
Well, I think the court has sort of a foundation of the issues before it, has an idea about what the effects of pretrial publicity can be for or against either side, possibly even both. We didn't discuss what happens to people who look at both sides of the slanted coverage, what the effect on that individual is. But I would suggest that the court can take what it's learned through these hearings, the evidence presented here, and apply that to the proceedings moving forward. And if we have to reconvene or if there has to be further argument, we can make those arguments, and the court has a basis to draw from now.
Thank you, Mr. Grunander. Mr. Burt, the same question posed to you. Subsequent 2D of the rules states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. So the court reads this as requiring individualized findings for each proceeding rather than permitting a blanket order prohibiting coverage. Is that your understanding?
No, it isn't, Your Honor, because I think what that section is referring to is you can't base a finding under the rule based on general concerns. It's got to be related to the specific publicity in this case. And the reason I read it that way is if the court looks at 2A, it says the judge may prohibit or restrict electronic coverage in those cases. It doesn't say in those proceedings. It says in those cases, as if the court can make a ruling regarding the entire case. And that reading, I think, makes sense in terms of the practicality of having the court have to revisit this issue every time we have a court proceeding. I think A points in the direction of the court being able to make a finding that applies to the case as opposed to a particular hearing or proceeding, and D directs the court that when you're considering the issue, you shouldn't take into account just generalized concerns like prejudicial publicity in general is harmful, but you have to look to the particulars of the case and decide in this particular case, is there a reasonable likelihood that the defendant's fair trial rights will be jeopardized under the first factor. There are other factors, of course, but I think that is, or for instance, on the privacy concerns, I think D is calling you to look at not in general, well, juror privacy or witness privacy may be jeopardized. That's a general concern or a general view. What the rule is saying you should do is don't look at general views or preferences. Look at whether the witnesses or potential jurors in this case could be impacted in terms of their privacy rights. That's the way I read the rule.
All right, one final question, Mr. Burt, I'll start with you.
Sure.
So the court's not limiting argument on the factors set forth in Rule 4-401.01. However, I would like counsel to address one specific factor, 2BV, which allows me to consider whether electronic media coverage will create adverse effects greater than those caused by media coverage without recording or transmitting images or sound. Even in the absence of electronic media coverage, the media retains a First Amendment right to observe and report on the proceedings. Is there evidence before me that would assist the court in comparing these two circumstances?
There is, Your Honor, and in particular, the report set out in great detail in Dr. Ruva's declaration, and we didn't have time to explore this in detail here, but the declaration indicates that the source of the media does matter, that electronic coverage has a greater impact than print media because it's more visual. And from the perspective that Dr. Ruva talked about this source misattribution theory, the visual of the courtroom is much like what a juror is going to be hearing during the trial. So in that scenario, they're much more likely to make the kind of source misattribution errors that cause jurors to have this implicit bias. They're thinking, oh, I've heard this before. And what they may have heard before is the kind of coverage we saw today where the court proceeding is in the background. They've silenced what's going on in court, and the media talking heads are saying, let's look at the text, let's look at the confessions. So the danger here is that they're going to confuse those two and not know that they're confusing them. And so that comes from the visual looking at the images. And you're not going to get that, according to Dr. Ruva's declaration, from print media alone. And she cites a number of studies on that issue. So I think there is evidence before the court on that.
Well, then that creates another category, which is audio, because the audio is available to anyone if it's not a closed hearing. And so walk me through the scenario if audio is played and then, as you described, media is doing what you just described with the audio clips being played and then them commenting on that.
I think the situation is not comparable to the video scenario, because in the video they're using it as a backdrop. It seems unlikely that they can use an audio backdrop, silence the audio, and make the kind of commentary that they're making here. They're using those images as a dramatic way to say, look, we're in court. And the announcer saying, and we heard during the hearing the text messages. Well, that didn't happen, of course. But how would you do that with an audio? You couldn't silence the audio and have the commentators putting in that prejudicial content. It's I think, qualitatively different.
Okay. All right, Mr. Grunander, I'll pose that same question to you and happy to repeat it if you'd like.
That's okay. I'll just pick up on where Mr. Burt left off. Certainly the media could, certainly an outlet could grab the audio and splash something up on the screen, which we see as well too, that could prejudice one party or the other. So I think the court raises a good point that the audio is going to be always available. Certainly I think that intense coverage of any proceeding, there's a greater risk, right? I think that's fair to say. One thought that came to my mind, though, is that even perhaps a middle ground, if the court has concerns here, is the WebEx broadcast. That would give the court control of the camera. There couldn't be zooming in and zooming out, stuff like that. But there is a greater risk with additional coverage.
All right.
I would say.
All right. So we have about 24 minutes, and I realize that your closing arguments, well, they are important. And so I'll give the parties an option. You can have a very brief closing, or if you wish to submit your closings to the court for consideration in written form, I'm happy to entertain that so you're not limited to a time constraint. What are the thoughts of the parties?
I have submitted to the court, I think it's getting near the 200-page limit of written arguments in front of the court. And the hearing has provided the court, I think, with some sense, but the real important stuff is in the declarations that were submitted in support of the motion. That declaration is thoroughly addressed in the written motion. So I'm not sure it would be helpful for the court to burden you with yet more paperwork. I mean, I'll do it, but I think the court has the tools in the written submissions. I do want to, in the brief time I have, say a couple of things that I wanted the court to focus on that have come up since we filed the pleadings that I think are important. And I think if the court could give me a little time to do that, then I'd be satisfied with keeping within the time limits and submitting it based on the pleadings that are in front of the court.
Sure. How much time would you like?
I'll try and do it in 10 minutes.
And how about 5?
Deal.
All right.
One of the things the court, when we were discussing this issue the last time, the court asked me whether the Estes case had been overruled. And I've been thinking a lot about that after that, and I'm not sure I answered it satisfactorily. I said no, that there is still this notion of prejudicial pretrial publicity in high-profile cases, which this is. I stand by that argument, but I went back and took a look at Utah Supreme Court cases since Chandler was decided in 1981 to see whether there was any sort of hint in Utah cases suggesting that Estes was no longer good law. And I also looked just in general at how many times that case has been cited. It's been cited as of yesterday about 4,200 times, which is not generally how overruled cases are treated. It's not listed in Westlaw as overruled. It's cited a lot. And the Utah Supreme Court, after Chandler was decided, cited it 3 times, or they either cited Chandler or they cited Estes in 3 opinions. One of them was when they were considering modifying the rule in Utah, which back in the 80s prohibited in-court coverage. And in 1981, the Utah Supreme Court published a brief memorandum of opinion about that proposed modification. And the court cited Chandler in its discussion. And the proposal was that the prohibition be eliminated. And the Supreme Court says the members of this court are unanimously of the view that Canon 3's prohibition against televising, broadcasting, or recording of judicial proceedings should be reaffirmed, and that the petition for modification of those provisions should be denied. We are not satisfied that the balance between the interests of news reporting and the interests of a fair trial represented by Canon 3 would be improved by the proposed changes. Experiments underway in other states may yet suggest appropriate modification to the canon on the subject, but for the present, we remain unconvinced that change is warranted. And they note that Chandler was decided before they published this opinion. So they recognized that Chandler was on the books. They did not go down that path. And so that's the first time they cited it. They cited it again in a case called State versus Vasquez, 1983, 672 Pacific 2nd, 1254, where they discussed it in the context of a juror misconduct claim for jurors who had, despite the court's instructions, had read the pretrial publicity. And it's cited for Estes is cited for the proposition in Vasquez that it is axiomatic that a defendant is entitled to a fair and impartial trial based on the evidence presented to the jury without the jury being influenced by information from outside sources. See Shepard, Estes, and State versus Pierce. And then the Supreme Court decided, referenced Estes again in a state called State versus Bishop, 753 Pacific 2nd, 438, decided 8 years after Chandler. And they cited it again in Estes in a case decided the same year, Lafferty, 749 Pacific 2nd, 1239. So I don't think Estes has been overruled. And the one thing I wanted to stress to the court, I know the court from past rulings is inclined to keep these proceedings as open as possible. I know the court's frame of reference has been the rule that you just referenced. But as I tried to stress in the motion, there are federal constitutional rights involved. And the federal courts take a much different view of cameras in the courtroom than the state courts, both in Utah and everywhere else. And the general trend of the federal decisions has always been they don't want cameras in the courtroom. And so sooner or later, if there's a conviction in this case, this case is going to end up in federal court. And one of the issues that'll be raised if this motion is denied is, was that a proper denial? And I cited to the court in the original motion a case from the 10th Circuit that says in a clash between the First Amendment and the defendant's fair trial rights, the defendant's fair trial rights must always prevail. So this case will be litigated if there is a conviction in the 10th Circuit. You have 10th Circuit authority saying if there is a clash, and there certainly is, between two constitutional rights, then you always have to opt in favor of the defendant's right to a fair trial. Now, in this case, we don't have a clash of constitutional rights because the federal courts have said and been cleared for years that there is no constitutional right to have cameras in the courtroom in televised trials. So we're not talking about the clash between two constitutional rights. We're talking about the clash between a federal constitutional right and a state rule presumption that applies only if the nature of the publicity is news and not sensationalism. And the other factors that the court has to consider under the rule are not met. So however the court balances those factors under the state rule, the court still has to contend with the federal constitutional issues here. And those issues and the rules there are much different, and they argue strongly in favor of granting this motion. The last thing I want to say to the court, and I know I'm close to 5, if not over it, is one of the factors under the rule, if the court just is going to balance under the rule, is privacy concerns. And we have privacy concerns of witnesses who have expressed to the court that they do not want to be televised. We do not know the privacy position of the vast majority of witnesses who will testify in this case. So whatever the court does here, I don't think the court can make a blanket ruling that says you will never reconsider whether to take cameras out of the courtroom for witnesses who don't want to be televised. I think that may have to be something the court's going to have to deal with down the line. And similarly, I don't think the court in ruling here is excluding the possibility that certain hearings would also have to be subject to possible closure, most relevantly the preliminary hearing. Because
what happened? Why did we freeze stream? I want to hear what he has to say about the preliminary hearing.
Favor of closing the hearing. So we presented the court with a broad argument here that cameras should be excluded, especially under the federal constitutional test. But however the court rules, I don't think this issue is going to go away unless the court just says, I've looked at the publicity, I've balanced the interests at stake, and all things considered, and given the fact that we still have a chance to keep this case in this county, because the survey shows that we don't have overwhelming prejudice here. There is still room to take action to try and stem the flow of the kind of publicity that we've seen so far. And that's why we're urging the court now to step in and do the one thing you can do. You can't control the witnesses, you can't control the media lawyers who have spoken out of court, you can't control the prosecutors who have also spoken out of court about things that perhaps should not be spoken of. But the one thing you can control is, and the U.S. Supreme Court has said you can control, is time, place, and manner restrictions. You can say to the electronic media, you are certainly free to attend. You are certainly free to write about anything you see in the courtroom. The court is open to all. That serves the function of open access, transparency. But because of safety concerns, privacy concerns, fair trial concerns, I am balancing the factors in favor of closing the hearings to further electronic coverage.
Thank you, Mr. Burt.
Thank you, Judge.
Thank you. Sit down, Mr.
Mr.
Burt.
Grunander.
We got 10 minutes left, 11 minutes.
Thank you, Judge. Your Honor, mischief lurks in the dark or in secret. or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised, and the best antidote for falsehood is the truth, is accuracy. It's the actual real proceedings. And that's why we favor opening this court and allowing the cameras in the courtroom. Again, as I said before, an option the court could undertake is broadcasting these proceedings via WebEx. In 1981, the Supreme Court squarely held in Chandler that states may permit cameras in courtrooms, and that doing so does not, without more, violate due process. The court explained that the mere presence of broadcast media does not inherently render a trial unfair. Quote, the court said, an absolute constitutional ban on broadcast coverage of trials cannot be justified simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter, close quote. It is a challenge. It will be a challenge in this case because of the pretrial publicity in part, for and against the defendant, for and against the state in identifying impartial jurors. But it can happen, Judge. And I don't believe that prejudice has been shown. Irvin v. Dowd, a 1961 Supreme Court case, gives the standard for impartiality with respect to jurors who've been exposed to pretrial publicity. That court said, it is not required, however, that the jurors be totally ignorant of the facts and issues involved. In these days, mind you, this was 1961, in these days of swift, widespread, and diverse methods of communication, an important case can be expected to arouse the interest of the public in the vicinity, and scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. This is particularly true in criminal cases. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court, close quote. That was the reason I kept asking the first witness about, at the end of the day, yes, I understand this is about cameras in the courtroom, but at the end of the day, the question is, can we seat an impartial jury? Can Mr. Robinson receive a fair trial? And the evidence indicates that he can, Your Honor. In looking at the survey findings from Mr. Edelman. And I'll point to just a few that I asked him about towards the end of my cross.
Ignore my survey.
The question about, whether they had heard about President Trump saying something about the death penalty or life without the possibility of parole. 81% said no. Other public officials having commented on that, 65% no. Whether they'd heard about a confession from Tyler Robinson, 56% no. The question of DNA, 65% no. And ultimately the question of, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on court TV, YouTube, or social media? So all these large different media mediums. And 74, I believe it was, 74 responded no. That is significant, Judge, because for argument's sake, if we forecast picking a jury in this case, and we were to choose 1,500 prospective jurors to summon into court, 1,110 of them would not have viewed courtroom proceedings. because of the live streaming in this case on YouTube or social media or elsewhere. So that's the ultimate question before the court. Today, the question before the court is whether or not the defendant can receive a fair trial with the current coverage that's going on. Whether his right now is compromised and it's going to be compromised in the future, we can't predict that with any certainty, but there has been a substantial amount of coverage to this point. And it goes both ways, Judge. It's clear from this survey that there are negative feelings towards the defendant, which can help negative feelings towards the victim, which can help the defendant. 25% of the public responded negatively about Charlie Kirk. So at the end of the day, again, mischief lurks in the dark or in secret. Let's shine a light on these proceedings, a bright light, so the public can have confidence in what happens in this courtroom. Thank you.
Thank you. Thank you, counsel. I appreciate the arguments and the evidence presented today. I do want to read a brief statement, and then we'll go to scheduling when the court will make its ruling. The court takes this opportunity to remind all counsel that if any counsel is found to be in contempt of the court's pretrial and trial publicity, it's order docket number 23, and as amended in docket 242, that attorney faces possible sanctions ranging from orders to attend CLEs, public admonishments, and fines up into include jail time, removal from the case, and in the most serious instances, dismissal of that case. These sanctions do not address the consequential nature, the natural consequences that arise when the court must take time away from the regular course of case matters to determine if an order to show cause is appropriate and possibly hold an evidentiary hearing to determine whether contempt has occurred. That being said, counsel would do well to carefully consider their decision to make extrajudicial statements that have a substantial likelihood of heightening public condemnation of the accused, and should consider this before doing so. With that, let's turn to scheduling. Counsel, it looks like the next availability of this court to do a WebEx ruling would be May 8th at 3 p.m. And what is the availability of counsel?
Friday. State's available, Judge.
Thank you.
Yes. That was 3 p.m., Your Honor.
3 p.m. on May 8th.
And that would be WebEx.
On WebEx.
We're all available on that date and time.
Thank you. And counsel, before we adjourn, I encourage you to keep your foot on the accelerator in regards to this case. I acknowledge the hard work you're doing. I encourage you not to let up. We're going to have a preliminary hearing in May. And the court will issue its ruling on the two issues in regards to a continuance of the preliminary hearing and the motion before the court today. Ms. Nestor.
Your Honor, with respect to the hearing on May 8th, we would again request that our client appear via WebEx with no video.
Thank you, Ms. Nestor. I appreciate that clarification, and that will be the case. All right. Anything further before we adjourn today?
Yes, from the state.
All right. Thank you to all parties. Court is now in recess.
All right. Sure sounds like we are going to have a preliminary hearing on May 18th. Keep your foot on the accelerator, folks. Make sure nothing else happens in here. Let them go ahead and boot the screen on me. I'll take the sound off, but yeah, because if he's waiting until 10 days before the preliminary hearing to decide, like, they have to have everything prepared by then already anyway, you know. People will have had to have arranged their schedules and so forth. That seemed to me what he was saying. Another interesting comment there, that comment that he made before. Okay, so, oh, hey, Peter, what's up? That comment that he made before he turned to the scheduling, reminding all counsel that if you're found in contempt, there could be sanctions. It could be really bad. So please carefully consider the decision to make extrajudicial statements. Why'd he do that? I'm going to take us briefly over to the archive here so that I can show you. Of course, oops. Oh, God, I can't see my mouse. Sometimes I hate mouses. Okay. Got to scroll way down because we're past document 500 now. Been quite a lot of stuff. Okay. This is what he's talking about. The latest thing that was filed yesterday, motion for order to show cause concerning contempt in the motion to compel and the declaration in support of that. The defense has filed a motion yesterday arguing that Christopher Ballard has violated the gag order with a variety of statements that he made on different news media and TMZ, like sort out as something a little different. And so this was all kind of on the heels of the information coming out about the ATF report and the testing, the bullet, and so forth, and the inconclusive. And you guys might remember there was a Daily Mail article that came out and like announced the inconclusive result as if it was saying that it was a no match, that it was an exclusion, which it was not. So he made some statements that he couched in general terms for the most part, as here's what an inconclusive statement means generally, even though I can't talk about the evidence in this particular case. But he did make some other comments about how, we think the evidence is strong and he's going to be found guilty and so forth. And so the defense is taking issue with those statements, arguing that they violate the gag order. So you can check those out on the archive if you are interested in doing that. By the way, you'll notice that, which I do apologize for, when you download these now, they all come up with this file number 26. And that's because I changed my naming convention in my own file system so that I can keep track of things chronologically. But the end result of that is that it picks up all of my documents now as just 26. And then once we get to 27, they will all be 27 because that's how my naming convention starts. So you will need to rename these if you download them and stuff like that. But just kind of wanted to explain what that was about. So that will be on the horizon, this request for an order to show cause. It'll be another hearing that they're asking for. So we will see how that unfolds, but not going to go in depth on that today. Well, guys, this was quite a full day, wasn't it? We're over 7 hours on the stream. I have used nearly an entire legal pad full of notes, so fairly classic full day in court for Andrea Burkhardt and her notes. Oh, man. Let's just start with the takeaway, the 10,000 foot. We already talked about the preliminary hearing. It sounds to me like he's going to continue it. Starting with that argument, I'll just kind of recap, what we had. The defense is saying there's just a lot of discovery that we haven't seen, and so we're not prepared to address it. And specifically, Mr. Novak focused on the DNA issue, the fact that the DNA is mentioned in the probable cause that's put forth in the information, but the basis for that opinion still hasn't been produced to them. Meaning, like the literal digital information that the computer program uses to create an electropherogram, which is what tells you what the sequence of the DNA is. So they want that to evaluate, which I completely understand. It's a fairly classic thing to do as far as discovery and expert evaluation in a case. The whole question is just, do you get to do that before the preliminary hearing or not? And the question, I think, is going to boil down to, we heard these 4 categories of evidence from the prosecution that they intend to announce. They've got the surveillance video, the connections to the rifle, the circumstantial connections, the confessions, and then that's, you know, above and beyond the DNA. And that seemed to be a little bit persuasive to the court because he was asking questions about, so what if they didn't even produce the DNA? You know, what if they didn't bring that? If I can find a PC on any of these other grounds, then it doesn't matter if you get the DNA or not. So that seems to be a point that that may have landed. Just checking to see if there's anything I kind of need to recap that we haven't talked about. Not concerned about the bullet testing at this point, but it doesn't sound like anybody is proffering bullet testing as evidence at the preliminary hearing. I don't know. We'll have to see, but certainly not anything that hasn't yet happened. That was something that we learned today that I have been kind of wondering, because remember, this defense motion that the ATF stuff is all rising from. This was filed back in January 9th, and it's gone nowhere. It's just sat. There hasn't been a response filed. There hasn't been a hearing. There's been nothing. And so one of my questions has been, well, did they just moot this? Did they reach some kind of agreement for either the federal, the defense expert to go attend the testing, or for them to video record it? And we learned today, no, the feds still say, not in our lab. We'll do things the way that we want to. Why do they do that? We'll have to get their explanation. This is not an unreasonable request. This is a pretty routine request to be able to document the work so that it can be reviewed by the defense if they're not going to be allowed to be there in person. Sometimes there are legitimate considerations about, we need to make sure the premises are secure. We need to, make sure that the process isn't going to be, tainted somehow by the presence of additional bodies, things like that. Need to be sure that people are going to follow the rules about, sanitation and everything and so forth. But the reality is that if you're at least in principle, you're dealing with a lot of professionals, okay? Whoever is going to have the qualifications to go into a lab and understand what it is that they're doing so that their being there is useful at all, they're going to know how to conduct themselves professionally in the laboratory setting. So I don't know what the FBI's reason is. To me, that does not seem like a reasonable position whatsoever. But it's also not unusual to just take an aggressive position because you think you can and make them litigate it and whatever. And it's obnoxious as hell. But it's also just kind of part and parcel of dealing with cases and dealing with investigators and stuff. By and large, I mean, I keep coming back to this prosecution team seems so incredibly reasonable to me. Like, I'm kind of like, I'm a little spun because I'm not used to that. Not used to seeing really reasonable prosecutors. I'm not saying they're not out there. Of course they're out there. But maybe it's just, the ones that stick and that traumatize you are the horror show ones that we've all had bad experiences with. These guys are like bending over backwards to offer compromises is kind of really the theme that I get like almost every time we have a hearing. Example of that had been, bend over backwards to just fine. If the problem is the court camera and they can't follow the rules and they keep zooming in on Tyler when they're not supposed to do that, just like they did with Kohberger, then yank it and use the WebEx. That's a compromise. Have the preliminary hearing and hear what we have, and then decide if the defense needs an opportunity to come back and do more investigation, present additional evidence after discovery, etc. Because then you'll be in a better position to know if it's going to defeat probable cause. They are proposing solutions to so many of these problems. And I'm just going to come out and say, in my experience, that is not normal. Like, that's not the majority of prosecutors are not going to behave like this. They're going to want to do it their way, or just, want a decision one way or the other, pick their side, pick my side. This looking for a compromise middle ground is rare and very appreciated from my perspective. We also, got the recap of where they're at on discovery and where they need to be prepared. And, are they ready? That's at this point, I think the main good argument the defense has potentially, to be able to still kind of justify a continuance is if you haven't had the opportunity, and there's a lot of reasons why, you might not, but if you haven't had the opportunity to address specifically what's going to be presented at the trial, then you need time to be able to do that. And I think they did make a pretty good argument that there's a lot of stuff out here that the testimony alone is going to implicate. We can't just, Officer X is going to testify. I'll read Officer X's report, because if Officer X in his report says I got all this information from these 10 other officers, then we got to read their reports too, and we don't even necessarily have them all. So that did seem to me to be a pretty decent argument for the continuance. I think the problem, though, is then they over-asked 4 months. 4 months to be able to read police reports. I don't know that the judge is gonna see that as a reasonable request. So we'll see how that goes. But at least my read on those comments at the end of the hearing today kind of imply he's leaning towards we're going to go ahead and move forward with the preliminary hearing, maybe accept that recommendation, that offer that the state made, hold it, and then see. That was the Lopez process that they've been referring to, this Lopez case where the defense wanted to subpoena the victim to have her testify at the preliminary hearing. And that was the process they followed. Basically, judge said, no, you go through and you listen to the evidence and then figure out if this is necessary. And it's necessary only if there's a reasonable chance it's going to defeat probable cause. If the witness is just going to come in and repeat the testimony and maybe be impeached on small things, it's not going to make a difference. So you're not going to have a right to come in and berate the victim just because you want to do that. Then as far as the media stuff itself, I just not impressed. Not impressed with the showing that we got today. It's not targeted enough. If your problem is the live stream camera, then you need to be focused on the problem or, absence of problem that specific thing that you're asking the court to do something about causes. And if you haven't done that, you haven't shown a good basis for why it's a problem. We all understand there's a lot of bad media, and there always has been, and there always will be. Okay, not going to change. The issue with this case, for the defense perspective, is the attention to it. And so, to me, I don't see how the cameras change that really one way or the other. And all of these other considerations about the parties might pander to the camera and stuff like that. Those seem to be the issues that were addressed by the Supreme Court in their research before they ever decided to adopt this rule in the first place. It's exactly the kind of thing that they look into and take into account when they decided, as a general rule, we are going to allow cameras in because we don't think that that's a significant risk. Oh, got a little, hang on a second, drop my pen. Got a little sense of the scope of what some of the defense is asking for. Requests like they want the source code of the proprietary software that's used to do the DNA analysis. Yeah, you're not going to get that. You're not going to get that. Everybody knows you're not going to get the proprietary source code. Not without a really, really good reason, a really good explanation for why you need it. It's a trade secret. It's gonna get a high degree of protection. It's also third-party discovery. It's from somebody who's not involved in the case at all. So that seems pretty remote, but something to litigate, right? Gives us an argument to make and something to make a record about why the decision should go differently than they think it did. So, yeah, that was second witness. Dr. Ruva came across so much better than Dr. Edleman did. Willing to make the concessions. She's not there for one side or the other. She's just there for the reality. And if the research says X, she's going to agree the research says X. She isn't going to try to convert his question into a question about research on Y. She's not going to make her entire answer about, something else entirely, that's good or bad, and why you shouldn't even be asking the question. Much more credible witness. But at the end of the day, I think still not particularly helpful to this problem, because these are big picture problems that just involve media attention to cases, period. It's not unique to the live stream. Anytime there's a whole bunch of pretrial publicity about this case, that's going to have consequences. And so you're going to see that as well in cases that don't have courtroom live streams. You're going to see that in the Richard Allen case. You are going to see that in, every single federal case, ones that are going to be, publicized. See that in Luigi Mangione? There's no cameras in that case. I had to go to New York to sit in there on the suppression hearing myself, just to have a sense of what was going on and what the issues were going to be and everything. So I personally, I find that kind of stuff very interesting. I realize that's not universal, but I really do. These whole, just the way the human brain works is really fascinating to me. And the things that we're not aware of, so much of this process being invisible to ourselves, that stuff fascinates me. But it doesn't really matter for purposes of this motion. It matters a lot more when and if they get to the point of selecting a jury and, start to have questions about how do you deal with these problems in that context. But that's where I got to give her credit for coming across as actually an objective expert. She's like, well, here's the ways that you mitigate it. And yeah, you can't make the implicit bias go away, but you can ask, questions that help you identify it. And that's exactly what they do. Like what she described is the pretty standard jury selection process in cases that get media attention. And you got to remember, this stuff gets litigated in cases that are not getting national media attention. You will never have heard of them, but they got massive attention in the local community where they took place. And so there's a lot of exposure to them locally. We would have to deal with this, pretty regularly as a trial attorney, even though I never dealt with a case that got, this kind of national attention, at least not at the time when I was handling it. But you deal with cases all the time where there's been local news, local newspapers, people know people, stuff like that. And so, yeah, you always start from the standpoint of what have you read? Where do you get your sources? This is all pretty normal stuff. And if there's, a ton, you don't have a whole lot of people who aren't familiar with it or whatever, then that might trigger you to be looking into asking for a change of venue and stuff like that. So I found it all very interesting, but just not, I think, suitable to what the defense is asking for. I went ahead and starred a couple of comments I saw run through the chat, just because these are questions I hear a lot, and I have thoughts about them, and I'm going to share these two comments back to back because I think they will help elaborate my thought process about it. Aria the Sweetie says, I'm not sure the defense is looking out for Tyler Robinson's best interests. They should want cameras inside the courtroom. So I want you to think about that observation. And then I want you to think about this following observation. Cameras in the courtroom will help the truth come to light. You're absolutely right, Aria the Sweetie. Cameras in the courtroom make the process transparent. And so I think the implicit assumption in your question here, or in your thought here, is that transparency is beneficial to Tyler Robinson. I think that's the implicit assumption here. And so I'm just going to invite you to consider the reason why the defense doesn't want the cameras in the courtroom is because they know it is going to be really bad for him. It is not going to help him. It is not going to make more people think that he's innocent. Of course, I don't know that this is the case. This is me predicting. This is me looking at their motivations from the standpoint of somebody who has done the job of sitting next to court, sitting next to somebody in court and trying to defend them and trying to get the best possible outcome for them under a whole variety of circumstances, from this person is really super guilty and they're going to be able to, prove it easily, to this person is, really innocent, and this case is so thin that it's like, a travesty that the charge was even brought. And the majority of cases are in the middle ground between those. And so when you're dealing with a case, if I'm dealing with a case where I got a really good factual basis for innocence, you're absolutely right. I want that public. I want everybody to see it because it's going to help me if they all have that information. But if it's not, I don't want people to see that. So I just invite you to consider, from my mind, that is the most reasonable explanation for why the defense doesn't want the cameras in there. Are they on his side? 1,000,000,000% these guys are on his side. These guys do this work because they believe in the work. You don't have to, you can disagree with me. That's obviously an opinion. I can't see into their minds and hearts, but I can tell you, looking at their careers, looking at their records, looking at the choices they have made professionally, looking at how that lines up with the other options that are available to lawyers. Capital lawyers like these guys in the federal system, the Criminal Justice Act lawyers, pretty sure the current pay rate is $225 an hour for capital cases. It sounds like a lot, but they're running offices. These guys aren't working for a public defense office where they're overhead. They have a secretary that's paid for. They have an office. They have a telephone. They have licensing requirements. They have continuing education requirements. They have insurance requirements. They have staff to, I think I might have already said staff. You got a lot of overhead in a law office, and that's all coming out of your $225 an hour. So that's what I mean when I say these guys aren't doing this to become millionaires, because they're probably not going to. When you see somebody that chooses to do this type of work for decades, like both Mr. Burt and Mr. Novak have, it tells me something about their motivations, why they have made that decision. And they do it because they believe in it. So yeah, I have zero doubt that these guys are 1,000,000% in Tyler Robinson's corner. They are going to do everything in their power to get the best possible outcome for him that they can. And part of that job entails being realistic about what the likely outcomes are. Because you got to be able to, give advice about what's your best course of action here. You get offered a plea. Should you take it? Should you not take it? You got to be pretty realistic about what's going to happen if you're going to give good advice about a situation like that. That's my prediction. The reason why they don't want the cameras is because the cameras are going to show more than they are comfortable with, more than they want us to know about the case against him. It's not going to be helpful for him. If it was helpful, they would want the cameras there. We'll see, of course, we'll see. That's the thing about predictions is we always get to see how they play out. So just go ahead and bookmark that one or whatever. Come back to me when we know more about it. But that's my read on it. If the cameras were beneficial, yes, they would absolutely want them in. And also they would be, by the way, doing different things. They would be doing other things than what they are doing. They would be writing their briefs in a way that would highlight the things, the factual things that are to their benefit. That was something that the Kohberger attorneys did very, very effectively when they dropped, I don't even remember what motion it was now, but one of these pleadings where they pointed out like after the arrest and the search warrants had been done on his car and his apartment, his devices, all that stuff, and they had found like nothing, no blood, no victim DNA, no connection, no digital connection, like no building up any kind of case of he knew them, here's where he saw them, here's planning and preparation that he did. I mean, nothing. And so when the defense puts that in a pleading, it doesn't have anything to do with that, but you put it in because that's kind of a big deal. That's not what you normally expect. You expect in a case, if somebody committed a crime, that there's going to be multiple levels of corroboration to show that. So I would expect Tyler Robinson's defense attorneys to be doing the same thing. If and when there's favorable facts, yeah, you drop them in, even if they don't necessarily have anything to do with the issues that you're litigating, because part of your job here is to put him in the best position to get a good outcome. And the reality of a high profile case like this is that the publicity is part of that. And so if you can do things that will change the narrative, that are, within, you're not like being unethical. You're not like lying about what the evidence is or anything like that. But if you have stuff like that you can use, you do it. So we're not seeing stuff like that. We'll see. We will see. Michelle, yes, this is where we were. I had seen this question. I did a whole long talk about it and then realized it was here in a super chat. Yes, the bottom line is they do have a duty to investigate 100%. It's part of the Sixth Amendment obligation, but they also have the discretion under the Sixth Amendment to make strategic decisions about what roads they don't need to go down. And as long as those are reasonable, those are going to be upheld. It's just part of the deference that attorneys get to be able to make strategic decisions about their case. Lazy LCH, why is it got to be about DNA at prelim? Were there no fingerprints? There were fingerprints, we've been told, fingerprints on the roof of the Low C Center. We don't know the status of any kind of comparison of that. I'll just say, as a practical matter, if I'm the prosecutor on this case, yes, I definitely want the DNA more than the fingerprints. The DNA is better science. It's far more persuasive. It's far more like valid. Fingerprints are not like the worst of the kind of bad science methods that there are out there. But it's another one that's validated mainly through performance review than through like actual establishing the core assumptions of like every fingerprint is unique and here's how unique they are and so forth. But they've been able to show that just like through the testing process itself, people are able to make the right call, consistently. And so doesn't rule out an extraordinary situation, but nevertheless, it's not going to be as good as something like DNA. That is, it's quite a bit more objective. There's quite a bit more foundation to it, and just maybe, frankly, it's a little harder to understand. It's much more technical. Fingerprints. Anybody can look at a fingerprint and be like, yeah, okay, I could do that. If I were trained. I don't think a lot of people look at another human being and think I could figure out how to extract that person's source code and compare it to a piece of evidence. No, it's like all very, very foreign. And so maybe, there's just more believe the experts kind of tendency with DNA evidence. I mean, that might be part of it too. But by and large, it doesn't surprise me that that's what they would want. over something like a fingerprint, even if they do in fact have that fingerprint evidence available to use. Nick Stero, tool mark experts using crap science. Oh, I wanted to take that statement that Dr. Ruva made about how, he asked her, why do you use conditional language? And she said, because in science, nothing is certain. It's about probabilities. And it's a very modern view on science, the probabilistic model of it, which is one reason why DNA looks, if nothing else, it looks so much more sciencey because it's presented in probabilistic language. A fingerprint, they'll get right there on the stand and tell you, oh yeah, it's the same. And they will say that definitively. And the freaking tool mark experts will do this. I was like losing my mind when she said that. Please go tell that lady over in Delphi, who not only is like 100% confident about her stupid unscientific test. She compared a fired cartridge casing to an unfired cycled cartridge and said, yes, I can decide these are from the same gun. Not only doing crap science completely definitively, but also bolstering herself because she's never been wrong. Like, so definitive. She's never even been wrong. Oh, Dr. Ruva was a real breath of fresh air in that regard, not feeding us that kind of bullshit like we got from that tool mark expert. Yeah. Andrew Matthews, 1916. Was any bullet fragment recovered by the doctor? So what we know from the ATF report and the kind of related documentation that's come out in the recent days, they recovered a fragment of the bullet jacket and 4 fragments of the lead core, 4 lead fragments. So 4 pieces of lead, 1 piece of jacket material, which is probably going to be copper. Is that all that there was? I know this is a common question, guys. I'm probably going to, I don't know what I'm going to do. I might try to write something on Substack. I might do a video. I haven't sorted it all out yet, but I'm going to go into this a little bit more specifically because speaking of predictions, I have some predictions about things to look forward to from the medical examiner testimony. The reason why I bring this up is because I know I'm very well aware one of the kind of hot questions about this case, and one of the reasons for much of the skepticism about the case is, how did a 30-06 do this? A lot of people believe not possible. And a lot of people who believe that it's not possible are people with a lot of experience with guns. They've shot a lot of 30-06s. They've seen what it can do. And that's valid. It really is. It's a valid observation. But the problem is, okay, you're a hunter. Even if you're like a really good hunter, okay, you're going to have a limited sample size. You're not taking 200 deer in 1 year. Okay. You might not take 200 deer over your entire lifetime, but that's kind of like the minimum you need to have a pretty good sample to figure out what bullets do when you shoot them into a body. And the issue with, the 30-06 and just high caliber, high velocity rifles in the first place is that the more velocity is involved, the greater likelihood of fragmentation. Rifle bullets fragment significantly more often than handgun bullets do. And who knows this? The people that look at the other end of the sample, okay? Not the guys that fire the guns, the guys that look at the bodies. The guys that have seen hundreds, if not thousands of bodies that have been shot by all kinds of different guns. And they see what the effects of that are. They're the ones that have the sample size, the basis of knowledge to evaluate, okay, effects on body, what's normal, what's not normal, what's not predictable, what is. And so I'm just going to drop a little teaser right here for what to be looking forward to. Prediction of what we might hear in the preliminary hearing, something that you guys can go look into yourselves if you're so inclined. I'm going to drop you this little teaser here. Lead snowstorm pattern. You can go ahead and look this up. It's so common for particularly soft point rifle bullets to fragment, that there is like a typical pattern of how they present in a body. And they can even like evaluate things about the bullet and the firearm and stuff from the distribution pattern of like what it looks like. They can determine directionality and stuff like that from how this lead snowstorm pattern, how it looks. So these are things I'm expecting we're going to hear quite a lot about when we get the medical examiner's testimony at the trial or at the preliminary hearing. But we don't know the specific details at this point in time. So I'm offering that as a preview just because I think there's a pretty good chance we're going to hear about stuff like that. But it is also entirely possible. No, the bullet just fragmented into these four lead pieces. That's all the fragments there were. That would be uncommon for a rifle bullet, I can tell you, but not impossible. And so it's going to be a little bit of a wait and see. Nova Dexter, have you watched any YouTube videos debunking the 30-06 hoax yet? Valhalla VFT has a few scientific recreations. I've seen them around. I don't give them any credibility, really, for the reasons I just said. There's a lot of variables, so many variables to account for when you're looking at terminal ballistics. But also, you don't have the sample size. The sample size is with the people that look at the bodies. Okay, they're the ones that have the data set. And so I'm just gonna encourage everybody to hold on to the medical examiner. I would love, in fact, oh gosh, maybe I should. I don't usually do interviews and stuff like that on my channel, but sure would love to get a pathologist on and talk to him about lead snowstorm pattern. What do you know about it? Tell us about it. Tell us what you can know from something like that. So no, I don't consider any of that to be debunking. I personally don't consider any of it helpful. So I don't tend to look at it, but it does, yes, come across my radar. But I tend to focus on what is actually going to be, presented in court, what I expect will be presented in court. And I expect a medical examiner to testify. I don't expect a firearm, terminal ballistics person to come in and testify about, what guns can and can't do. To Truth for Liberty, I forgive him by alleged significant victim translates to convicted in public. Forgiveness is a private thing that people do and that they are allowed to do. And it doesn't necessarily have anything to do with whether or not the person should still bear responsibility for their acts. These are not the same thing. So, convicted in public, if he has a trial, the public is, and he's convicted, that's going to be the public that does that. And it's going to be in the public eye. And so, yeah, that's going to happen. I don't know the details of Erika Kirk's faith other than to know that she is a person of faith. And so I would expect she has rather different expectations for the justice that happens in this world relative to justice that one might look for in other venues. Michelle 8190, is there a difference between the weight of a subpoena issued for the defense and a subpoena issued from the government? I would think judges would favor the government and be more liberal with issuing them to the government. So in Utah, they don't have to go to the court for permission to issue a subpoena. The lawyers can just do it themselves. That's the same way as it is in Washington. I was, at least for felony cases, that's what I was always used to being able to do, is just issue my own subpoena. And it has the same weight as any subpoena that's issued by the prosecution. Other states, you have to go through court and get the court to issue the subpoena. That's the Massachusetts process that we saw during the Karen Reed trial. The attorneys don't do the discovery independently. They have to go to court and get permission to compel a third party to produce something. So in that case, I would also, with you, tend to expect that the court would be more receptive to prosecution requests than to defense ones. And that's just part of the structural bias that I personally perceive in, majority of cases in criminal court. There's just a tendency to favor the prosecution and to view the prosecution as more legitimate than the defense. But that's not our situation here in Utah because the attorneys can issue the subpoenas themselves. With respect to the ATF and the FBI, the problem is not, is it the defendant, is it the state? It's that a state court subpoena has no power over them anyway. It can't be enforced against them. And that's a product of the supremacy clause of the US Constitution that says the federal law is the supreme law of the land. And courts have interpreted that to mean federal officials and those who work for them, below them in the Department of Justice and so forth, they don't answer to state courts. And so what happens is if I send a subpoena to a state officer or to a federal officer, they laugh and ignore it. They don't have to do anything at all. But if they want to be proactive, they go into federal court and they ask the federal court, to declare that it's invalid. They don't have to follow it, and they will get that under the supremacy clause. So it's a jurisdictional problem, and it's like a power sharing problem. It's like worthy of a whole kind of conversation of its own. The problems that this situation causes or can cause in state prosecutions where federal investigations are involved, and perhaps the rules should be different. But given the law as it is right now, Congress could litigate or could legislate and say, they have to comply with duly issued process from state courts, but Congress hasn't done that. So here we are. We have some new members here. None the wiser 1163, a new member. Gray Space, a new member. Welcome, you guys. Thanks for joining the channel. Alexa Grote, this just confirms how important it is to have wonderful, honest people like Andrea to follow. You're very kind. We're not very good at the grift here. It's not so much the objective. Who's going to come and sit and watch an 8-hour live stream that's just a court feed and talking about it, right? the true core of the people interested in the case, that's who. It's a very nice thing to say. I do appreciate that. It is certainly my goal to be educational and informative. Entertaining is great if we can get there. But frankly, I find the chat probably more entertaining than I find myself most of the time. I have opinions. It's what an analyst does. Oh, I see all the time, Andrea, you're biased. Don't make me do the lecture again. The lecture about being biased versus being informed. Of course I have a freaking opinion. I've taken in information about the case, and that's literally what I'm here to do, is talk about what I think it means. And you can give it weight or not give it weight. And it doesn't matter at all. Some people will find it helpful. Some people won't find it helpful. But I find the bias comments just particularly funny. I saw one run through the chat. Andrea is so biased for the prosecution. You have no idea how hilarious this is to me because I'm so defense biased. That's my background. That's my position. That's what I understand. That's the job I've done. So that's always going to be my perspective. It's always going to color it. I'm always going to be skeptical of the state's case and the state's witnesses and want them to back it up and so forth. Right? My bias is very much for the defense. But we have a factual reality here in terms of the evidence, at least that they claim to have. And if they are able to back that up, there is a reality about what that means, what that implies vis-a-vis guilt or innocence. And so, I'm not going to be blind to the reality of the case. I wouldn't be a very good defense lawyer if I was. Anyway, that's way too long for me to talk about a nice comment about me, but thank you for it. We're going to just ignore that. That's some stupid bullshit. Tammy McDonald, thank you so much for covering this. We appreciate you. Well, thank you very much, Tammy. I appreciate you as well. Appreciate all of you being here and being interested in just the truth of what's going on in court without any sort of big dramatization or trying to sensationalize and so forth. Lazy LCH, wait till he sees prejudicial opinions of his testimony. Oh, Dr. Edleman. Yeah, he really didn't cover himself in glory today. And it's maybe a little bit unfortunate because I found him so powerful, so persuasive in the Koberger hearing. But I think the problem really is that just the subject matter itself, it was a stretch. The ask here to get rid of the cameras, it's a stretch. It's outside of what he really has the evidentiary base to be able to make claims about. And he knows that. And so he knows it's a weak point. That's why he's so defensive about it. And that's why he's trying to get out ahead of it and not answer the question and avoid it and so forth. I get it. I see it. You shouldn't take the engagement if, you're going to have a problem with that. But I don't know, maybe he doesn't mind getting up on the stand and kind of revealing a little much of himself and what he would rather be saying. Lax Forge, this guy doesn't want his own testimony broadcast after that line of questions. Yeah, see, we're getting closer and closer to why don't people want the cameras? Because they don't think they'll help. They don't think they'll help. If he thought it went well, he would absolutely want it televised far and wide because what a great advertisement for his services. No, they don't want the cameras when the cameras won't help. Harbinger of imminent death. How much trouble would you get in for Saul Goodmanning a witness? Would it surprise you to learn the man you ID'd at counsel table is not my client? This is going to depend totally on the judge. There have been situations where somebody has done that. I can't remember the details now, but I do remember seeing a situation like this. And I'm pretty sure what happened is the attorney got, recommended for disciplinary action for doing a little bait and switch with who was sitting at counsel table. The judge took it very personally, found it like a violation of candor to the court, like you're misrepresenting something by having somebody else sit at counsel table. I really don't see it that way. But it's going to depend. It's going to depend on the circumstances. It's always the safe legal answer. It depends. It depends. But this is just a situation where it really does. Because some judges are going to be like, how dare you? And other judges would be like, oh, what a clever ruse. Lazy LCH, thanks for covering this, Andrea. Seems like a lot of law tubers are scared of it because of the political stuff. I think Runkle is right. You are the smartest lawyer on LawTube. Actual quote, in case you hadn't heard. Yes, thank you. He insists on always saying that to me every time I'm on the show, and it's like super embarrassing. And like, what am I even supposed to say about that? Thank you. I appreciate it. There's lots of smart people on LawTube, lots of good people to watch, lots of good information, lots of different perspectives. I like Emily D. Baker myself. Personally, I really enjoy listening to Emily in large part because she has the prosecutor background. So her background is very different from mine. And so I find that very helpful to hear. And, obviously consider her very smart and experienced and so forth. I don't know if I guess it probably is the politics. I don't know. Yes, it's very political. I guess that doesn't bother me because I don't really give a shit about the politics of it one way or the other. It's not a team sport. It's not supposed to be a team sport. Nobody deserves to be murdered based on, beliefs and advocacy and so forth. Court should be fair to everybody. I mean, to me, these are not like partisan views. So, but I understand very well that there's political implications to all the like swirling attention to it and the reasons why people care and so forth. So just to kind of like warn everybody, you're here watching because you're interested in it because of the politics of it. I'm probably going to offend you at some point with something I say. I don't care which side of the aisle you're on. I'm probably going to piss you off one point or another. Just the whole team sport of politics is not my thing at all. Lazy LCH, meant to say this earlier. I find it interesting Nestor just tried to get Corey's sentencing moved off ER's birthday by saying she had a death in the family and can't be ready by May 13th, but not today. That is interesting. that is interesting. Maybe because it's just a short-term conflict. And when it comes to the preliminary hearing, they're looking at kind of more longer term stuff. And she was just really explaining why why she's behind on the kind of preparation side relative to everybody else. And so compared to just having been in the trial in the first place, this is, maybe kind of nominal compared to that. But yeah, it is interesting, isn't it? I mean, it's not unusual for defense lawyers to want more time, like I said, have conflicts and things like that, and a lot of different reasons for wanting more time on different things, but just generally does help to be, consistent. And so even if it didn't matter, it probably looks better to mention it, but I don't know if it matters. I don't know if it matters that much, but I know lots of people don't like Kathy. I didn't watch Corey Richins. So, but I realize I need to go back and kind of familiarize myself with her game, because I hear many people are not fans. Lax Forge to the defense. If you are explaining, you are losing. This judge is clearly going to allow cameras. The defense will keep trying to exclude. He's been extremely camera favorable so far. Really don't have any reason to expect that to change. The rules tell him he has to be. I couldn't help but notice the questions that he had for the parties, all geared around how do I apply the rule? He's not looking at this as a constitutional issue, and it's kind of the defense's job to try to make it one. But under Chandler, the U.S. Supreme Court case, it's pretty clearly not, because they said in and of itself, having cameras in the courtroom, not a due process problem. And that was because years before in Estes, they had said it was. Estes said cameras in the courtroom, period, due process problem. Got to reverse the conviction. And so Chandler came back and said, no, actually, it's not a per se thing. You can have cameras in the courtroom. So it's really not a constitutional issue. It's just going to be an application of the rule. And that's what the judge's questions indicated he was going to be primarily considering, I think. I highlighted this just because I saw it run through. Andrea, how do you feel about pool coverage with delay of broadcasting to public by just minutes? I don't have a problem with this. And frankly, in many ways, I think this is often a smart thing to do. Just because, yeah, stuff can happen in court. There can be accidents. You can accidentally pan to the jury. You can accidentally pan to the, document on the defense table and stuff like that. And so when you have the lag, it just gives you enough room, room for error to be able to correct that type of thing before it goes out to the public at large. So I don't necessarily have a huge problem with this. I don't know, other people might disagree, but I don't see that as a significant deprivation. A few seconds, maybe even a few hours. Frankly, even yes, I'd rather know right now. Of course, everyone would rather know right now. But even the next day, it's better than not seeing it at all. So, harbinger of imminent death. You talked about how Shepard's case gave preferential access to the media over the public in the courtroom. Didn't the same exact thing happen in Karen Reed's case, who could get seats? Yeah, once they moved into the small courtroom, it kind of did, didn't it? Because they had a certain number of seats set aside for each of the families, and then media, and then once those were all taken up, it's like there was no room left. And they did a similar thing in Delphi as well. We ended up with, on average, somewhere in the ballpark of 20 seats every day for the public, and 50 people in line to get those seats. Delphi was a little bit worse, though, as far as the preferential media treatment, because they gave the media preferential access to the exhibits. We, the public, didn't get to go up and look at the trial exhibits at the end of the day. The media did. They got to go in and look at everything, but we, the public, were excluded. That was, from my perspective, complete violation of the First Amendment, giving the media special access. Plenty of cases say it's not allowed to do that. So yeah, this kind of thing does happen. This is kind of one of the advantages, I think, of having the courtroom cameras in the first place. You reduce the demand on access to the courtroom. The courtroom is always going to be a finite space. And so you're always going to run into problems of competition for who gets the seats. And when you have that situation, it's kind of hard for me to argue against at least some of the media, being guaranteed access, because that's the only way that we're guaranteed some kind of reporting about what's happening. The public might, but they also might not. But then how many and how far does that go, and how do you choose who? I mean, these are the difficult questions the court has to answer. So I think it's implicated by that. Maybe not quite to the degree that that happened in the Shepard case, but it is definitely something I think to be aware of. But that's all the more reason have the camera in there, because then people don't have to show up and be there present in person if their goal is to have the full and complete information about what's happening in the process. Harbinger of imminent death. What is a good success ratio for a defense attorney? This is really an unfair question because it depends on a couple things. It depends on who you're talking about. Are you talking about a private defense attorney, or are you talking about a public defender? Because the public defender doesn't get to choose their cases at all. They get what they get. And it's frankly a miracle that they win any of them a lot of the time. Private criminal lawyers get to be selective about which ones they choose. So they can vet their cases to pick only the ones that they think they have the best chance of winning. So generally speaking, I would expect private defense lawyers should have a very good success rate, a very high success rate. Public defenders, significantly lower. I can argue a lot around the edges of what success is in public defense land. Because success is often not acquittal. Success is conviction of a lesser included. Success is getting a alternative sentencing option, a treatment program or something like that. Success is getting a slightly lower sentence. A lot of those things are the measures of how good of a job you're doing as a public defender. In cases where you're not going to win acquittals. The majority of your cases as a public defender, your chances of winning acquittal are very low. But it's not zero. So, I guess you'd want to have some. And it's probably, if you just want to look at like trial rates, there's probably an argument that public defenders are going to have a good rate of success at trial. Well, yeah, I don't know. It's so much easier to plead the guy out, convince him to take the plea if he's got a weak case. And a lot of times it's in his interest to do that, but it's not your choice as the lawyer. It's always up to the client to decide. So some people that should take a plea, you just can't push them to do it. Other people, it's like, I had a case that was a prison assault, right? He's charged with a strike offense, assault in the second degree. No, it was assault in the first degree because he shanked somebody. It's in prison, okay? It's on camera, 10 different ways. There's witnesses everywhere. Everybody knows the guy did it. He's not getting off. But you know what? It doesn't matter. Why doesn't it matter? He's already in on 3 strikes. He's not getting any kind of sentence that is going to matter at all. It's not going to add or take away from what he's already got. So not a whole lot of incentive, to fight something like that. So these are just all the things that kind of play into the sort of outcomes you get. I wouldn't be able to put this into numbers. I've tried to kind of generally explain my thought process about it and kind of the general trends as best I can. But yeah, by and large, public defenders winning cases at all, kind of nothing short of a miracle, because they didn't get to choose the case. The system, the structure of the whole process is not in their favor. The assumptions are against them. The time is against them. The resources are against them. They're very much outgunned in many of those respects. So frankly, a public defender who is winning any kind of trials at all is probably a pretty good one. Well, so it looks like on this case, we'll be back on May the 8th for the decision. Likely to have some stuff to talk about in the meantime. I probably won't go live to just like go over pleadings or things like that. It's a variety of reasons, kind of easier for me to just sit down and film that stuff like that when I get a chance. But is some stuff to go over. We got, like I said, this whole new motion that just got filed. They want to hold Chris Ballard in contempt. So we can take a look at that and see what that's all based about. Like I said, a lot of thoughts about this ATF stuff and what that tells us in terms of what we can anticipate seeing at the preliminary hearing. Some things that just to look forward to may come up, may not come up, but may come up. And oh man, I've got some real thoughts about the shadow doc. There's a shadow docket in this case, guys. I'm convinced now there's a shadow docket in this case, and I've kind of known this for a while. Figured it out once the secret appeal came to light. Whole process the defense went through to try to go up to the Utah Supreme Court to review the decision to keep Tyler Robinson in shackles in the courtroom. And didn't know about it until well after it was done, because it was just sort of kept off the docket. And there's a number of items that are just sort of kept off the docket. And I continue to hear things that imply there's stuff that gets filed that just doesn't make it on the docket. Mentioned today something about list of all the discovery that's been produced. Maybe he said they just provided that one and didn't file it. But yeah, things just, there's numbers that are not being associated with documents on the docket. And in the case of the late appeal, it just sort of popped up after the fact. And so at least some of these numbers seem to be documents that exist, and whether or not there's some reason why we aren't seeing that they even exist, I don't know. So it's a bit of a mystery, but I've been doing a little bit digging into that and have some thoughts about that as well. Lazy LCH, I would rewatch the whole Corey case if you live stream catching up on it. Well, I'll give that some thought, but I probably won't do that. Mainly just because, frankly, watching the entire trial on the live stream, it's like one thing to sit here one day for 8 hours on the live stream and then see it in a few weeks. But doing it every day, to watch a trial, it's frankly, it's just kind of a lot. It's a lot of sitting. And I'm not a very good grifter. There's like other things I want to be doing with my time, particularly in this beautiful spring, and my bonsais are awake, and I've got a sick rooster I'm dealing with, and the lawn needs mowed. The irrigation just came on, and I got valves to fix, But I'm definitely considered something like trying to go through and pick out some of the some of the things, because I'm mostly interested in Kathy Nestor. And so maybe looking at some of her cross-examinations, some of her other arguments and stuff like that. And maybe watching stuff like that together. I would definitely consider doing, but don't think I'm going to probably watch the whole trial, but thank you very much for the invitation and the support for an undertaking like that. So you guys, you know the drill. Just keep your eyes open for stuff. You know what you need to do to get the notifications and all that. We'll be planning to go live for the May 8th hearing. Now, I say that having not yet still made up my mind about whether I'm going to go back to LA on May 6th for the closing arguments in the Yohan Griffith versus Alice Evans divorce from hell case. I feel like in many ways, like I've gone this far, it would really be a shame to not. but it's like also kind of a long way to go for one hearing and stuff. So anyway, haven't made up my mind about that, but either way, I would expect that I can be back for the WebEx decision on the 8th. So definitely planning on that. Definitely planning on the preliminary hearing, of course, if assuming that goes forward. At this point, I am kind of expecting that it will. If anything comes up in the meantime, yeah, like I said, you know what to do. Look for the notifications and so forth. But by and large, I don't expect to go live unless there is a live hearing that we really want to cover. If it's going over documents or old hearings and things like that, probably just going to sit down and film it when I get a chance. I still got some stuff to go through over the Afro Man case. Still got some thoughts about that. I'll give you a little teaser because the brother, remember the brother, the former chief of police who got fired for some inappropriate behavior and a criminal charge that Bryan Edleman just couldn't remember what it was. I don't know what it was. Well, I know what it was because I have his guilty plea hearing. I went and got the recording from the court. So we've got that. I'm going to share that with you guys so you can listen to it. And still haven't done my piece about the judge. Okay, singling out these little comments and things like that the judge did. So that's still in the works. What else? My mind's a little kind of everywhere after a long day. I think those are the main things, right? Those are the main things. Was there a Farwell thing that just happened? Maybe it's coming up. I can't remember now. I feel like there's some issue with the Sandra Birchmore case, but now I can't remember off the top of my head. We're going to get a ruling in Luigi Mangione pretty soon on the state motion to suppress, May 18th. So that'll be coming up, but that won't be televised. That'll just be something we'll hear about. What else, guys? Just kind of going through my notes here. Might get some movement in Steins one of these days. Old Sheriff Mickey Steins. Rex Heuerman pled, so nothing's happening there. Yeah, that's kind of where I'm at this point with the things that I'm looking at. That's what I was thinking of because I went to check on like what's happening with Robert Devine's appeal. Guys, remember he appealed the decertification up to the Supreme Court. And then haven't heard anything about it since. So I did go and check the docket, and the reason why we haven't heard anything is literally nothing has happened. So if something happens, I will try to notice and talk about it. But that's another one that doesn't seem to be in any kind of hurry to go anywhere fast. Going to get the reply brief in Richard Allen. Supposed to be the end of this month. We'll see if that gets extended or not. But so those are just some of the things that are on the horizon and kind of in the hopper and always paying attention to look forward to. And of course, continuing to monitor this case, the docket, the filings, and share what I collect over there on the Substack so that all of you guys can see the court records for yourselves as well. So guys, I think that's going to be it for today. That was not a short one, but that's fine. I was prepared for that. Wasn't expecting it to wrap up quickly. So, hey, I don't know about you guys. We still got some daylight left because we're after the solstice now. Life is coming back into the world. I love this time of year. This is my favorite time of year. Things are really nice and pleasant right now, and the days are long, and we haven't reached the stage in my particular environment where things start to desiccate, dry out, get very crispy because it gets hot. It gets very dry. We don't get rain here in the summer, and it gets real windy is the big piece. The wind is what does the most damage to the bonsais and things like that, which incidentally, it's probably high time for me to go check them. So I do want to thank you all for being here. Thanks for being part of the solution when it comes to, the problem of the sensationalized media and stuff like that. We're here because we're interested in seeing for ourselves the real deal, unfiltered. We can form our own opinions. we can also disagree. A lot of disagreement in the chat from time to time, and that's fine as long as it's respectful and nobody's being an enormous asshole about it. Then we don't take any of that personally. This is not an echo chamber. People can think what they want, and other people can mute who they want, draw conclusions about the character of other people as they want. That's what makes this a wonderful free country. But just the fact that people are here at all to watch the live stream of a pretrial court hearing, to me, I'll never not be kind of astounded at that commitment to understanding the process and this case itself. It always kind of surprises me that people who are not lawyers, would still be interested in this kind of issue. So I do very much appreciate that. Don't take it for granted, and try to do my best to be a value add to that process. So with that, guys, we draw connections. All right, to your mom. With that, guys, gonna call it a day. Go Phils. It's been a very hard thing to say lately, but been reminded. So thank you, Jack. Yes, go Phils. One of these days we'll get some offense. I have faith it's gonna happen, and we'll be back soon. Appreciate all of you. Do take care of yourselves. Do get some time outside. Some of that glorious vitamin D and all of that really does do wonders for one's outlook on life and so forth. And just, make sure that we keep everything in perspective, that this trial absolutely matters, and the case matters, the facts matter, all of it does matter. But there are also ways in which it doesn't matter, and it doesn't always matter all the time. Other things matter too. And, just good to focus on those as well. So with that, guys, thank you all very much. One more time. Thank you, mods. Appreciate all of you so much. And we will be back next time. See you guys soon.